লিস্টটা নিয়ে এসে এখানে বসে দেখতে পারবি।
হ্যাঁ, দেখতে পারি।
না দেখতে পারবি। ঠিক আছে।
Give all the applications,
Order 41.
all applications, contempt,
My lord, this
modification,
is-
review all, give
But
all the
only,
applications.
one thing, this is a review application. My lord, Justice Tandon sitting with Justice Samanto, as his lordship then was. Therefore, my lord, this is
Give
a
applications.
yes review. Grateful to lordship.
My lord, before 15 days, I mentioned before for a hearing matter, he also directed me, come after a 15 days, my lord. After 15 days, I come.
But I didn't know at that point of time that I will be going to hold a circuit at Jalpaiguri. So I'm going there. So unnecessarily, it will not be of any use.
As per your lordship,
Come.
direction. As
Yes,
per your lordship
come when I come back. When I come back, come.
I mentioned original site matter.
Item number 1, my lord, extension of time. My lord's order direction was to submit before the corporation within a week. Order was uploaded on last Friday, my lord. The order was 27 June. So, my lord, I'm praying for extension of time. So, my lord,
To be mentioned.
item number 1, it is
To
appearing.
be men-
It is appearing.
Then why you are mentioning?
Right.
Why you are mentioning?
Because
Sorry, the matter is appearing.
lordship.
Item number 1 of the earlier site. Item number 1.
Whatever it will be.
That's
My lord, may I be permitted to mention with leave to Honorable Justice Viswas, my lord, a matter assigned to your lordship, my lord, a WPLRT.
Not possible. We are not, I am not here. I am going to hold a circuit.
My lord, it is assigned, my lord, can you make
True, but that has
next-
to be heard.
next month,
Can you come there at the Jalpaiguri and argue the matter?
no, lord, next month. My lord.
Let me come back. We
My
don't
lord,
know.
As your lordship, please.
But I'm mentioning that matter, my lord, review application. We have given notice.
Review, we didn't, we said give the slip.
No, because your lordship, I'll tell your lordship, my lord. Your lordship remembers on Friday, my lord, the matter was taken up because it was a special day, they didn't come. Your lordship told me that you give a notice and come back and mention, we'll take it up on Tuesday. My lord, I have given that notice, my lord. Lordship will kindly take up the matter today. Today it is item number 80. AJ.
Let us see.
Item number 80. my
Yes,
lord,
let
we are
us
in
see.
a bad shape, my lord, because
Take it out. Item number. Ache.
item 80, my lord, in the list. Lordship will
Yes,
please take it up, my
next.
lord. We'll
Let us see. The other side is not here.
No, we'll intimate them that your lordship will take over at 2 p.m. my lord, subject to my lord's
Whatever,
pleasure.
let us see. Let us see. Move.
Kindly remember, my lord, otherwise we'll be in real trouble, my lord.
Give them a notice. Yes.
Yes, we'll give a notice. For
Yes,
2 p.m. my lord,
call the list.
my lord, for 2 p.m. we'll give it.
Call the list.
I appear for the respondent, my lord.
For withdrawal, my lord.
My lord, usually a
On record is also present today, my lord. Yeah.
What?
Item number 1 and 2 is for withdrawal, my lord. Yesterday, my lord was pleased
Yes.
to direct,
Where is the advocate on record?
my lord. He is present over here, my lord. And the letter from the client is, we have also taken the withdrawal letter, my lord. May I hand over?
my lord, before lordship passes any order, my lord will kindly.
Let us first see.
My lord, I have handed over the original
Just
withdrawal
1
letter, my
minute.
lord.
কি ডিফেক্টটা কি বলছে? Oh, the appeal lies with us. It is the protection of women from a domestic violence act. Then it is a criminal one. Maintenance আছে নাকি? Yes, maintenance আছে। No, no, no. এই Where are the letters?
My lord, I have handed over the original.
Ah.
letters.
Madam, have you filed a Wakalatnama?
Yes, I had filed for.
What is the number?
I have a copy of the Kalatnama that was filed before my lord. Copy of some.
মানে আজকাল অ্যাডভোকেট এন্ড রেকর্ডদের কোনো দায়বদ্ধতা নেই। It is signed by the father. বলছে I want to withdraw on behalf. Can it be done? Wakalatnama is executed by her daughter. So the difficulty nowadays with the young generations is very, I tell you very frankly, I am absolutely perturbed and annoyed with the young generations who are acting as an advocate. They do not know anything, yet they act as an advocate. Who has authorized you to appear on behalf of the client? Who authorized you? The client herself? What is the letter written by whom?
My lord, what has happened, my lord? The power was granted by the.
Sorry, can it be done? Where is the power attorney? না জেরক্স তো অরিজিনাল ফাইল করে দিয়েছে সেটা আলাদা কথা।
My lord, the original.
Lordship, since it was a changed brief, actually. I
Madam,
bow down. I bow down to
Madam,
my lord.
don't say so. It is your duty when a appellant herself has signed the Wakalatnama.
I bow down, Lordship.
And
I'm
how
apologizing. I
a
beseech
father
Lord-
is coming, she's a major girl, and the father is coming and saying that
Lordship, I apologize for this.
on behalf of my daughter, I do not want to proceed.
Lordship, I apologize.
And
Lordship,
then you
Lord-
accepted
Lordship, kindly grants me one more day, Lordship, kindly, please. I'm extremely sorry for this, Lordship.
Why you accepted this letter? You ought to have said, no, please go and get the letter done by your daughter.
Lordship, I'm extremely sorry. Power ka baat nahi. Everything was fine. Lordship, there has been a power of attorney. I just,
Cannot be when she herself filed the appeal.
Lordship, I understand what is falling from my lords.
And your Wakalatnama is also defective.
Lordship. Lordship, I shall not repeat this again. I'll keep that in mind.
Nobody nowadays cared about everything. Just passing out from the college and then started acting as an advocate and record.
Lordship, kindly grants me. one
Without
more-
knowing the provisions of Order 3 of the Court of Civil Procedure, without knowing the appellate side rules. I've been noticing since that this determination is given to me. Not a single appeal I could get it listed without any defect. You don't know what is required. What are the documents to be annexed with the memorandum of appeal? You do not know.
I'm just praying before my lords.
Lord, item number 2, my lord.
Let this matter go out of this for the time being.
My lord, item number 2, my lord, the appellant is my minor son. Lordship will kindly see who is the person who has affirmed the affidavit, in what capacity. My minor son, my lord, the grandfather calls himself. Lordship will kindly see the affidavit in item number 2.
देखिए,
How he got his guy, how is a constituted attorney of my minor son, my lord?
देखिए। गुरु,
My lord, see page 16 affidavit. I am the constituted attorney and father of the applicant.
No, no. Wakalatnama is signed by correct because the mother is a natural guardian.
Mother,
She can, no problem.
not on Wakalatnama. Lordship will see the affidavit, affirmed, application, page 16. Mother can definitely, my lord. There is no, my lord,
Just look at
my
it.
lord will kindly see. He becomes father of my son.
Hey,
And post, my lord, post filing, my lord, what they do, they file another application before the trial court. Lordship will kindly see the conduct. My lord will kindly see what the,
we will not. What is going on?
for the appellant, my lord, that
The respondent wife, my lord.
my lord, the child has come, my lord. Child has been brought. আমি কি আছে কি বল? আমার ওখান থেকে ফাইলটা আমি জিজ্ঞেস করে বলতে পারবো না।
Yes.
Yes, my lord, the child. This is the child.
Who is accompanying the child? The mother?
My lord, father.
Father is.
Father?
Yes.
What is the matrimonial dispute?
Lord, this appearing for the respondent is presently engaged in courtroom number 36.
So what? What is this matter?
Your lordship will kindly remember, this is a matter where the bailiff has been called for. Bailiff was called for taking evidence, lordship.
Yes.
Disposed of. I have raised the point of locus standi based on the judgment. My contention is that, Lord, the petition applicant number 1 and 2 are the same applicants who were there, Lord, in the original contempt application. And your lordships have held that those applicants have no locus standi to present the contempt application. And Lord, the new applicant who's, Lord, added, he stands in the same footing because, Lord, he is deriving his right, so to state, Lord, from the applicant number 1 and 2. And Lord, there is an application filed by the applicant number 1 and 2 saying that neither they have filed the application nor they have authorized anybody. So, Lord, the locus standi point has become final because no appeal is preferred. And Lord, they have accepted that point. So that being there, Lord, there is no question of, Lord, application being maintainable by them. Now, Lord, the second aspect of the matter is, if your lordships kindly, Lord, take the judgment. On the initiation of contempt rule,
because your lordships have not dealt with this matter on merits in the order. If your lordships will not kindly will not come to internal page 11 of the order, paragraph, last step. Yes. Yes, kindly will not come to paragraph 15 at the bottom, where your lordships will not deals with this. It takes us to the another aspect of the matter, whether any case has been made out for initiation of contempt for civil contempt proceedings suo motu under rule 21B of the said rules. Now, my lord, this, then lord, your lordships deals with this. If your lordships straight away, lord, come to page, next page. Lord, please come to the last 4 lines. After your lordship discusses lord, rule 21B, then your lordships will find, although the High Court is conferred with the power to initiate proceedings suo motu for civil contempt, yet it is an ardent duty of the High Court to first satisfy as to whether there has been any violation of an order passed by it. It is paramount consideration of the court to ascertain any violation of its order for the purpose of issuance of the notice upon the alleged contemners, and such satisfaction should have been recorded in writing so that the person against whom the aforesaid contempt proceedings is initiated would get a sufficient notice of this alleged role in the violation of the order, so that he may get an opportunity to disclose his stand on such perceived allegations. Then Lord, please come to internal page 15. Page 100, Lord. Kindly, Lord, the paragraph starting with the word, paragraph 21. The present application for contempt, has your lordship found that, is founded on the fact that despite the said order by which alienation and transfer of the subject pipeline was impeded and or interdicted, the same has been done, and therefore such action is contumacious, and therefore the court must activate the provisions of the Contempt of Courts Act against the alleged contemners who are arranged as the respondent in the contempt application. Then, Lord, the other facts your lordships have noted, Lord, which are the facts? There is no dispute with regard to these facts about the balance sheet. Lord, kindly see III. Alleged contemner number 34, SR Steel, is continuing, SR Steel that is, III, is continuing to assert that its owns the aforesaid pipeline transferred to it by petition number 1, even after the order dated 22nd December 2016 passed by this court. The resolution plan approved by NCLT constituting one judicial member is in flagrant violation. Then, Lord, your lordship records, Lord, what are the points taken? Then, Lord, your lordships may kindly come to page 21. Or rather, Lord, before that, please come to page 17. That is, Lord, in 102. Lord, kindly take, Lord, the 4th line from the top. The sentence starting with the word in course of an argument. Has your lordship found that? Even some of the averments made in the contempt application would reveal that this court holds that there is no civil contempt, yet the conduct of the parties and the manner in which the parties have acted before the different forums invite the initiation of a suo motu proceedings for criminal contempt, as it tends to or actually interferes with the administration of justice, as well as tarnishing the image and reputation and sanctity of the court. The litigation has traveled in different forums and under different provisions of the Act, and we do not find any element disclosed in the said application that any attempt was made to stay the aforesaid proceedings or any order being passed in this regard. The fact remains that the proceedings before NCLT continued and reached the final destination upon approval and acceptance of the resolution plan. The respondent number 34 was admitted in corporate insolvency process before the National Company Law Tribunal, Ahmedabad, under the Insolvency and Bankruptcy Code. The respondent number 45 was held as successful resolution applicant initially by the Committee of Creditors. Then this fact can be skipped for the time being. Please come to Lord, page 21. Yeah. Or rather, Lord, yes. Kindly, Lord, come to paragraph 23. A sentence starting with the word contemporaneously. Has your lordship got that? The petitioner number 1 was also admitted in corporate insolvency resolution process by the National Company Law Tribunal, Cuttack, against the respondent number 45, who emerged as resolution applicant in contempt number 34, was also declared as successful resolution applicant, and the resolution plan was unanimously approved by the committee of creditors of the petitioner number 1, followed by an order passed by NCLT under section 3031 of the IBC. The appellant in FMAT such and such, wherein the order of status quo with regard to transfer and alienation of the subject pipeline was passed, along with the petitioner number 2, challenged the said order of approval passed by the NCLT to the resolution plan, approached the National Company Law Tribunal, but could not emerge successful therefrom, as their appeal was dismissed on 18th of January 2022. Although the petitioner number 2 did not proceed further, yet the said appellant challenged the said order of NCLT before the Supreme Court, and specially petition was eventually dismissed. The resolution plan in respect of the petitioner number 1, as well as the alleged contender number 34, would reveal that all the shares held by the respective members were effaced and reduced to nil. Now, my lord, next paragraph, kindly take the second line onwards. It says, at one point of time, it is contended that the pipeline belonged to the petitioner number 1. On the other, it is contended that it belongs to the alleged contender number 34. The fulcrum of the entire allegation, running into several pages, are founded on an assertion that the moment the pipeline was transferred to the petitioner number 1 by the alleged contender number 34, and the deed of cancellation being the subject matter of the suit in Shalda Court, was subject to the approval of the lender and the stakeholder, including the shareholder, the same cannot be regarded as a complete transfer of the said pipeline, and therefore was not given effect to at any point of time. However, the cancellation deed is the subject matter of challenge in the suit before Shalda Court, and the appeal was sprung therefrom, in which the order of status quo order with regard to the transfer and alienation of the pipeline is passed by this court, and the said appeal is still pending. So the suit before Shalda Court. Now, Lord, please come to page 21. Sorry, this is at page 106. Kindly, Lord, come to the third line. The sentence starting with the word, it would not be proper for the High Court. Has your lordship got that? High Court, in exercise of the contempt jurisdiction to hold the person guilty of violating the order of court, if the facts emanate from the record would reveal that certain acts have been done in due implementation of the order passed by the contempt competent forum, it may remotely suggest the technical contempt, but the moment the approach is made to a forum raising a plea of nullity, it is advisable that the court should not initiate a contempt proceedings when the act complaint of is in due implementation of the order passed by the forum in exercise of power conferred by the statute. Such orders passed by NCLT, though after the interim order passed on 22nd December 2016, it should be 2016, yet those were passed in a proceedings which cannot be said to be invalid, but is exercise of power conferred by the statute. The order approving the resolution plan is affirmed up to the Supreme Court, and therefore simply because a plea of nullity has been taken does not appear to us prima facie to be in view of the language employed in section 419(19)(3) of the Companies Act 2013. It would not be proper for the court to issue a notice or admit on first motion the contempt application, as it tends to interfere with administration of justice. Even if the court finds that the contempt may be presumed, but is too venial to justify it being brought to the attention of the court, there is no difficulty in dismissing the motion. And then, Lord, please turn the page. The matter can be viewed, the next paragraph. The matter can be viewed from another angle. The stand of the parties in relation to the said pipeline is on the basis of the orders passed by NCLT and affirmed up to the Supreme Court. If a contempt is initiated on the teeth of the aforesaid orders, at this stage, it would have been an implied effect on rendering those orders ineffective and redundant, and the person who have acted on the basis of the aforesaid order would still be punished being guilty of violation of the order. If the status of the pipeline has been declared in a resolution plan affirmed up to the Supreme Court, it is too technical at this stage to issue a notice upon the alleged contemners being guilty of violative of the said order. Then a plea of fraud.
Respectful, is my learned friend arguing the CPAN or the recall? I just want to be clear.
I'll just clarify.
No, he may clarify before, my lord.
No, no.
The index
He's
was
arguing
in the
on-
beginning, my lord.
No,
The
no,
index
no,
was
no.
focused never at the end.
He's arguing on a application. application for recall.
Is argument on the merits of whether contempt.
no,
has
it's
been
not a
committed.
merit.
Patience, Mr.
Aha.
Please have
Give me the
patience.
index first.
No,
I
no,
will
no,
give you the index. I'll give you.
Mr. Costa.
Well, it's a
Let
very
him,
strange way of
I
arguing.
know, I am
I'll
conscious.
keep arguing. At the end, I'll tell you why I'm arguing.
No, no,
He should say, now on this point, I'm going to say this.
let him complete what he wanted. If he transgressed, we know how to pull him back.
Your lordship,
Don't worry.
time is
We
valuable.
know how to pull him back. Let him
So, Lord,
complete what he wanted to say.
My second point was that initiation of a contempt was also dealt with by your lordships on merits. Dealing with all the facts, taking into consideration whatever was argued by my learned. Therefore, Lord, my contention is that, Lord, this is a dismissal on merits. Where, Lord, a recalling application is not maintainable. This is
I'll deal with
This is not why I wanted your lordship to have a look at the order, because my lord's order does not stop at the locus standi point. My lord, on the last occasion, my lord indicated that I should have stopped there. But I said that because your lordship was also dealing with the other contentions, Lord, the maintainability initiation of a contempt was also, Lord, dealt with on merits. And your lordship said that this is not a case where, Lord, your lordship will exercise the jurisdiction in issuing a contempt. And the basic purpose, Lord, there are 2-3 reasons your lordships have given. One of them is that the entire action has been taken on the basis of a statute. And Lord, a competent forum has passed the order, which has been confirmed up to the Supreme Court. And it is also noted by your lordships that when learned friends client have challenged the order up to the Supreme Court, and Lord, this order was sustained. The approval of the plan, which was allowed by the NCLT, was sustained by to Supreme Court. Now, Lord, the other aspect of the matter is fraud. Your lordships have also dealt with it at the bottom of page 22. Your lordships will find a plea of fraud is also taken in a contempt.
In a lighter vein, had he said this in the beginning, then I would not have objected. Then I understand that he's arguing a recall.
I didn't understand that you
No,
would, yes, you are not following.
What he wanted to say is, that you have to just show the horse before you put him to a cart.
But I showed
You have not showed him.
I showed the face of the horse by saying that initiation of contempt was what I was dealing with.
But he showed such a small patch below that it looked like the butt of the horse. So I was wondering that why is he showing me the backside of the horse?
Correct your vision, sir.
But
Correct your
but I
vision.
will try.
Correct your vision.
But I will try. I'll go to the same
Anyhow,
Now, Lord, fraud. I said, Lord, a plea of fraud is also taken in the contempt application that the parties have fraudulently acted before the NCLT as well as Supreme Court and obtained the order therefrom. We are not unmindful of the settled proposition of law that the fraud unravels all actions, yet the particulars of the fraud is to be spelled out with perception and clarity.
No, with precision and clarity.
Precision, sorry.
That is wrong.
Precision and clarity.
That's my mistake.
No, it's precision and clarity.
It
No,
must be a
it's one
precision.
spelling mistake. A beneficiary of the
No, it's
fraud-
my mistake.
a beneficiary of the fraudulent act cannot reap the benefits therefrom, but equally unless the court found without any unreasonable doubt that the fraud has been committed, it would not be proper at the nebulous stage to initiate a contempt proceedings and punish a person. In whatever way we peruse the pleadings of the contempt application, we do not find that it is a fit case to admit the motion and to issue a notice upon the alleged contempt. The contempt application is dismissed. So, Lord, it is not a dismissal on technical point. It's a dismissal, Lord, on merits.
No, what he wanted to say is that there has been some error
Yes.
apparent on the face of the record.
Yes.
For that, he wanted to say that certain frauds have been pleaded. The fraud has been practiced upon the court in divulging the wrong, incorrect facts.
Right.
Which was well within your knowledge.
Now, Lord, please come to page 19. Lord, I have read, Lord, all the total judgment where my Lord had succinctly put, Lord, whatever was argued. There is not a word that my learned friend had said without, Lord, with the rider that, Lord, any fact that your lordship had recorded is incorrect fact. But Lord, he says,
he wanted
yes,
to,
internal page 19.
yes,
your lordship
he
will not
wanted to
kindly-
rely upon,
104. 104.
he
104.
wanted to rely upon,
This one paragraph.
My lords,
104. Kindly, Lord, take paragraph in the interlinked.
My lord,
Paragraph 25.
everyone has forgotten
Paragraph
phrase
25.
five.
Paragraph 25.
Yes, I'll
Aye.
just, my lord, address your lordship on that. That is my next point.
Yes.
Lord, because I thought, Lord, I'll first place the judgment. Paragraph 25, may I just read paragraph 25 before I make
Third
my
line of that paragraph. Third line of
third line of that paragraph, it says,
That's the next point. Let me know the horse. Where's the horse?
I'll show you the horse. Just a minute. Have patience. The resolution plan would reveal that the aforesaid pipeline was always intended to be a property of the respondent number 34. And after the approval of the resolution plan, recognizing the alleged contempt on number 34 as a successful resolution plan applicant, no further deliberation is required thereupon, as the order approving the resolution plan was affirmed up to the Supreme Court, and therefore whatever has been expressly provided therein is binding on the parties. Lord, I say that, Lord, entire sentence will have to be read, because your lordships have said that it is inconsequential whether the pipeline belongs to 34 or 45. This is, Lord, your lordship's finding that, Lord, once the approval plans are approved, your lordships don't have to read it separately in a contempt jurisdiction, whether, Lord, it belongs to 34 or 45. This is not the sentence. I said that one can't stop midway the paragraph. One has to read the whole paragraph, because your lordships have clarified in the later part of the paragraph. It clearly says no further deliberation is required thereupon, as the order approving the resolution plan was affirmed up to the Supreme Court.
My lord,
Now, my lord,
is plan
what-
a typo, my lord? It should be plans or plan.
May I?
No, because that would be your lordship's typo. according to
My learned friend will kindly wait for his turn. I'm nearly, Lord, finishing my argument. Lord, I only say this, that, Lord, the paragraph has to be read as a whole, because your lordship's mind is reflected in the paragraph itself. Because your lordships have said that it is inconsequential to go into this issue as to whose pipeline, who has violated the order. This is totally inconsequential. That is how, Lord, the paragraph is poised. And, Lord, after that, your lordships have proceeded, Lord, to dismiss the contempt application, Lord, recording the fact that, Lord, under a statute, Lord, it's a statutory right which the parties have exercised. And it is too venial for the court to, Lord, even issue a notice. So, Lord, my submission to your lordship is that, Lord, insofar as the contempt application is concerned, not only your lordships dismissed it on the ground of locus standi, but also, Lord, your lordships went ahead, because the arguments, elaborate arguments were made to meet all the points. And this is a judgment, Lord, a reasoned judgment. There is no question of, Lord, recalling of an order which is, Lord, passed by giving reasons. And, Lord, even if I say that, Lord, even if your lordships have recorded here about the resolution plan, your lordships have really, Lord, clarified this paragraph in the later part of the paragraph. So, Lord, an inconsequential statement made in the judgment, even today, Lord, I say, if your lordships delete this paragraph, the judgment will still remain. It does not affect the judgment at all. So therefore, Lord, it's an inconsequential thing, and your lordships have said that in the order itself. So, Lord, insofar as, Lord, recalling is concerned, these are my humble submissions. I say that, Lord, all the grounds have been dealt with. Whatever grounds we took, locus standi point has been dealt with. Whatever point my learned friend urged has been dealt with, including the point with regard to fraud. And, Lord, the NCLT member being single member, etc., everything has been dealt with. It's a detailed judgment. So, Lord, there is no question of recalling it on the ground of 3 lines of a paragraph, because the paragraph will have to be read as a whole. Lord, these are, Lord, my submissions. The other thing, Lord, 151, a power under 151 can be exercised, Lord, under 2 circumstances.
No one is bothered.
One is, Lord, to prevent the miscarriage of justice. The other is, Lord, to prevent the abuse of the process of court. Lord, this application itself is an abuse of the process of court. Lord, these are my submissions.
Lord, I'll just take 5 minutes. Mr. Carr, you argue for who, sir?
I argued for it. Yes, I'll just take. Respond number 34.
Give your memo of appearance.
Lord, IFAR for the respond number 45. I shall be very brief. I don't intend to repeat anything that my Lord Mr. Kaur has said.
my lord, your lordship's judgment, my lord, has been placed, my lord, in my lord, fairly extensive fashion. My lord, lordship has decided on all the parts. Now, my lord, if your lordship will kindly see, my lord, page 76 of the application. What is my learned friend's cause of action here, with which he comes before your lordship?
Yes.
Well, he delves on the locus standi aspect, but will kindly see, my lord, this is what he really says as to why, my lord, he is making the application. Well, let kindly see 25A. The first and foremost to seek recall of an order obtained by fraud. Now, my lord, I pause here for a moment. My lord, today, if your lordship has been misled in passing an order, my lord, there's a fraud committed on court. My lord, then of course, my lord, your lordship has a power of recall. But my lord, that is not the allegation. My lord, kindly see how it is worded. To seek recall of an order obtained by fraud is the other side of coin seeking criminal prosecution, etc. Well, then your lordship will kindly see, well, the Honorable Supreme Court such and such. This being so, there can be no reach standard. Now, what is the fraud? Well, there has to be a fraud on court to trigger recalling. Your lordship has seen that there is no error apparent that is pointed out, so it's not a review. If it has to be a recalling, in that case, the recalling must be on the basis of fraud committed on court. Well, there is no fraud committed on court. That is not the assertion. Your lordship's order is being really challenged that your lordship has failed to appreciate the ground of fraud that my learned friend had made out while he was arguing the application. That cannot be a ground for recall. That's an order on merits. Your lordship has decided rightly or wrongly. My learned friend has judicial recourse against that. So, the first question is, how is this application maintainable? The secondly, if your lordship sees, he proceeds on the basis of derivative rights. Now, kindly see, if your lordship kindly sees, now, para B at page 77, last paragraph. That being so, since applicant number 2 has already set out in its description is acting only as a shareholder claiming derivative rights to act for applicant number 1 company, but also independently as a citizen. Now, we'll come to independently as a citizen that your lordship has dealt with, in extenso. Now, so far as his application, as on the basis of the derivative right that he claims to exercise is concerned, kindly have a look at the paragraph page 36.
Page
36. This is a part of the cause title. The cause title has 103 respondents. So naturally, it goes on to page 36.
Yes.
Now, if your lordship will kindly see, initially, if your lordship sees, this is how the parties were arrayed. Well, if your lordship sees, page 2, first is Orissa Slurry Pipeline Infrastructure Limited. Then, how is it, being activated? Acting through its notionally erstwhile but actually lawful shareholder
Same cause title as that of the contempt.
That's right. Now, so far as this is concerned, now, let us come straight away to paragraph page 35. Who is the applicant now? Stray Multiple Asset Investment Trust.
That's what he's not going to repeat.
Now, so
Kar said it, Mr. Sudipto Sarkar said it.
And
everyone says, I will not repeat the other ones.
Let my learned friend hold his horses. I have not even been 2 minutes into my argument. Well, now, so far as this is concerned, there is an order passed by your lordships on the 6th of July, which records that Smate has come forward and said that, he has given no one authority to represent it in this proceeding. Well, that is already recorded in your lordship's order of 6th July. Now, so far as this is concerned, then your lordship will find, it says, Stray is representing whom? Stray Industrial Finance, SIFL. SIFL has come and told your lordship that it has not given anyone any authority to represent. So, we have a gentleman who now says he's Veer Jai Khosla, who's the applicant number 2, but he does not even affirm the application himself. The application your lordship will find is affirmed by a third party. Now, not only that, if your lordship sees, he says he's a shareholder, but no proof of shareholding. Now, let us proceed on the premise that he is a shareholder. Shareholder of whom? He says, he is a shareholder of SIFL, Stray Infrastructure Finance Limited, wrongly mentioned as Stray Industrial Finance Limited. SIFL, has been paid every bit of money that it was owed. Not 1 rupee is outstanding to SIFL. Now, my lord, today, if SIFL has been paid, my lord, every rupee that was owed to it, my lord, under the plans, my lord, then, my lord, what is the cause that survives? He says, I am agitating a right as a derivative, my lord, a derivative interest. Now, my lord, with the greatest respect, derivative interest of, my lord, the company of which is a shareholder. That company has been paid its entire dues, nothing survives. Now, my lord, kindly see, now, my lord, what he now tries to, my lord, next agitate in his recalling application. My lord, kindly have a look at, my lord, I'm trying to, my lord, figure out what he says is right. My lord, kindly see, my lord, paragraph 1 of the application. Applicant is the appellant, Shrey Industrial Finance Limited, SIFL, acting through its shareholder who is claiming derivative rights to do so. Now, my lord, the shareholder is, my lord, the applicant number 2, who is claiming to be a shareholder of, my lord, SIFL. SIFL has, my lord, no axe to grind because SIFL has been paid its entire dues. Now, my lord, so far as derivative right is concerned,
SIFL has come and prayed for that he has not authorized.
yes, my lord, that is on record. Mr. Surajit Mitra, my lord, appears for SIFL. And, my lord, not only that, my learned friend had on the last occasion, my lord, when this, my lord, was pointed out to your lordship, said that I don't want SIFL, I don't want to ride on SIFL's back. Now, my lord, kindly see,
Subject to the caveat in my written submission, my lord.
kindly have a look at, my lord, now, what he says is, my lord, he is right to approach your lordship. First of all, I've said that application is not maintainable because there is no cause of action disclosed for recall. Now, my lord, kindly see paragraph 1.1. My lord, this is, my lord, what he says is, my lord, his grievance. Why he says he has a right to approach the court as a derivative, my lord, shareholder. My lord, the appellant company, which is applicant number 1 herein, is Shrey Infrastructure Finance Limited. It is a company which has contributed.
Industrial or
it should be infrastructure, wrongly mentioned is industrial.
It's a type.
The appellant company, which is applicant number 1 herein, is Shrey Infrastructure Finance Limited, SIFL. It is a company which has contributed 52% to the corpus of India Growth Opportunity Fund, administered by SMATE, the aforesaid trust. Notwithstanding the so-called insolvency resolution process that Orissa slurry pipeline infrastructure hospital has been subjected to, holding 69.81% of the total lawful paid up equity share capital of rupees 89.95 crores in hospital, wrongly being shown by the respondents at rupees 1 crore, appellant company SIFL is aggrieved because hospital was made the subject matter of manipulation and orchestration at the instance of respondents. So, my lord, the investment is made, my lord, according to my learned friend, by SIFL in, my lord, a fund, which fund is administered by SMATE. Now, my lord, so far as this is concerned, I, my lord, really have not been able to understand, my lord, as to how, my lord, this is being, my lord, represented to be, my lord, a shareholder's action in that sense. Now, my lord, even then, my lord, today, my lord, the shareholders have, my lord, approached court. My lord, this matter was contested right up to the Supreme Court by, my lord, Shrey itself. Did not succeed. Now, my lord, when the company did not succeed, the question is, my lord, can a person who now masquerades as a shareholder because he acquired his shares after, my lord, the company, my lord, went into CIRP, my lord, come and agitate these points? And, my lord, so far as the question of, my lord, your lordship has dealt with the question of, my lord, my learned friend's right to, my lord, approach this honorable court under the rules of this honorable court. Then your lordship has independently dealt with my learned friend's right to, my lord, act as a messenger to, my lord, draw your lordship's attention to, my lord, contempt committed, and, my lord, seek, my lord, punishment for contempt. My lord, that your lordship has dealt with. Then, my lord, he said that there's a fraud that has been committed. My lord, so far as, my lord, the act in violation of the order, my lord, of which contempt is committed is concerned, my lord, that your lordships have dealt with. Now, my lord, what is the portion, my lord, that my learned friend says is, my lord, the portion for which there should be a recalling? My lord, today, with the greatest of respect, my lord, your lordship has really, my lord, indulged all of us in this matter. But, my lord, with the greatest respect, my lord, if these kind of, my lord, applications are entertained, my lord, this, my lord, in itself is, my lord, a grave abuse of the process of this honorable court. And, my lord, this, my lord, must not be countenanced. Now, my lord, so far as this is concerned, just one last submission I wish to make. My lord, my learned friend, my lord, assertion of locus. My lord, the same assertion was made by my learned friend before, my lord, the National Company Law Appellate Tribunal in, my lord, Shrey Industrial Finance Limited versus Satish Kumar Gupta. My lord, may I just hand up a copy of this, my lord, order to judgment to your lordship? My lord, my learned friend, my lord, appeared in this matter, so he's very well aware of it. My lord, this is, my lord, the my lord, bench of the appellate tribunal. Lordship will kindly see, my lord, my learned friend represented, my lord, SIFL in my lord that matter. And my lord will now kindly straightaway come to page 40.
The applicant was different in the matter, my lord. I'm sure my learned friend will come to that in due course of time. That the
My
applicant.
lord,
in that
kindly have a look at
application
my
was
lord,
different.
page 40.
But again, I find industrial finance.
Yes,
Different
my lord,
shareholder.
my lord,
Industrial
there is nothing
and
called industrial finance,
infrastructure, that is what
infrastructure.
I'm asking.
My lord,
Yes?
that mistake has my lord been my lord perpetuated in my lord a lot of places. It is infrastructure. There is nothing called stray industrial finance.
But Bill Gates is culpable, my lords. Copy paste, copy paste.
My lord, kindly
copy,
see.
paste.
Kindly see, my lord, page 40. It is SIFL, my lord, SIFL stray infrastructure. My lord, this mistake has, my lord,
Whatever.
ultimately
yes.
crept in number of places. Now, my lord, kindly see page 40. However, in the present case, a feeble
40
40
of,
my lord, of my lord, this judgment in order of the enclave.
yes.
However, in the present case, my lord, just after the italics, however, in the present case, a feeble stand has been taken.
No, page, oh, sorry, I'm looking at 39, sorry.
Well, your lordship will find a portion, my lord.
However, yes.
However, in the present case, a feeble stand has been taken that applicant number 2 is a shareholder. In the capacity of a shareholder, she can also represent company applicant number 1. Applicant number 2 has not even bothered to disclose as to what was percentage of her shares in the company. In any event, it is not a case that majority shareholder had come forward to protect the so-called interests of the company. The applicant number 2 had taken plea of exercising the derivative right in the interest of the company, that is applicant number 1. The applicant in the present application has admitted that the management of the company is under administrator. Once administrator was there in normal course, having been satisfied that the committing fraud judgment was obtained, then in that event, it was expected for applicant number 2 to request administrator to take appropriate steps. In the present application, applicant by way of referring to 2 emails purported to be sent to the administrator of the company, well, these emails are well noted, has tried to develop a case that earlier administrator was requested to protect the interests of the company in the present context, and thereafter the applicant filed the present application. However, on the face of the aforesaid emails, it is difficult to place reliance on the same. In the email dated such and such, some event which took place on 10th February 2023 has been referred, whereas second email dated 10th February 2023 reflects that it was sent on 20th February 2023 at such and such hours. However, the present application itself was verified on 10th February 2023. If we propose to further verify the genuineness on the issue, we will have to conduct an inquiry whether on the same date before 1807 hours any communication was made by the applicant on behalf to the tribunal or not. We consider that at the moment such inquiry is not needed particularly. Insofar as the submission made by Mr. Khosla, learned counsel for the applicant, that fraud vitiates everything and his reliance on the judgment of such and such is concerned, we are also in agreement with submission that fraud vitiates everything. However, before treating a judgment as nullity obtained on the basis of fraud, primarily, court is to be satisfied the fraud has actually been committed. In the case of SP Chengalvaraya, fact was entirely on different footing. In this case, preliminary decree was obtained by fraud and concealment of fact which was not in the knowledge of the defendant at the time of preliminary decree. However, at the stage of final decree, fraud was detected by the defendant and such, the court was persuaded to dismiss the case. In the said case, order impugned had not merged with the order of the Supreme Court. However, in the present case, after the
particular case, there was certain mutations which were affected. Those were suppressed, and later on, those mutations entries were disclosed, and the court perceived that it is a fraud.
Now, that is, my lord, fraud practiced on court.
Special precedent
That
which
is,
prove
my lord, my
that
learned friend will
Indians
hold
in a
himself.
lighter way.
No, my lord, my lord,
Lordship is smiling.
He's on the lighter side, not on the merit.
But Indians, when it comes to fraud, are very creative people. So that is why there's a catena of judgments. And then we have courts trying to distinguish. No. This fraud will not be covered by that judgment because that judgment was a different fraud.
At the end of the day, my lord, the court has held, even the NCLAT has held in this case, my lord, on a similar application, my lord, relating my lord, similar my lord, set of facts and circumstances, which your lordship will find from the rest of the judgment, that my lord, A, there's a merger of the orders, my lord, in the Supreme Court judgment. B, my lord, so far as the fraud is concerned, there are no particulars, no precision, my lord, fraud stated. That is also noticed by your lordships in the judgment in question. And my lord, C, my lord, that my lord, there is no locus standi, my lord, which can really be, my lord, canvassed. So, my lord, all these points repeatedly in different fora, my lord, have been canvassed. My lord, courts have always held against my learned friend, always. Now, my lord, today my learned friend really wants your lordship now to convert this, my lord, contempt application into a suit come to a finding of fraud.
No, we are on the recalling. We are on the recalling.
No, that's what,
Stick to
that's
that,
right.
my lord.
Now, my lord, that is, my lord, what I see, my lord, the application purports to be. But if your lordship looks at, my lord, what is, my lord, ultimately being sought to be canvassed is that please hold that there's a fraud committed right up to the Supreme Court. Please denounce that fraud and please take necessary putative action so far as that is concerned. But that can't be done. With the greatest respect, my lord, I would, my lord, implore your lordships to, my lord, kindly not, my lord, give any further, my lord, leeway to my learned friends. My lord, this is an application which is a miscarriage of justice. It's an abuse of the process of this honorable court. It is, my lord, really an attempt to, my lord, ultimately undermine, my lord, the dignity of this honorable court by my learned friend, because he, my lord, purports to, my lord, seek recalling by saying that your lordships have heard without, my lord, seeking recourse to, my lord, what is the judicial review available to him. My lord, I would request your lordship to kindly, my lord, dismiss this application with exemplary costs.
If he could indicate, my lord, what may be exemplary costs. Because we might just volunteer a donation, my lord, rather than keep on hearing this barrage of exemplary costs.
No, this is not expected actually.
No, my lord, he wants exemplary costs.
Can say exemplary.
I don't know, he wants
has left to
5,000,
the
5
wisdom-
lakhs, 50
it
lakhs.
is left to the wisdom of the court.
Well, if your lordships are seeing, since my learned friend says this, kindly have a look at the last paragraph of this order, my lord, which I did not place. The enclad judgment, just the last paragraph.
Your lordship may kindly underline it, my lord, for reason I will explain.
In view of the aforesaid facts and circumstances, we have the considered opinion that the present application can be dismissed primarily on the point of its maintainability. Accordingly, the present intervention recall application stands dismissed with indication that if any further material is brought to our notice regarding any other specific ulterior motive of filing the present application, we may consider to issue appropriate direction for in-depth inquiry investigation by appropriate investigating agents. My lord, there is a limit, my lord, to which we can go. We can't, my lord, keep pressing that limit. Copies actually दिए दो ना. Well, my respect, submissions.
My lord, I shall try to, my lord, be very, very, my lord, miserly, my lord, in my submissions, my lord. I am appearing for 11 to 15, 1 to 11. 1 to 11.
We will appreciate it.
And I'm sure, my lord, he will not repeat.
Provided, my lord, I'm
what
not,
his colleagues have said.
provided I'm not interrupted, my lord, in my lord, this.
We need to point out the horse is missing, my lord.
Yes.
Now, my lord,
On a recalling.
my lord, let us first, my lord, try to identify who is the petitioner.
There we go. Locus, derivative rights,
No, no.
cannot appear.
Whatever.
I need your
Please,
lordship's
please,
protection, my lord, this
please.
can't go on.
Please,
I also
please.
need protection, my lord. This cannot go on.
No, please.
This
Everybody has.
constant refrain, I will not repeat, and
Please.
then they start repeating.
No, Mr. Koshtra. Every counsel has a right to argue a case on behalf of his client. That is, let us manage the court. Let the court be not managed in other. We'll manage it.
But that is what is
Don't-
happening.
Now, my lord,
You did not allow us to react, and you reacted
Because
very
I'm a
promptly.
lord's officer.
No,
I am my lord's protector.
but let us.
Very good.
Let us. Yes. Yes.
He needs protection from another protector.
Yes. What do you say, Mr. Saha?
my lord, will your lordship, my lord, permit me to first, my lord, help your lordship, my lord, identify who is the petitioner? Is the petitioner?
That has been, I tell you very frankly.
My lord,
that has been-
kindly
that
give
has
me, my
been
lord.
argued. That has been argued.
I've been
by-
here. I've been here.
Now all the stand of all the councils are that look, they are the same
My lord,
persons.
give me 5
The
minutes.
same
It will take
persons
lesser
who were
time.
there, who were there in a. Do you want to take
My
a
lord, if your
different
lordship doesn't
approach?
want me to argue, my lord, I'll leave. My lord,
I'm
but
asking
kindly give me, my lord,
Mr.
10 minutes
please,
time.
If we can have a patience, you too should have a patience. If you want to address from a different angle, definitely we will permit you to do it because we do not want to leave any stone unturned. If
My lord,
they have approached from a straight line, you may approach from a curved line, no difficulty, but not in overlapping the straight line.
That is
what-
that you will decide, my lord, but let me open my case.
My lord, may I
Yes.
make a concession in his
May I,
favor?
may
In
I,
his
may I
favor?
open my case? My lord,
May I
let,
make a concession in his favor? In his favor.
my lord, then
May I-
your
may I
lordship will say,
May I say,
My lord, will my learned
He's
friend not
making
die?
a concession.
No, I don't want his concession. Let me proceed in my.
If I'm giving a concession, then it does not.
No, thereafter, your lordship will say that, my lord, I'm reacting.
Uh-huh.
Your lordship will not
If
grant me the
somebody-
protection, my lord, then I'll have to do
somebody
it
is
myself.
conceding, somebody is
No, no, I'm not,
conceding.
I don't want his concession. Let me place my case.
Hell with it.
He
wants
has,
it, my lord.
he
The
has,
court needs
no,
it.
no, no.
If he concedes to this, yes, that they do not
You
have a.
should kindly
lotus standi.
permit me, my lord, with the deepest of
it?
respect, kindly, he doesn't know what I'm going to say and he's conceding.
Yes, my lord, kindly permit.
He
me.
doesn't know what I'm going to say. I've not opened my mouth. Both your lordship and he will not permit me to proceed.
My lord, my
Now-
concession.
Say that, my lord, I'll
now,
go
Mr.
away.
Khoshla,
Say
let
that, my
him-
lord, I'll go
I
away.
have permitted everybody to.
My lord,
ask
I have
in his own
also,
way.
my lord,
Mr. Shah, please have patience.
And please ask
I
him
have,
to control and.
sorry,
my lord,
please,
he's got
please,
foul
I have
temper.
permitted,
He
I
tends
have
to lose it in
permitted,
court.
Mr.
No, my lord, your
Khoshla, I
lordship
have
is not-
permitted every councils to
he,
argue
what
in
did he
his own
say?
way.
He said, I have a foul temper and your lordship is not checking him. Then I'll check it myself.
I did not hear it because I am.
He said, I have a foul temper and I should be directed to control it. And your lordship is not, my lord,
Please,
reacting to
please,
that. Your lordship
The
is
audio
telling me.
system, the audio system creates a lot of.
No, my lord, I think everybody heard it loud and clear.
Just one,
He repeated it 3 times.
just let me,
No, my lord, first kindly take care of this.
we will. You are not permitting me to speak.
He likes
Please,
to dictate.
please,
how
sorry,
things must be
Please,
carried on.
sorry. Every council has a right to argue in his own way. We will not interrupt it. And every council, I am requesting to please forbear from using any other words. Which in the good spirit does not appear to be so.
Point out.
Please do not do it. Let him finish. Let us take care of his argument. We'll take care of that.
Just one
Yes.
submission. my lord. Just
No,
one
nothing,
submission.
no
My lord,
submissions. You will get an
Let's-
opportunity. You will get an opportunity to give a reply. You will take note of it. Say everything
I
in reply. There
surrender
will not be.
derivative
Yes.
rights if they are willing to address the fact that your lordships have held that contempt is permissible suo motu, and therefore I do not see why
The
recall will not be
difficulty-
permissible.
No,
suo
Mr.
motu.
Khosla, the difficulty is that every concession is subject to certain riders.
No, no.
No,
my lord,
that
your
is what I
lordship
say.
judgment.
No, this can't be. Let him argue.
Very well.
Let him argue. Yes.
I first want to, my lord, once again request your lordship to take note of the fact that he repeated 3 times that I have a foul temper.
This
I'll
is
give you
all.
an affidavit,
no,
my lord.
sir.
I will give you an affidavit by this
Please,
evening.
please,
Yes.
Serve it on him as well.
Now, my lord,
please.
if this is the way
entire
in which,
nation, the entire
Lord-
nation is looking at it.
no, I know that. And that is why your lordship must come down on this with a
Yes.
heavy hand.
Absolutely.
Because, my
We'll
lord,
consider
when
that.
I try to, my lord,
Joyce
interrupt
Saha
it.
versus Deepak Khosla is a personal attack being made in robes. A senior advocate, my lord, cannot act. He wants to move an allegation. Let him move an application. I have no difficulty, my lord. But we can't.
What is
sit
this? I want to act.
contest
This is
between
What
not
are
a,
you saying?
this is not a debate
No, this is
which
not.
is going on
He's urging
that
your lordship to
everybody
take action against-
immediately interrupt. No, please take your seat. You also take your, everybody should take a seat. Let him speak. His turn has come.
Very well.
Argue.
Now, my lord, let us first try to identify who is the petitioner. My lord, is the petitioner Hon'ble? Is the petitioner's
It
mate?
is appearing from the cost title.
No, my lord, my lord, if your lordship will then kindly come straight away, my lord, once to the cause title, the petitioner, my lord, actually is, my lord, Jai Vikram Khosla. If your lordship, my lord, will kindly take Veer Jai Khosla, I'm sorry. Kindly, my lord, have, my lord, paragraph page 35 and 36. So let us first find out who is the petitioner. And your lordship, my lord, I request you to read it backwards. Instead of, my lord, reading, my lord, from page 35, read from page 36. So the last name that your lordship has at page 36 is Veer Jai Khosla. Now, my lord, Veer Jai Khosla, then your lordship will go to the name above that. That is Shrey Industrial Finance. Now, below that, acting through Veer Jai Khosla. So, my lord, Veer Jai Khosla, my lord, is the person who is, my lord, at the bottom of the chain, who is actually the petitioner. Now, my lord, Veer Jai Khosla seeks to represent Shrey, and Shrey, my lord, seeks to represent, my lord, Smith. That is the chain of events. So, actually, my lord, the petitioner before your lordship is Veer Jai Khosla. It is not even Veer Jai Khosla. Now come to page 85, which senior Mr. Shah showed to your lordship. And it is filed through a constituted attorney.
Allegations as serious and severe as this, matter having traveled to the Supreme Court a number of times, it is filed through a constituted attorney whose, my lord, power of attorney is not disclosed. What kind of, my lord, expertise he has in the matter, where he derives his knowledge from, my lord, how he is, my lord, connected to, my lord, Veer Jai Khosla, nothing. So, my lord, if Veer Jai Khosla, my lord, is the petitioner before your lordship, kindly examine, my lord, his basic right to represent. He says, my lord, he is a shareholder of, my lord, Shrey Industrial Finance Limited. That is, my lord, the capacity in which he seeks to, my lord, seek audience before your lordship. Now, my lord, the first thing, therefore, he had to say is how many shares he owns, what are the distinctive numbers, what is the percentage of his shareholding, my lord, in Shrey Industrial Finance, when did he acquire these shares, where are the original share certificates, for what consideration he my lord, holds, and who are the, my lord, other shareholders that he seeks to represent. Zero. So, my lord, other than a bold assertion that I am a shareholder of, my lord, Shrey Industrial Finance, there is, my lord, I say this with a sense of responsibility, not one document in, my lord, can 10 before your lordship or in any other, my lord, proceeding, from which it will appear, my lord, how many shares, my lord, Veer Jai Khosla, Mr. Deepak Khosla's son, my lord, holds in this proceeding. No, because, my lord, it's important. Because this is, my lord, a personal crusade.
From where you got it?
Where I got what? Page
Yes,
36.
The second sentence from where you got it,
The second sentence, my lord.
which you said. First sentence I can understand. From
Yes.
second sentence from where you got it.
My lord, I'll just check up. But, my
Yes,
lord, I
please
don't think
check
this
up.
will be denied. But I'll just check up. I'll just check up.
So we're waiting.
Yes.
Lord, there are a lot of tricks are employed.
Sorry,
I will
sorry,
just
Mr.
Very
Khosla,
good.
you did not.
Now, my lord, your
When we have
lordship.
counted him
Yes.
for two sentences. First sentences I can understand. Second sentence which you uttered, from where you got it.
My lord, my lord, no, it's
May I
defamatory.
repeat
Yes,
these two
absolutely.
sentences? May I repeat?
Yes, my lord.
First sentences you say that he is claiming to be the.
Yes, my lord, I'll tell you, lordship.
Yes,
I'll
he is
tell you.
claiming to be the
Yes.
shareholder. He has not disclosed anything. I can understand. Second sentence which you
My lord,
say,
there is another. Let me first answer.
son of, where, from where you got it?
CPAN 70 of 2023, page 160, affidavit of Mr. Veer Jai Khosla.
Where is
I,
that?
Mr. Veer Jai Khosla.
Where it is?
My lord, that is in CPAN 70.
70.
Which is, my lord, another, which is item number 91, the next item in your lordship's list.
Yes, what it
We are
says?
now arguing 90. This is
Yes.
91.
What it says?
My lord, page 160, if your lordship will permit me, I can hand it up. I, Mr. Veer Jai Khosla, aged 25 years, son of Mr. Deepak Khosla, occupation business.
Which Deepak Khosla, my lords?
So which Deepak Khosla?
Which Deepak Khosla, I don't know.
There may be
Maybe, my lord.
many
If-
persons.
let him deny that. It's not
So-
his son.
Not to deny anything, not
So
stay
why
No,
you
we've
will
not yet
invite
come to
such
the
a
affidavit
fringe issue?
stage.
No. Why you will invite such a fringe issue to come?
My lord, I'll tell your lordship. Very well, my lord, your lordship will ignore that. Ignore that for the time. Ignore that for the time. So, my lord, your lordship, therefore, permit me, my lord, these are, my lord, my learned friend doesn't want me to address the moot point. The moot point is, I concede, my lord, I should not have allowed him to digress me.
Not a point that is
But-
moot does not require to be addressed.
No, let us.
Now, my lord,
Please, let
the
it.
moot point, therefore, is
Yes.
that, my lord, the person's name appearing at the bottom of the cause title
Yes.
is, in fact, the petitioner.
Yes.
And he is an individual who has, my lord, come together asserting that he is a shareholder without giving any details
Yes.
or any documents. Now, my lord, if, my lord, there is, my lord, a complete, my lord, silence with regard to, my lord, the amount of shares hold, percentage of shares. Your lordship is aware, my lord, that normally, my lord, a person, my lord, under the Companies Act is allowed to carry on a derivative action on behalf of, my lord, the other shareholders if he has a certain percentage of shareholding, my lord, under section 244 of the Act. He must either have 1/10 or he must have, my lord, 1/10 of the number of shareholders. Now, my lord, therefore, my lord, your lordship, my lord, has nothing to go by, my lord, this man's locus standi to institute the petition.
Yes.
Now, my lord, I shall, my lord, work my way up. So, my lord, first is Deepak Veer Jai Khosla, my lord, fails to satisfy, my lord, the initial test as to why, my lord, an application, my lord, can be entertained, my lord, at his behest and instance. Second point, my lord, is, my lord, now he says he represents Sway Industrial Finance Limited.
Yes.
Now, my lord, before I show your lordship, my lord, his, my lord, interest in Sway Industrial Finance Limited, my lord, let me, my lord, first, my lord, try to, my lord, breach, my lord, the missing part of the puzzle. How does Sway Industrial Finance comes in? Sway Industrial Finance comes in, my lord, as your lordship sees from
It
the
is
cost structure.
infrastructure. It should not be industrial. anyhow.
Infrastructure, I'm sorry. Because it says, my lord, that it is 52% of the contributory of SMAT. Sway Multiple Asset.
Yes.
Now, my lord, kindly have one page of your lordship's order, of which recalling is sought. Kindly, my lord, come to page 95, which is possibly in volume 2, and kindly take paragraph 14
Our judgment.
of your judgment, your lordship.
It is there at page, internal page.
My lord, I am
The
reading
same-
from
same,
the paper book.
Uh,
Internal
can
page,
10 it is here. Internal page,
my lord, 10, paragraph 14.
paragraph 14. Yes. Yes.
The petitioner number 1 is the company which has been subject matter of an insolvency proceeding under IBC at the behest of its creditors or conglomerate of the creditors, and resolution plan has been approved, and all shares, preferential, equity or otherwise, have been effaced or reduced to nil. This is, my lord, your lordship's finding. This is not a recording of submission. My lord, your lordship has, my lord, I'll read this paragraph, but let me formulate the point I'm making.
This is the
Your
petitioner-
lordship, in your lordship's judgment,
This is the
ha-
petitioner number 1. And the
Petitioner
number 1 was a.
petitioner number 1 is Sway, Sway Infrastructure.
Hospital.
Hospital.
Hospital. That's why
Hospital.
you did not have to. When we are saying
I
that was hospital.
Hospital.
I'm very, very brotherly feelings to
Yes.
my
No,
brother and
no, no.
him,
Yes.
not earth.
Now, my lord, your lordship will kindly see.
Yes.
My lord, first let me, my lord, formulate the point before I go. Now, my lord, your lordships have noticed that, my lord, once a resolution plan, my lord, is approved, whether it is the resolution plan, my lord, of CIFL or it is the resolution plan of Hospital, the, my lord, passing of the resolution plan, what are the fundamental things, my lord, it does? Amongst other things, it, my lord, first wipes out the existing shareholding. And whoever is the new bidder or, my lord, the new resolution applicant who has, my lord, succeeded in the bid, my lord, his shareholders come in. So, my lord, this is the paragraph where your lordships take note of the fact that, my lord, the shareholding, my lord, of, my lord, the companies, my lord, CIFL, Hospital, my lord, these, my lord, have been, and the words your lordships use are effaced or reduced to nil. Hospital. Effaced or reduced to nil. Therefore, my lord, the shareholding, my lord, no longer exists.
True.
Now, my lord, if the shareholding does not exist, can, my lord, Veerjay Khosla come to say that I am a shareholder of CIFL and CIFL is a shareholder of X, Y, and Z, because, my lord, CIFL is no longer a shareholder of Hospital, of SMAT or Hospital. No longer, my lord, a shareholder or, my lord, a contributor of SMAT, because, my lord, the entire thing is effaced. My lord, these are the words. Keep quiet. Now, my lord, your lordship will kindly, my lord, permit me to read this. The petitioner number 1 is a company which has been subject matter of an insolvency proceeding under IBC at the behest of its creditors or conglomerate of creditors, and resolution professional plan has been approved by all the shareholders, preferential shareholders or otherwise, have been effaced and or reduced to nil. The cause title would reflect that the petitioner number 1 is sought to be represented by the petitioner number 2 as notionally erstwhile, but actually its lawful and actual shareholder. The moment the resolution professional plan has been approved and implemented, as the record would reveal that the same was challenged at the behest of the creditors, lenders, shareholders before the appellate authority as well as the Supreme Court, got affirmed, the said company cannot be represented through its shareholder or lender, as the said shares get effaced and or reduced to nil So far as the petitioner number 2 is concerned, it is a trust established under the Indian Trust Act 1882 and is claimed to have been acting through its investment manager. The trust being a legal entity governed by the Indian Trust Act, the assets and properties of the trust vested upon the trustee, and the proceedings before the court can be initiated through its trustees. In the absence of the trustees being arraigned as party, the trust cannot be represented. My lord, kindly pause here for a moment. This is the finding that my lord, SMATE can only be represented through a trustee. And my lord, in that case, my lord, SMATE, my lord, your lordship will now kindly see, not being a party to the suit, I'm sorry. The trust vested upon the trustees and the proceedings before the court can be initiated through the trustees. In the absence of trustees being arraigned as parties, the trust cannot be represented through its investment manager, nor it can derive any right to represent the trust in such capacity. There is no hesitation in our mind, in view of the facts narrated above, that the petitioner cannot be regarded as a party or an aggrieved party, being not a party to the suit in the Shialda court or in the PIL filed before this court, which is still pending. In view of the above, we do not find that Rule 21A of the rules for contempt framed by the High Court has been fulfilled or satisfied, and therefore held that the contempt application cannot be entertained at the instance of the present petitioners. So, my lord, your lordships have held that, my lord, only, my lord, the trustees, my lord, can represent the trust, my lord, in terms of the provisions, my lord, of the Code and the Trust Act. Now, my lord, therefore, to say that, my lord, Veer Jai Khosla will represent Sifil, and Sifil, my lord, has an interest, my lord, in SMATE, and therefore, my lord, the petition is maintainable, is, my lord, with the utmost of respect, my lord, absolutely, my lord, completely baseless. Because, my lord, there is already a finding. If the finding is there already, then, my lord, this stares him squarely in the face. That, my lord, other than a trustee, SMATE cannot, my lord, be appearing before your lordship.
Difficulty, I tell you very frankly. Suppose a proceeding has been initiated and ultimately the court by a judicial pronouncement held that the plaintiff does not have a locus standi. Does it mean that the right of the plaintiff to challenge that particular findings made by the court is completely taken away in all senses? No. Because that order or this finding can be challenged subsequently. Even a review can be filed,
Correct, but
saying that there is an error apparent on the face of the record.
Veer Jai Khosla was not there in the previous petition.
Now, question is, because you are talking about the SMATE. SMATE was there as a party.
Yes.
So the SMATE has come as one of the applicants for the purpose of recalling of the order. So that application has to be taken out
with the deepest of respect.
Now, that is what I'm saying.
Yes.
Now, your contention is that it is actually not the SMATE or the SIFR. It is somebody else who claims not only a derivative title, but also as a shareholder who have come up and filed the application, who was not a party in the contempt.
May I just add?
He was not an applicant in the contempt application.
May I just add a small caveat to this? My lord, I do not dispute that SMATE can come up at any time and challenge your lordship's order, either in appeal or review or recall.
Correct. That can be done.
SMATE can do that.
Yes.
But my lord, your lordship has come to a finding that whatever SMATE does has to be done through its trustee. That is the finding.
But look at it.
Now,
it is not a permanent or complete embargo on the SMATE to file. If they could prove that this particular finding is
my lord, I already bound
law,
down. I already bound down that SMATE can come. But my lord, kindly see what the law is. The law is that a trust.
The court has also arrived at the finding that this is the law.
That's exactly my point.
But the remedy to a party cannot be stopped because he may contend. Ultimately, whether he will succeed or he will not succeed is a different scenario. But he may contend that this finding is wrong, perverse, contrary to law. Can he not do it? Ultimately, what will happen is a different.
This question, my lord, a party meaning, my lord, who? A party meaning an existing party. SMATE can come up. SMATE through its
This is
trustee
what-
can come up and say
Correct.
that your lordship's finding is
what
incorrect.
your contention is somewhat different. Your contention is that SMATE, I can understand, but here actually neither the SIFL nor the SMATE who have come. The actual applicant is somebody else.
Yes, that is my first submission. There are
That
two
is something,
submissions.
somebody else who was not there at the time of the contempt application. And for the first time, an application for recalling has been filed. And then you say that this person has no locus standi for non-disclosure of 1, 2, 3,
If
4,
I
5,
may
6.
put it in point form, my first point is that in the absence of any proof or documents, he cannot say, Mr. Khosla cannot say that he represents CIFL. That's first point number one.
Saying,
That's point number one.
yes.
That he cannot say that he represents CIFL. Number one. Number two is, CIFL cannot in any event represent SMATE, because in terms of your lordship's order and in terms of the law, a trust can only be represented by the trustee, which is already mean your lordship's finding. So, this is the second point. It's a completely independent point. That even supposing Mr. Khosla had come and disclosed that he has 20% shareholding. Even then, the question that would beg your lordship's consideration is that could CIFL have represented SMATE in view of this particular portion of the order. And I don't think, here I will take correction from my friend, I don't think this portion of the order has been assailed as being wrong or incorrect. So if that is the situation as on today, that this particular finding of your lordship to the effect that SMATE can only be represented under law through a trustee and not by its agent as it was being sought to be done before,
We'll
then
consider that.
then CIFL cannot represent SMATE.
Correct,
That's the
correct.
second
That is
part.
what is, yes.
The third part, is there are three arguments combined, in this argument. The third part is, with the passing of a resolution plan, the entire previous shareholding gets wiped out. Now, therefore, if Mr. Khosla was a previous shareholder, so, there, the question that will still, beg consideration is, whether he continues to be a shareholder or not. Because, CIFL shareholding.
Mr. Shah, sorry for the interruption, though usually I should not, but
No,
I have to make. We are concentrating or really squeezing the entire zone of consideration on an application for recalling that particular order or a judgment. The applicant therein has disclosed certain facts. According to him, those facts really lead to a fraud having committed from the ends of the contesting the respondents therein. And therefore, this order should be recalled. Now, the only question is whether there has been a fraud or whether there has been any error which is there, which needs to be corrected, which needs to be absolutely recalled, and then the court. So we are on that stage. So far as the locus standi is concerned, definitely there is already a judgment which is there, and for which this judgment is sought to recall. So one has to understand in that perspective whether there is any justification, there is any ground to recall. We wanted to hear that only. We are aware, we have already held.
May I just take 2 more minutes of your lordship's time on that?
Yes.
Now, the entire, if your lordship now goes to paragraph 24 or 25 of the judgment. Your lordship will, kindly see, my learned friend's application has 2 prayers. In the first prayer, he says, that he asks for recall. Prayer A at page 36, he asks for recall. The second prayer is in the alternative. I'll come to the second prayer.
Yes.
Page 81. Now, he asks for recall, of the entire order. Not, of paragraph, 25 of this order. He asks for the recall of the entire order. In the alternative prayer, which is prayer B, perhaps, he is trying to cushion it by saying In the alternative, you just correct a portion of this order.
Yes.
Now, my lord, if he asks for recall of the order, my lord, on which, my lord, your lordship has held, my lord, that the contempt, my lord, does not lie, then, my lord, the test in my very respectful submission would be whether, my lord, if this order or is this correction that he wants, if it is corrected, whether, my lord, the effect of that is that, my lord, the contempt would become maintainable, or, my lord, the contempt, my lord, would, my lord, become punishable, or, my lord, would be entertainable, or, my lord, notice would be issued, my lord, which.
No. It will be only thing is that whether this particular observations for which the recalling application has been founded upon is of such
Magnitude. I'm grateful.
magnitude
Your lordship putting in much better than
that if it is taken off from the record, whether it will
Yes. Or
I would
corrected.
say it will
nullify the entire
not-
order.
it will not permit the other portion of the orders to
To survive.
stand on its own.
Lordship, that is exactly what I'm trying to say. Now, my lord, if your lordship, therefore, my lord, for the time
These
being,
are the true prayers.
my lord, therefore, if your lordship for the time being, my lord, proceeds as if paragraph 25 is not there. For the time being, my lord, proceed as if paragraph 25 is not there, and kindly see whether, my lord, that order, my lord, would still, my lord, stand or would fall if paragraph 25 is not there. My lord, this is, my lord, the only test, my lord, which I wanted, my lord, to place before your lordship. If your lordship comes to a finding that if paragraph 25 is amended or changed or modified as Mr. Khosla would like it to be, and that effect would be, my lord, to, my lord, allow the application, and your lordship's order would have to be, my lord, overhauled in that sense, then, my lord, of course. If not, the question is, my lord, correction of records, then I'll come to prayer B. Now, my lord, if your lordship will permit me, my lord, I will, my lord, show to your lordship by referring to a few portions of the judgment, which I will do so, my lord, very quickly, that, my lord, your lordship has held that the application is not maintainable on various grounds. On various grounds. Now, my lord, in this regard, kindly, my lord, permit me to quickly point out, my lord, just a few paragraphs. My
Because
lord,
I tell
kindly,
you, because Mr. Senior Saha has argued in tune with Mr.
Kaur.
He says that if you read this paragraph 25, it does not really say that the court has really arrived at the very conclusive finding, because the entire sentence, the entire paragraph, if it is read together, it was simply a reflection of what perceived in course of the proceedings, nothing more than that.
My
Their
lord,
contention. Your contention is that even if it is taken that it is wrong and taken off from the record, yet it does not really affect the main
affect the order.
judgment
I'm so
or
grateful.
the ultimate conclusion.
That is the only thing that I want to show.
No need to argue.
So, my lord, your
No need
lordship,
to argue. We'll consider that.
my lord, may I just give your lordship the paragraph numbers where I will show to your lordship that, my lord, dehorse paragraph 25. The order has
Yes.
been.
Your senior Mr. Saha has taken us to the several paragraphs later on.
Your lordship,
Where
just take a note of it.
Everything has been.
Kindly just make a note of the paragraphs which I want to rely upon.
It is
My lord,
paragraph, I am telling you, paragraph 26, the latter part at
Yes,
page
yes.
106.
Yes,
Then paragraph 27 at 107.
yes.
And these are the two
Also
paragraphs which
28.
has.
Also 28.
Now, 28, he says about the fraud. So he says that element of fraud is a different, there it has been argued. But this paragraph 25 has to be read along with 26 and 27, which cannot be read in isolation thereof.
No, my lord, may I in that case just take you to 28, my lord, and give your lordship, my lord,
That's
what
the
my
fraud.
perspective. Yes, just take 28.
Yes.
26, 27 has already been placed, so I don't want to, my lord, again take your lordship. 28, a plea of fraud is also taken in the contempt petition that the parties have fraudulently acted before the NCLT as well as the Supreme Court and obtained orders therefrom. We are not unmindful of the settled proposition of law that fraud unravels all action, yet the particulars of the fraud is yet to be spelled out with precision and
It should be
clarity.
precision.
So, my lord, precision, yes, with precision and clarity.
Wrongly, perception has gone wrongly. We overlooked, both of us.
The perception of the precision, my lord, is also.
Precision. It's a precision.
A beneficiary of the fraudulent act cannot reap the benefits therefrom, but equally, unless the court finds with reasonable doubt that the fraud has been committed, it would not be proper at the nebulous stage to initiate contempt proceedings and punish a person. In whatever way we peruse the pleadings of the contempt application, we do not find that it is a fit case to admit the motion. So and so. So, my lord, 28, paragraph 28, my lord, I am relying on it because, my lord, your lordship says, my lord, fraud is also, my lord, the ground, my lord, that has been taken here. He's saying the same thing. And, my lord, this same contention about fraud.
Here, his argument, if I correctly understood, was his argument is a fraud in relation to certain statement which is reflected in paragraph 24 or 25. He says that is an element of fraud.
My lord, may I only say this?
He does not say about the whole incident. He says
only that line, those two lines. Those two lines in
that
paragraph
is what
25.
he says is a fraud.
Now, my lord, may I just borrow the principle that your lordships have enunciated in paragraph 28? Your lordships have said that, my lord, mere allegation of fraud. Now, my lord, these things are not good enough. Particulars of fraud have to be stated.
Under code of civil procedure also.
Civil procedure code, civil procedure code, the law is, my lord, very clear on this, and that is what your lordship has laid down. That, my lord, particulars of fraud have to be given, and, my lord, there must be a conclusive thing of fraud. Now, my lord, what is, my lord, at best, my lord, what has happened here? That, my lord, your lordship, my lord, has made an incorrect recording. Perhaps that's what he's suggesting. Of fraud, my lord, I don't know, my lord, how he wants to carry forward this case. But here my submission will again be that, my lord, particulars of fraud have to be pleaded in that regard. My lord, instance of the fraud, my lord, these, my lord, particulars have all to be provided. So, my lord, paragraph 28, I'm also relying upon. So, my lord, on a collective reading of these paragraphs, my submission is, my lord, that, my lord, the order that your lordship has passed on 13th March survives the horse paragraph 25. Then, my lord, kindly permit me one more minute, my lord. I know your lordship is, my lord, kindly take paragraph 25 once more. Just, my lord, 1 or 2 more minutes, my lord. Kindly take paragraph 25 once more. My lord, your lordship will kindly see. It's at internal page 19.
No, I have seen. Yes. In the interregnum, the resolution plan
would reveal that the said aforesaid pipeline was always intended to be a property of the respondent number 34, and after the approval of the resolution plan, recognizing the alleged contemnor number 34 as the successful resolution plan applicant, no further deliberation is required thereupon, as the order approving the resolution plan was affirmed up to the Supreme Court, and therefore whatever has been expressly provided therein binds the parties. My lord, really speaking, my lord, what your lordships, my lord, were observing, that once something has been settled by the Supreme Court, nobody else has the right to touch it. Your lordship, my lord, has not, my lord, for even once, and I don't think, my lord, that was your lordship's intention, or, my lord, that is what is reflected in the order, to, my lord, define, my lord, who owns the pipeline, whether, my lord, A owns it, or B owns it, or Ram owns it, or Sham owns it. Your lordships, my lord, paragraph 25, your lordship's order is relevant, my lord, only insofar as the last 3 lines are concerned, where your lordships emphasize that since this has received whatever is there before the Supreme Court, your lordship is not interpreting or modifying or correcting the Supreme Court order or the orders passed by any other court or tribunal. So what your lordship has really tried to say in paragraph 25 is that, my lord, this particular plan has received the imprimatur, my lord, of the Supreme Court, and therefore it is binding on everyone, and therefore you cannot, my lord, say that it's contemptuous. The alleged acts are contemptuous. My lord, what is being done over here is, my lord, the previous portion, which really formed, my lord, by way of background or preface, my lord, of what your lordship really wanted to say, that is being latched on, and your lordship is now, my lord, being called upon to give, my lord, an interpretation to, my lord, who, my lord, actually owns the pipeline, which was never your lordship's, my lord, intention. And which is not, my lord, with the deepest of respect, my lord, what the judgment, my lord, intended to say. Now, my lord, it is, my lord, only on these 2 lines that this entire, my lord, fight, my lord, has been restarted. Saying, my lord, there is fraud, it's been wrongly recorded, we've led your lordships down the garden path. My lord, my lord, if you're even, my lord, may I go to this extent? My lord, even if your lordship deletes paragraph 25 or these 2 lines in paragraph 25, my lord, it does not, my lord, touch the order in any manner whatsoever. And if it does not touch, my lord, then what recalling is my learned friend asking for? Last point, my lord, is, my lord, he says that under 215 as a court of record, you can, if you find something wrong, you can correct it. My lord, very basic submission to make here. My lord, your lordship, my lord, were never intended, my lord, to, my lord, read the Supreme Court order and to, my lord, find out, my lord, who, my lord, actually owns the pipeline. So, my lord, if he says that, my lord, there is a wrong recording, then that, my lord, must be ex facie. It must be an error apparent on the face without having to look at or refer to any other document. If it is one such case where, my lord, it is glaring that, my lord, there is a mistake. In that case, my lord, your lordship's powers, my lord, under 215 can perhaps be invoked.
Yes.
And your lordship may be asked, my lord, to, my lord, suo moto, that these are, my lord, the terms that he has used, my lord, in his prayer portion, suo moto corrected. But, my lord, not when your lordship, my lord, is being called upon to, my lord, look at the Supreme Court order, actually who did it, who correctly, who said wrongly, which wrong statement was it. Nothing. My lord, it is the Supreme Court order records, my lord, that, my lord, the pipeline is owned, my lord, by the KMDA. Let it be so, because it's never been, my lord, there was never any proceeding before your lordship for your lordship to decide, my lord, who the pipeline belongs to. And this has been latched on, my lord. Your lordship is seeing, my lord, if my friend is approaching every court. My lord, my senior Mr. Shah has already read out that portion, and there is a repeated attempt, my lord, to reopen the same question. And here, my lord, that, my lord, reopening has been resorted to by latching on to these two lines of your lordship's order. My lord, these are my respectful.
Thank you.
For your lordship, rise, my lord.
And my lord, 12. Can I come back with some other?
No. Because the difficulty is because this pen should not be available and
For this, my lord, because I have to serve a claim, my lord, settled by me. It's an assigned matter before a division, my lord, which is, my lord, fixed. Your lordship is.
you do it and then come back.
My lord, his application I have surrendered. That is, record my submission and delete him if he wants. I have no difficulty. My contesting does not matter. It's your lordship's decision.
Which one?
SIFL.
At whose behest?
Administrator of my lord, say infrastructure.
Okay. So he says that he surrenders that yes, he's.
So long as my objections are captured in the order, my lord, because
No.
No.
Mr.
My lord, my argument may be, my lord,
No,
let me
no,
put it this way.
No. Then let us decide on a judicial side.
All I'm asking.
Problem is concession must be unconditional.
My concession is
condition-
unconditional,
Yes.
that I have given my reasons for not opposing him. Just please capture my reasons in the order. That is not a condition, my lord. I have stated that.
So explanation is.
Anyhow, he wanted his submission to be recorded and concession to be done so that your
Exactly.
application is
I have
allowed.
no difficulty.
He says he concedes that he cannot.
No.
This is a
I do not concede anything, my lord. I am conceding that I am not opposing his seeking dropping,
That's all.
provided my objections are captured in the order.
No. Only thing is submission is recorded and then he concedes that he is not opposing the prayer. The application be allowed
In this
and the
matter.
name be deleted.
Yes, my lord.
That's
Lord,
all.
My lord, because of what have been happening, these arguments, please direct for FMAT to be listed after lunch, my lord. This has to stop.
What? No,
What they are arguing.
What
It doesn't matter who the owner of the pipeline. We are trying to get the pipeline decided in the contempt matter. My lord, it's not a 25-foot pipe. It's a 253-kilometer pipeline worth 7,000 crore.
We have been hearing for a long time. Let us see, because the
So kindly
constitution
direct the
is there.
FMAT to be listed.
Let us see, Mr.
My lord, the
don't worry.
FMAT need not be heard.
We will not record any our findings to that effect. Only thing is, we will record that he concedes the prayer of your application. He further submits this. We will say straight away that we are not going into that particular the thing what he has submitted, since he has not opposed the prayer. The application is
Without prejudice to any of my rights and contention and my submit that. My lord, we're not seeking, my lord, other than we have to
Let us come
adjudicate.
at 2 p.m. Let us see what.
My lord, the FMAT may please be called for after lunch.
Yes. No. Let us come after that.
Grateful.
2 p.m.
Right.
they're supposed to come. Item 80 today, my lord. They have
Stand on the NTPC, another code already prefixed matter has been 2 p.m.
Which-
Keep the matter tomorrow that it will.
First matter,
Yes, madam.
tomorrow first matter.
I will get.
Yes. Yes. Yes,
But I'm being led by Mr. Surajit Mitra, my lord.
please, let him. Yes, you are in reply. You are in reply.
To him, my lord, or oh, the main matter. Very good.
Lord, we'll make submissions after the.
Yes.
So the transcript of what was argued on the last date of hearing. We have faithfully checked it, my lords, and if your lordship desires, we can even place it on affidavit. Your copy. You don't need.
Lord, I think, my lord, copies are being handed over, my lord.
Exit. Why do you need?
Transcription
Nothing to do
of
with
the
this
argument which is advanced. We have taken note of it.
My lord.
I can share with
My lord, submissions of other side counsel being recorded and my lord,
I do not
those-
know.
I don't think, my lord, this has happened in our
modern age,
court,
my
my
lord.
lord.
Modern age.
In our high court, I don't think this has
Modern age, my
happened.
lord. Even Rwanda.
Oh, now, Mr. Khosla, I must remind you, we have a disclaimer.
Yes, I'll read out the disclaimer, my lords. Just if your lordship will just allow me, I'll just read it out.
Hey, no, it will come in the, hey,
My lord, now
it will come immediately. Look, pick it, yes, disclaimer has come.
Well, for their benefit, I will just repeat in case they would like to.
Yes.
Malod, respectfully, the focus is being lost by the other side who are trying to argue the merits of the contempt. I am not on the merits of the contempt. I am on the merits of the recall. If my recall is dismissed, well and good. But if the recall is allowed, does not mean automatically that they are guilty of contempt, that they're convicted of contempt. All it means is the CPAN 922 will be considered on merits. And it may very well be that after considering on merits, maybe CPAN 922 will be dismissed again.
Yes.
Secondly, my lord, false statements have been made here to yesterday and today. I mean, last time and today. The relevance of what I'm saying is, my lord, that because just as I have the right, I'll go into locus later, I have the right to seek recall of the 13th March judgment. I would also have the right to seek recall of any order dismissing my application for recall if that dismissal was obtained by fraud.
Yes.
Thirdly, my lord, I have the right to also file a fresh recall or an additional recall for 13th March if any additional grounds have been uncovered since the date of filing of the last application or in the nature of an additional affidavit. The
Yes.
point I'm trying to come to, my lord, is that if your lordship would like to give a quietus to this matter, a permanent quietus,
Yes.
my lord, let it be on first principles of adjudication, which is I assert, he rebuts, I rejoin, we argue, your lordships consider all facts, argued orally and on affidavit, and pass a reasoned judgment, which may be good, which may be bad, whatever. Right now, my lord, the whole problem has got created because they were able to convince your lordships that they don't need to file an affidavit in opposition to the contempt petition, as a result of which I think, 14 hours of arguments were heard on the CPAN, oral arguments. And then in the recall again, though they took time, they obstructed disposal of the recall on the date of listing by saying, no, we want to file an affidavit. 1.5 months were lost. Then they came back and said, no, we don't want to file an affidavit. And therefore, none of the assertions were rebutted. But in oral argument, my lord, and I will show from the transcription, numerous contradictions to fact have been asserted. Now, my lords, if my lord may kindly have my written submission. I will skip or rather just summarize point one, my lord. It's just that, they keep on harping that they will not re-argue, but everyone has been re-arguing the same point and again, which has been argued by the other learned counsel already. But what they omit to deal with, my lords, which is very important, my recall had two prayers. Prayer A was fraud has been played, so recall the order. That they've dealt with in extenso, but in triple extenso, they've dealt with the merits of the contempt. I think the rationale is that if we convince your lordships that no contempt was committed, then even if there was fraud, even if para 25 is deleted, that's the argument. What changes? In any case, there is no contempt maintainable. I don't think, my lord, that's a fair approach. Because if A has stabbed B in the abdomen and a medical report has been produced certifying the injuries on the body, including the head, the neck, and the stomach, and the groin. And on the page relating to the injury on the stomach, they have evidence that the doctor was bribed to exaggerate the report. So now the accused says, just remove page 19 from the report. And now acquit me. Well, Lord, I don't think that's how it works, because para 25 is the foundation of your lordship's view as to whether or not the pipeline is SR's and therefore no contempt has been committed. It's another matter, my lords, that there was, if I may say this with the utmost of respect, a fallacy in the approach or the yardstick adopted. Because the first thing required to be settled by your lordships while dismissing CPAN, I'm not entering into the merits, it's linked to the recall, was what is the meaning of the status quo? Because if the meaning of the status quo was that the pipeline will remain with SR, then the fact that the resolution plan made an express provision or by implication that the pipeline belongs to SR is contempt. And that was the key point in CPAN. In other words, my lord, it is secondary to analyze whether the resolution plan had a provision for the pipeline to be part of SR's estate or not. The first question was, what is the injunction? Good, bad, ugly. What is the injunction? Because today a lot has been said about the injunction. Perhaps they are trying to pave the way for a foundation that, assuming the recall is allowed and the CPAN is taken up, the next defense will be there is no content because I didn't understand the injunction. So a lot has been argued, my lord, that the injunction is that since the cancellation deed was 24th June and the injunction, and which went into effect on 30th June 2016, since the injunction is dated 22nd December 16, it meant a blessing that yes, pipeline has been transferred, but don't transfer it further. Preposterous. Preposterous. It is almost as if SR was the plaintiff. You need to say something? Okay. I'm just being polite to my younger friend, my lord, if he wants to say something. So, my lord, it's my humble submission, and which is what I made in representation to your lordships on the administrative side by email. My lord, I made a representation to your lordships on the administrative side after the last hearing. That email was not placed before your lordships? Oh. It was only a reiteration of my request made in the last hearing, my lords, that please have FMAT 13/10/2016, the CAN 7 in that, which is listed for clarification.
When a matter is taken up in a judicial site,
Yes, my lord.
what is the occasion to send an email
I'll answer, my
on,
lord.
on an administrative site?
I'll answer, my lords.
The council can make a prayer for whatever they wanted, and it is the court whether to consider or not to consider. The court has to take a
I
decision.
respect that, my lord, but
Why the emails and the correspondences are made on the administrative side?
my lord, if I were in Calcutta, the next morning I would have come to make a mention in the morning. Number one. Number two, they were kept in copy.
But you have the advocate and record who is there in Calcutta itself.
My lord, he is in this, the AOR, my lord, is currently in Delhi. So
I do
that
not
is
know
what
whether
the-
he's a practitioner here or he's not a practitioner here.
my lord, could I make a submission, my lord? The most archaic procedures are in the Honorable Chartered High Courts. And it is for the reason that they're the oldest Honorable High Courts. My lord, just as the law evolves, just as the interpretation of the same law evolves, my lord, rules also need to progress into modern times. I committed no
sir,
transgression.
There are committees in place. There is a rule committee who is taking care of whatever is felt by the court that some amendments, some reforms has to be made. That is the separate issue that will take care of this. But that does not mean that a litigant will not follow the statutory provisions.
This is not a
because the
statutory
rules-
provision, my lord,
Yes,
that
yes, 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 yes.
administrative mention cannot be made in writing.
No,
Day in, day out, my lord,
No,
representation.
I'm on that. I'm not on that. Because you said when you reacted to it that there are archaic rules in the chartered high courts which are still prevalent. For that, I reacted. And I said that no, there is a rule committee who's taking care of that. As and when the occasion arises, rule committee suggests certain amendments and certain amendments are brought. There is no difficulty in this regard. But when a judicial matter is already there, and if I correctly remember, you mentioned on the other day that this FMET has to be there. Then we say that we will concentrate on a recalling first. We will decide the recall application, and thereafter we'll consider if there is another proceeding. We'll take care of that.
My lord, I'll
We'll
explain.
hear out.
Well, I'll explain. what happened.
But that does not mean that the emails are being sent in an administrative side to do it. What we'll do?
May I
It's a
explain?
judicial matter.
May I explain, my lord?
The court,
When the
the court
transcript
will
was-
accept the prayer made at the bar, or the court may not accept the prayer made at the bar. I'm conscious when I make these statements because I have seen that my reactions sometimes is also reflected in this transcription.
We just tried, my lord, because we did not want to give a select extract. And your lordships
No,
are
they-
not
they-
bound
no.
by any observation
No.
made during the hearing. Please, this is my clear understanding of the live streaming. Your
Because-
lordships are merely
because-
engaging in a dialogue with councils
That's
to
all.
get the whole
This is
truth.
merely just to understand the issue, just to understand the position of law, just to understand the fact. This is only interaction in that regard, nothing. Ultimate decision is taken in the form of a judgment and an order and signed by the judge.
I do not think that we have committed any transgression. Rather, we try to assist your lordship so that there's no
But
select
why-
extract.
why mentioning on the administrative side?
I'll answer, my lord. When we re-saw that YouTube video and this transcript was prepared, we realized that there is repeated assertion by Mr. Sudipto Sarkar that day as to what is the meaning of the status quo. So then that brought us to the realization that unless that foundational issue is settled, what are we arguing?
That you can come and argue and mention the matter in a judicial side before the court and then ask that please consider this FMAT first before you proceed to decide the recall. I believe that on one day you mentioned it,
I
you
did.
want it. And then we said, no, we will go by this application first, we'll decide it. And thereafter, if the matter is pending, we'll consider and then dispose of that matter.
That is
also.
what is I am trying to say, my lord. After the hearing, when we read the transcript, we realized that there is repeated reliance by learned counsels.
You could have come and mentioned the matter before.
Lord, but if I come, then they oppose. No, it's not listed in the cause
So,
list today. It cannot be taken up
question
today.
is,
All sorts
then
of
what
obstructions.
for the courts are there? Somebody will assert, somebody will deny, and then the court has to decide.
My lord,
So they may, even if they oppose it, it is not binding on the judge. That if the judge feels that the matter should be listed, the judge will pass an order that
Lord,
matter to be
in my
listed.
defense, I did mention this morning again, my lords.
Again, we are repeating that we wanted because this application has to be disposed of first. FMAT is there. We will definitely take care of that. If the determination is still with us, we can definitely take that matter. And we have already made a substantial hearing on these applications.
That is
So
correct,
they
my
never
lord.
decided why
The
why
reason,
postponing the disposal of this application.
because, my lord, if your lordships has not taken a view, what is your injunction? Then what are we? In fact, my lord, your lordships has passed certain observations in the judgment under recall, which are tantamount to settling the suit. My lord, the suit is SIFL versus Hon'ble and SR, which says, please declare that the cancellation deed has not gone into effect and a status quo was granted. Now, if your lordships are of the opinion, my lord, please bear with me. This is a very important statement I'm going to make. If your lordships today, rightly or wrongly, misled or erroneously, are of the view that if the plan included the pipeline, so what? That means there is no injunction in force, because if the injunction was in force, your lordship's High Court's own judgment by the division bench, Sujit Pal, which has been acted upon by the Supreme Court in the judgment DDA versus Skipper Construction, that fruits of contempt, that has no meaning. Anyone can violate an injunction, and if it is encompassed, the violation, if it is encompassed in another proceeding, which has gone to the Supreme Court, goodbye to the injunction. That is what your lordship judgment means. So therefore, that again, that error has arisen.
So it is an error or it is a erroneous finding. There is a distinction in between an error.
It is an error
Let us
because
see. So then you'll have to come under the review.
may I explain why I do not need to come into review? It is actually a per incurium of a court of its own earlier order. My lord, firstly, may I make another suggestion, my lord? If we are dealing with an offense against justice, if it is my humble, respectful submission that all procedural formalities are required to be put into a gunny bag and thrown out the window, because it is your lordship's dignity at stake. And your lordship's dignity arises from your authority. It's not that the authority arises from the dignity, because your lordship do not have any special dignity that your lordships are blessed with, either born or an appointment. Your lordship dignity flows from your authority. So if your lordship's authority is flouted, where is the dignity? I'm answering the question, should it be reviewed? Should it be recalled? Should it be ex debito justitiae? Should it be a letter sent to the residents? Should it be a TV interview that someone gives to a television? It doesn't matter. If your lordship's dignity has been flouted, no procedural issue comes in the way of your lordship's using a hot knife, cutting through butter and come into the core of the issue. And the core of the issue, my lord, is this. What was the injunction? Has it been violated? If so, contempt. What are the consequences of contempt? Supreme Court will see, NCLT will see, Sialda suit will see, whatever. But it's your lordship's dignity that your lordship would be required to protect. Because if your lordship's authority keeps on being flouted, then what is the purpose of having court hearings from 10:30 a.m. to 4:15 p.m. if your lordship will keep passing out orders that people will keep on flouting and nothing will happen with a procedural problem A, procedural problem B, procedural problem C? So that's why, my lord, I was respectfully urging, I'm not saying your lordship heard FMAT first. Lordship may take Can 10 to its conclusion, but don't pass orders. Pass orders together. That way, your lordship will ensure that your lordship's order, whether we like it or whether we don't like it, at least there won't be an error in the order. Let me give an example, my lord. Today, your lordships are guided by your earlier judgment, barring whatever flaws I point out, which, as your lordship has pointed out, don't go into arena, the pool of review, stick to recall. So your lordships have taken view that basically pipeline included in resolution plan, so what? That means that your lordships are either defying Sujit Pal, or your lordships sub silentio are viewing the injunction to mean that the pipeline has gone to SR on 30th June 2016, but no further alienation. So the resolution plan has provided for the pipeline to be part of SR. So what? But again, I come back to the issue that this will depend upon your lordship's view as to what was your own injunction. And I'm saying this categorically, my lord. If your lordships will dispose of Can 7 in the FMAT by holding that the injunction was pipeline has been transferred to SR with effect from 30th June 2016 by virtue of the cancellation deed 24 June 16 and no further alienation transfer, contempt will not lie. But that view, my lord, is different from the view accepted by NCLT, and which I will read out, that order of 7th February 2018, where NCLT has interpreted your lordship's order, which is not to say that NCLT's interpretation binds your lordship. Not at all. Maybe NCLT has misinterpreted your lordship's injunction. But no one has challenged that order of NCLT. No one has come back to your lordship to say, please clarify the injunction, because NCLT has misinterpreted your injunction. NCLT has viewed your injunction to mean that the pipeline is an asset of Hon'ble, whereas your lordship's injunction clearly meant that because the cancellation deed has gone into effect with effect from 30th June 2016 and the injunction is 22nd December 2016, therefore the injunction means that the pipeline will be with SR, but not to be further alienated transferred. Nobody came back to your lordship. So, my lord, what clearly follows from that is that they accepted the interpretation drawn by Honorable NCLT by its order of 7th February 18, and which I will read out, my lord. I assure your lordship, it will shock your conscience as to what was argued on the last date of hearing and today. That is why now we are moving contempt before Honorable NCLT as well. So, my lord, just to conclude this issue, if your lordship will please hear arguments on Can 10, no difficulty, without break, but please don't pronounce orders till you decide Can 7 in FMAT 1310.
That we will take a decision. That will take a decision. Yes.
My lord, please apply, my lord, simple logic to ensure that whatever order, because whatever order your lordship passes here in Can 10 will practically dictate Can 7 in FMAT 1310. Whereas it should be the other way around. The view in the FMAT on the injunction should guide the contempt. Otherwise, this is a classic case, my lord, of the tail wagging the dog. Or Mr. Joydeep Kaur's cart before the horse. So that's my humble request, my lord. Please decide FMAT 1310 in conjunction with this Can. So, my lord, they have all focused on prayer A, where we said that a fraud was played upon the court to induce it to believe that there was an express provision in the plan when there was not, and we stand by that. No one has shown what was the source of information of this honorable court to lead it to observe in para 25 of its order that where is this express provision in the plan? Because for the simple reason, the plan was not on the record of this honorable court. But no difficulty, sources can be multiple. Please then point out what other document led to the conclusion of the court. Or please own up and admit, like Mr. Dwipan Basu admitted on 16th of July, that yes, a statement was made at the bar, but it was corroborated by the compilation given.
There was no admission from my end.
YouTube video shows.
Yes, kindly show.
Yeah,
There is a
please see
categorical
it.
admission from my end, please.
Okay, let me put it this way. There was an observation made by your lordships.
Don't change your stance. You right now said something.
Let me rephrase. I'm not amending my stance. Let me rephrase my stance so that you also get it. There was an observation by this honorable court that in these words, that if my memory serves me correctly, a statement was made at the bar, and Mr. Dwipan Basu only grinned and kind of nodded. According to me, my lord, that is an admission. Sub silentio. According to me. Maybe not according to him.
Yes, yes.
Then, my lords, I've handed over this transcription. Now, please see point 2. I marked out 7 portions of this transcription, which are, if I may respectfully submit, my lord, objectionable. They're contrary to record, they're contrary to order, they're contrary to pleadings, they're contrary to documentation, etc. Firstly, my lord, he assures, my lord, kindly have serial number 3 at the bottom. He assures your lordship where he says, that is my lord, that's the prayer that he has made, and the alternative that he has given comes later. He does not deal with the second prayer at all, because it is impossible to deal with. May I show your lordship prayer B, just to refresh your lordship's memory and put it in context?
What?
May I show your lordships the prayer B?
Yes, we have seen that.
No, just to refresh your lordship's
Yes,
memory,
yes,
because everybody
Yes, yes.
except Mr. Joy Saha has skirted that issue, and in Mr. Joy Saha has skirted that issue on merits. He's only raised it in context of locus standi under Article 215. But he's not gone into the prayer. Can you have the prayer for a moment, my lord?
Page 81.
Yes, my lord. And I invite them, my lord, that even if now they want to say something, they're most welcome. I can sit down and they can have their say. My lord, it says in the alternative, means it's a parallel prayer. It's not a subordinate prayer. First prayer is, fraud was played. Please acknowledge the fraud. Recall the judgment. And this business of deleting para 25, my lord, is nonsensical, because just because paras 1 to 24 come before para 25, but the entire theme of para 1 to 24 is based on the observation in para 25 that there was an express provision in the resolution plan, and therefore, and I concede this, my lord, if there was an express provision in the resolution plan that the pipeline is part of SR Steel, because the resolution plan has been blessed by NCLT, NCLAT, and Supreme Court, it binds everybody.
Will the nonsensical word is a good word for that?
Beg your pardon?
You use the word nonsensical. Is it
May I just have the full sentence, my lord?
good spirit?
May I just have the full sentence, my lord, just to refresh exactly
No,
what I
I
said?
have.
No, the full sentence of what I
I
used.
have seen. I have read. There is already there. I have also heard it.
No, I'm not denying. I'm just saying, my lord, the complete context. Did I say the nonsensical arguments?
No.
So you
referred to paragraph 25.
With your friends after the hearing.
You were referring paragraph 25.
Big one?
You were referring paragraph 25 as a nonsensical.
No, 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 no. I'm so sorry, my lord. Then you can replay the YouTube video. I would never use that kind of language for an order of the court.
Yes.
I said the argument.
Okay.
I'll repeat again, my lord. I said that even if para 25 is deleted from the judgment, to say that then the order will stand on its own legs is a nonsensical argument, because the entire theme of paras 1 to 24 is constructed on the view adopted by this honorable court in para 25, that the plan has an express provision that the pipeline belongs to SR. And my lord, with due respect, I reiterate that it's a nonsensical, abusive, contemptuous argument.
Yes. You want more?
Could I have the
Cold.
fan off, my lord? I mean, it'll
Oh,
be a little.
I just thought that you want more cool air.
Papers keep flying, my lord. So
I thought the cool air you
it'll be
want.
hotter, but it's a hot
Hey,
argument.
পাখাটা বন্ধ করে দাও।
And your lordship may note, my lord, Mr. Sarkar never reverted. Mr. Joydeep's car did not even come close to prayer B. Mr. Joy Saha touched it peripherally, but only touched it peripherally to say that yes, if there is an error apparent on the record, then Article 215, perhaps, also he qualified it. He didn't admit. Perhaps, meaning in a given case, maybe no locus standi may be necessary. But he did not address prayer B. So, my lord, prayer B says, in the alternative, acting suo motu, and in alignment with the views of the Honorable Supreme Court expressed in the state of Bihar versus Bharat Coking Coal, discharge his duty as a court of record under Article 215 to maintain, my lord, that's a typo, not to main, but maintain.
Is maintain correct and
maintain
accurate
correct
record.
and accurate records, and thereby include in the body of the judgment dated 13th March 23 a reference to the document on the record of this court. My lord, please see our fairness. We are not putting this court in the corner because your lordship has said expressly provided in the resolution plan. I'm not saying please show where it is in the plan. I'm saying any document.
Yes.
A reference to the document on the record of this honorable court with this page para number that reveals, as held by this honorable court at page 19, para 24, my lord, this is a typo, para 25 of the aforesaid judgment, that the resolution plan filed by AMIPL in, my lord, would your lordship just correct that, my lord? I use a dictation software. So we programmed that if I say AMPL, it will type AMIPL. But if I don't say AMPL clearly enough, it takes it as ample and it types it as AMPLE. But that's AMIPL, my lords. Resolution plan filed by AMIPL in October 2018 for SL has expressly provided that the pipeline was part of the property of respondent number 34. No one has touched this prayer, my lords. And if your lordship is not inclined to recall the order, whether for technical reasons or on merits, I have no difficulty. Your lordship will just, because my lord, if I go and appeal, what can I appeal?
Yes.
It's a finding of fact that is expressly provided. It's like defamation, my lord. If a trial is being held that Ramlal made abusive words to Shamlal, so I'm summoning him. Now, Shamlal can't appeal that order because unless the words are reproduced, that what did Ramlal say? What is the argument in appeal? No argument. Same way, my appeal will rest on the premise that this honorable court committed an error. So the Supreme Court will say, well, which is the document which according to you does not contain but the High Court said it contains? I say, my lord, I do not know. They say, you go back to the High Court. Ask the High Court, which is the document which had an express provision. So I come back to square one. So, my lord, prayer B is very important. Nobody has touched it. So, your lordship may please kindly bear that in mind, my lord. Then, my lord, this is very interesting. Please see. Serial number 21, but kindly come to page 7. It's a long serial number, my lords. Serial number 7 of the transcript, my lord. Sorry, transcript. Here, my lord, Mr. Sarkar, who was appearing for Hon'ble. Please note that, my lord, this suit, my lord, please consider this. The suit is SIFL versus Hon'ble and SL. but the entire benefit of the suit was for Hon'ble, defendant 1, and indirect derived benefit for the plaintiff, SIFL, as a lender cum shareholder of Hon'ble. And Mr. Sarkar has said, so if your lordship says, if he said that it is the property of Hon'ble, that is also correct. My lord, right on top, page 7. Right on top. So, if your lordship says, if he said that it is the property of Hon'ble, that is also correct. So, learned senior counsel for Hon'ble, and my lord, verifiable from YouTube because this transcript has been checked 7 times by 3 different people. So, lordship can verify. This is a statement made. Hon'ble's lawyer says it is correct to say that the pipeline is of Hon'ble. That being so, my lord, fraud was played, recall lies. It's an admission. Then, my lord, please note another interesting submission, which again proves that fraud was played and recall lies by Mr. Sarkar. I'm on Mr. Sarkar right now. He says, he admits that there is no express provision in the resolution plan to the effect that the pipeline is an asset of SL. May I show? Same 21, my lord, but towards the bottom. Yes, my lord, page 7. Please come to the bottom 6 statements.
Yes.
Where it starts, when your lordship has passed an order, a reasoned judgment. The judgment is not based on statements from the bar. I'll ignore that. The judgment, my lord, is also not based on the fact that the resolution plan expressly provides. It does not say that it expressly provides that SR is the owner. This is the stand of Hon'ble. And again, my lord, the frustrating circumstance in this particular proceeding is no affidavit in CPAN and no affidavit in CAN 10. Everything arguments against the bar. Thank God today, my lords, we have YouTube. Otherwise, it would be impossible to capture these admissions and then have it corroborated before this court.
Yes.
My lord, strictly speaking, your lordship should direct me to stop here and allow the recall. It's admitted by the key affected party. And please note, my lord, Hon'ble is the owner of SR. Hon'ble is the owner of Hon'ble. So when counsel speaks for Hon'ble, he speaks with the mind of Hon'ble, who is the owner of SL. That's the triangle. Very well. I'll continue further, my lords. Then, my lord, please see the panic. The repeated denial that no statement was made at the bar. I will show your lordships. Kindly come to, my lord, serial number 7. That is page number 2. At the bottom, where that bold line is there, and so and so and so. Then Mr. Sarkar says, there is nothing, my lord, mentioned about any express, my lord, oral assertion or any averment recorded by your lordship. This is correct. Your lordship has not said in para 25 that there was an express provision in the resolution plan in terms of statements made at the bar. Your lordship did not say that. So that's what he's highlighting. But what your lordship did say is that there's an express provision in the resolution plan, and the plan is not on record of this honorable court. So therefore, my lord, what is the source was admitted by Mr. Basu, which of course today he's denying, and which is now being rebutted by Mr. Sarkar repeatedly that there was no statement of the bar. Kindly, my lords, come further. Kindly come to the next page, page 3, where he reads out, I'm on serial number 9. He reads out para 25. In the interagnum, the proceeding before NCLT was initiated and ultimately the resolution plan has been approved and implemented by the parties. The resolution plan would reveal ... He stops there. And then he says, now, this is what your lordship has recorded, my lord. Not any statement. Again, he repeats, there is no statement at the bar. Then, my lords, kindly come to same page 3 in the middle, the highlighted portion. Now, my lord, where is any question, my lord, of any fraud being played upon the court, or my lord, any statement, my lord, being made, my lord, from the bar? My lord, it goes further. It's repeated again and again. Kindly come, my lords. Serial number 21. Please come to page 6. Towards the bottom. The highlighted portion. Now, my lords, the order is very clear. It is not, my lords, that your lordships are relying on some statement made from the bar, recording it, and then saying that for this reason, do not issue notice.
Yes.
Then, my lords, kindly come on page 7, towards the bottom, last 6-7 lines. Again, he says, when your lordship has passed an order, a reasoned judgment, the judgment is not based on statements from the bar. The judgments, my lord, is also not based on the fact that the resolution plan expressly provides, etc. And so on. So, my lord, this now makes the situation even more, shall we say, grave, that if they deny that they made this statement at the bar, and if the resolution plan is not on the record of this honorable court, and if the order dated 7 February 18, which I would just like to read out next, my lord, after I finish these bullet points, then, my lord, how could it transpire that your lordships could be, may I use the word misled, because I do not want to use the word erred. Then how could your lordship be misled? Because the 7th February 2018 order of NCLT, I read out. If your lordship can kindly have.
Hey.
My lord, kindly have annexure 15 in CPAN 922. It has a 7th February. Annexure 15, my lord is, sorry, annexure 15 in CPAN 922. I think it may be in volume 2. Yes. CPAN 922, please have annexure 15, my lord. I don't have the hard copy, but I'll read from my copy, my lord. I will just give my lord the page. I beg your pardon, my lord. My lord, I'll just give it, my lord. But would your lordship be having volume 2, my lord? It will probably be in volume 2. What in this copy also I don't have it.
For referring to order,
7th February 18 order, my lord. All the annexes are chronological. 7th February 2018. Volume. But in my index, it is available. My lord, would there not be a covering index, my lord, giving all the list of annexures on the facing page? On page 2, the internal index may have. Do you have a copy there? My lord, I'll just give my copy. My lord. Or may I give it from the laptop, my lords, and
therefore,
my lord, this is an order of 7th February 18, where the RP of SR Steel filed an application before NCLT that please declare that the pipeline belongs to SR. NCLT rejected that by a 48-page order on 7th February 18, saying nothing doing. There's an injunction by Calcutta High Court. And the meaning of the injunction is this. No, so what I'm, Malod, may I? So CPAN 17 and which is over. I'll just read it out, my lords.
Small application, I was carrying one, carrying so much.
My lord, may I hand over my laptop to your lordships? Or may I read it out? Your lordships have that? Kindly have para 64. The operative portion, my lord, 64 to 81. Para 64, my lord, they try to raise the argument that because the BTA was not accompanied by a conveyance deed, therefore the transfer from SR to Hon'ble of 2015 has not happened. So that argument is rejected. NCLT says clause 4.41 of BTA gives option to the buyer to obtain registered conveyance deed in respect of pipeline if it feels the pipeline is an immovable property. Therefore, it is not open for the applicant, which is the RP of SR, to contend that the pipeline is the property of corporate debtor on the ground that there is no registered conveyance deed. Well, then kindly come to para 68. NCLT lists 4 more objections to the arguments raised by the RP. It rejects them. Then, my lord, kindly come to para 70. It's a one sentence demolishes Mr. Sarkar's stand. May I read para 70, my lords? It is pertinent to mention that the interim order has been passed by Honorable Kolkata High Court restraining unwinding of BTA on the basis of cancellation deed. My lord, now come to para 72. It gets even more clearer. In light of the above facts and in view of interim order passed by Honorable High Court of Kolkata and pendency of civil suit, the applicant cannot claim ownership of pipeline on the basis of cancellation deed, which appears to be ineffective. And it is without the approval of all lenders as required by the loan agreements and the finance documents, which is evident from annual report of the corporate debtor and so and so, so and so, so and so. Then kindly come to the below the note. This is a finding delivered by NCLT and which my learned friends, colleagues at Ahmedabad Bar have argued that this is not a finding, it's a reproduction of a pleading. I mean, this is the depth to which arguments have gone. Then NCLT holds, and my lord, that bold underline is not mine, it's coming from the subsequent order of NCLT. Minutes of the meetings of the lenders to applicant and respondent number 1 also show that there is no approval for rewinding and transfer of business undertaking pipeline from all the lenders, more so from respondent number 2. Respondent number 2, my lord, was IDBI Bank Limited. Therefore, was SRE. Therefore, pipeline remains the property of the respondent number 1. This is a finding, my lord, by a judicial forum. And by the principle of comity of courts, my lord, surely your lordship would not say today that the injunction dated 22nd December 2016 respects the fact that the cancellation deed of 24 June 16 has gone into effect with effect from 30th June 2016, and our injunction was only to prevent further alienation and transfer from SR Steel. In fact, my lord, even that would be contemptuous, because even if that be the my lord, kindly bear with me. We have come, my lord, with a well-rehearsed strategy. CPAN 434 of 2022 is basically for that, because if they say that the cancellation deed went into effect on 30th June 2016 and therefore the pipeline was an asset of SR not to be transferred or alienated further, then why did they alienate to Hon'ble, where Hon'ble resolution plan was filed for 2,453 crores on the basis that the pipeline belongs to Hon'ble? That's an alienation, that's a transfer. So one way or the other, my lord, the goose gets cooked. Either in contempt because they say that the pipeline belongs to SR, or contempt because they say that the pipeline belongs to Hon'ble. That's why I'm again humbly urging your lordships. Please decide CAN 7 in FMAT 1310 either first or concurrently with this recall application. And please note, my lord, no challenge to this 7th February 2018 order by anybody. And nobody came back to the Honorable High Court of Calcutta to say, please see what NCLT is doing. You have upheld that cancellation deed has gone into effect from 30th June. The injunction is 22nd December. Therefore, the pipeline belongs to SR. Please see what NCLT is saying. Please clarify. Nobody came. Today, a battery of counsels without affidavits are saying this, that the cancellation deed has gone into effect. And my lord, may I also say, would your lordships not agree that to assert that the cancellation deed dated 24 June 2016 has gone into effect on 30th June 2016, is it not an assertion of fact? Would your lordship tolerate that assertion of fact made at the bar when there's no affidavit? My lord, hours are being spent by your lordships. For me, it's not a problem. I'm at your lordship's disposal. Hours are being spent by your lordships because the indulgence granted by this honorable court to the opposite party that yes, go on. We give you the liberty to make out your case without affidavits. Otherwise, if they are required to file an affidavit, my lord, the hearing will be 5 minutes per lawyer. So, my lord, may kindly note, my lord, now we moved for contempt of honorable NCLT because now by the statement made at the bar, it's clear that the 7th February 2018 order has been violated by saying that the cancellation deed has gone into effect in direct derogation of the finding cum direction given by honorable NCLT in its order of 7th February 2018. Then, my lord, please come to the next point. There was repeated, if I may be permitted to use the phrase, harping at the bar that your lordship's order never took the view that the pipeline is an asset of SR. It only took the view that it was intended to be the asset of SR. My lord, I don't understand this kind of English. If your lordships are of the view that the resolution plan intended for it to be an asset of SR, then where's the question of your lordship saying there's an express provision that it is an asset of SR? Either one or the other. But this point was pointed out as a defense, actually as a defense. That there's been no transfer. There's a new word used. There's only a technical transfer. My lord, my lord, the Transfer of Property Act does not talk about technical transfers. There's a transfer or there isn't a transfer. This point, my lord, about being intended. Kindly have page 6, my lord, at the bottom. This wonderful new phrase, my lord, which I think constitutes at the very least an intellectual discourse on a new concept being introduced in law. Kindly have page 6 of my transcript. Standard transfers are prohibited, but technical transfer may be allowed. I don't understand what is the technical transfer. Either the property is of SR or it is of Hon'ble. My lord, there's a tax evasion issue here. If the pipeline belongs to Hon'ble, Hon'ble is claiming depreciation and deducting it from its income tax. If the pipeline belongs to SR, SR is claiming depreciation and deducting it from an income tax. And this pipeline, my lord, with the utmost of respect, is not a 25-foot pipeline of 400 rupees. It's a 253-kilometer pipeline of 4,000 crores. The depreciation is 600 crores. The tax saving on that is 200 crores plus every year. I'm sure that your lordship would never permit your lordship's judgment of any nature to become the platform for tax evasion. Then, my lord, repeated hammering was done, if I may be permitted to use the word, that the injunction most important objective of the injunction was to ensure that the right to use remains with SR. My lord, please remember, the plaintiff was not SR. The plaintiff was SIFL, lender to SR, lender to Hon'ble, shareholder in SMITE, or rather contributory in SMITE, which is shareholder in Hon'ble.
Since my learned friend is relying on the order of 7th February 2018, Lord, the subsequent orders he should also, Lord, rely
You
on.
will give me time. I will not do it in your
No,
sequence.
no, you are
I
stopping
I
at-
will not do it in your sequence.
You are stopping at 7th February 2018.
I am not stopping anywhere. You are stopping me.
You're
You're stopping me from making my full presentation.
Lord, entire
Lord,
reply
I
is
am-
not on a new facts.
My lord,
On
with
new-
due respect,
new-
my lord, please ask Mr. Carr to sit down.
Lord,
He's disturbed the court
will-
enough.
I will only.
Please see the transcript. What he's arguing.
I am only, Lord, objecting that
Unfair.
in reply, he is on a different contour altogether.
No, I do not agree, my lord. I am replying to his arguments.
I have never
I-
argued anything.
Not his, the whole team's. My lord, with the utmost of respect, my lord, I cannot argue with a man who's not on affidavit, but who argues facts.
I don't need to
Please.
file an affidavit. For recall.
My lord did not check them, my lord, when they transgress into the merits of the CPAN. My lord, this is not fair, my lord. My lord will say they are arguing whatever, will not check them, though I rose repeatedly. Now I want to rebut everything they've said. My lord, I come. All right. May I assure your lordships this assurance? I will be most considerate of your lordship's dignity. I will protect it to ensure that nobody abuses your lordship's dignity, whether me or they. If that takes some extra time, my lord, then the fault is not of my creation. If someone has, my lord, it is a good move on his part. Now I've forgotten where I was. Intention, yes. Kindly come to the bottom of para 7, my lords, page 7. It was the intention. Then my lord, may I my lord, may I respectfully submit to assert what is the meaning of an order of a court of law is an assertion of fact. It's not an assertion of law. If a man has to say that I interpret this order like X, though the whole world is saying Y, that is not a statement of question of law. He's not reading out an order. Yes, read out an order and keep quiet. But to read it out and then say it means this. Exactly. My lord, may I remind your lordship my opening line that this issue is about your lordship's dignity and authority. Let procedural things be put into a gunny bag and thrown into the hoogly. Who will be rubbing their hands in glee that if this court has no teeth, wonderful. My lord, No, my lord, Mr. Sarkar tried to say, what is the injunction? He tried to say that the purpose of the injunction was to ensure that SR will always have right to use, and it has right to use. So where the offense, where the contempt? My lord, the plaintiff was not SR. The plaintiff was SIFL, who was protesting a transfer from hospital to SR. And your lordship granted protection. My lord, status quo is not that the judges have got off their chair, got into a car, gone to the site, verified what is the situation on the ground, and then say, okay, status quo as of Saturday, 3 p.m., verified. Honorable judges give status quo directions on the basis of the position presented before them, which may be false, which may be true. But if it is true, then the status quo interpretation is not actually what is status quo outside. It is status quo as presented. And if what has been presented is different from what reality outside, then the person injuncted has a right to come and seek vacating of that injunction on the basis of misrepresentation or incomplete facts given to the court. But if the respondent does not come, if the defendant does not come to seek a variation of the injunction, he need not allege wrongdoing. He may only say that the suit was prepared, let's say, in the interior on Wednesday, and by the time it reached Calcutta and was filed on Monday, came up for hearing on Wednesday, there are some additional events that have transpired between Monday and Wednesday, which are not reported in the suit, and which, if they had been reported in the suit, the injunction would have been different. So no problem. He can always seek a variation. But to say that I will interpret the injunction on the basis of my actions, which I didn't reveal to anybody, I kept them hidden, and they were actions committed before the injunction. So now when the injunction comes, it's a pat on my back that my actions, which I suppress from the whole world, have been endorsed by the court, and now the status quo. My lord, law students read books read by Mr. Sarkar. And if this is the interpretation of a status quo, God help all those students, my lord. My lord, please, I mean, because I've been suffering all this, now your lordship will be... It's not a personal attack. It's an attack on the argument, not on the man. I withdraw it, my lords. My lord, has he not attacked your lordships? Has he not insulted your lordship's intelligence by saying that status quo means that whatever was not known to your lordship but was suppressed from the court is status quo? My lord, I have the very high regard for him, and I believe I have a good personal rapport, but this is business. Very well. Are your lordship rising early today, my lords? Oh, okay. All right. I'm so sorry. So, then, my lord, kindly come to page 2 of my written note. I may not need to refer to the transcript again. My lord, they made numerous assertions of fact. I'm on page 2, my lord, para 3. They made numerous assertions of fact, my lord, one of which I just pointed out, that they're saying that the cancellation deed has gone into effect. My lord, they have to be put on affidavit. My lord, with due respect, your lordship may not say, no, I will ignore what they stated if it's on fact. My lord, that is too much indulgence. Let him say it on affidavit so I know who in Hon'ble to prosecute for perjury and have him sent to presidency jail. Because the lawyer will be protected, he say I was acting on instruction. My lord, please pause here, my lord. Since they've gone into facts, the decision of this court cannot simply be to let a wrongdoer go and say, no, he's made 10 statements, 6 are facts, 4 are law. I'll just remove the 6 facts from my memory. They were cautioned not to go into facts. They've gone into facts, they must come on affidavit. Because if this statement comes on affidavit, that the cancellation deed has gone into effect, we will immediately ask suo motu cognizance of perjury because of affidavits filed by Hon'ble on 28th June 2019 in the Sialda court. My lord, so please pause the hearing. My lord. Please tell them to come on affidavit on all the facts asserted by them, and then we go for further hearing. My lord, I am not in a hurry. I want accurate adjudication. I want accurate justice, not hurried justice. So it means after your lordship come back from Jalpaiguri, I have no problem. My lord, but how can they make a certain? My lord, I cautioned them.
Have a nice note.
No, my lord, I heard about Jalpaiguri only in the last state of hearing. That's the first time I got to know that there's a. Very well. Then your lordship may at least ignore the assertions of fact, my lord, which have been made, because 90% of what has been argued by the opposite side is assertion of facts and in relation to merits of CPAN 922, not relating to the recall. Recall, they very carefully skirted. Yes. Yeah.
Second that's word, but in this fashion on campus. In sentence. Word I get is that argument.
My lord, with due respect, locus standi is a one-sentence argument. They have accepted that order must be read in totality. Your lordships have held that you have suo motu power. Your lordships have held that you have suo motu power in contempt. Whether you implement or not implement in a given case is a different matter. So if your lordship have suo motu power in contempt and your lordship have erred, now your lordship will demand locus standi for someone to come and correct your lordship's order? I'll repeat. That would be a dismissal. No, my lord, that is on merits of such a. My lord, with due respect, your lordship is again, your lordship is putting the cart before the horse, if I may say so respectfully. Because I'll explain why. I'll explain why. If I may answer, my lords. So I may answer. Therefore, if I've understood your lordship correctly, that because there is no need for locus standi, for knocking on a court's door, for it to take suo motu action for contempt, I'll repeat. If I've understood your lordship correctly, so in the judgment you have said to this effect. Very well. Yes. No, very well. Pardon? The mic, if it's not inconvenient, your lordship may, the mic.
No, my lord's microphone is not working. My lord is not audible over the VC. My lord, I'm getting messages from it.
Oh, now it is working. Okay.
Grateful.
So what I wanted to say that they have argued basically 2 points. One is that the applicants of this application has no locus standi to maintain an application for recalling. That is the first, I think that is the, I would say, more emphatically argued than anything else. Secondly, what they have said is twofold arguments from the different councils. One is that if you read the sentences used in paragraph 25 of that judgment or order of 13th of March, you will not find that there has been a categorical finding which has been arrived by the court. The court simply records something and then say that in a next sentence that the resolution plan is there and whatever is provided in the resolution plan, the parties are bound by it. So one has to read both the sentences in that fashion. The second argument, the line of argument apropos this was, I think Mr. Saha argues, Junior Saha, again, to be very correct. Otherwise, Mr. Khosla will say, which Saha, I do not know. The junior Saha, Mr. Joy Saha.
Son of who? Brother of who?
Mr. Jishnu Saha is also arguing. So Mr. Joy Saha argues that even if we treat it that the language is, this sentence is there, whether this sentence would really clinch an issue that had it not been there, the ultimate decision would have been just opposite.
Very well.
So what he says is that if you ignore this also, if you delete this part also, it does not affect the ultimate decision which has been taken in 13th March. This is what I say that alternative argument, if I correctly understood, was that. Nothing more than that.
So let me answer these 2 points first, Manoj, then I'll move on. Since they're fresh in your lordship's mind. I have nothing to say on locus except this simple sentence. They have admitted that an order must be read in the whole.
Yes.
Your lordships have said that when it comes to taking up proceedings for contempt, this court is empowered suo motu.
What is there in the
Yes.
judgment.
Therefore, there is no locus standi for anyone to be demonstrated for initiating contempt. Court may not. But there cannot be a bar at the threshold of the registry. No, no, no. Who are you? It will come up. Your lordship will consider. Do I want to take suo motu? I want to take suo motu. But your lordship will not say, who are you? Well, that is your lordship judgment. If I'm having resistance right here, then my lord, I would have more resistance when I speak next.
No.
Oh, so according to your lordship, suo motu means absolutely suo motu, not on petition.
Don't ask us to clarify. What we have said is said in the judgment.
Very well. My lord, if I read P.N. Duda and a lot of other judgments regarding information being placed before the court, suo motu would also mean on petition, but where the petitioner would be described as informant, not as petitioner. And then the court will proceed suo motu, which means that if notice is issued, there'll be no rejoinder by the informant, because not a list between him and the other side. He's not a party. He's an informant. He knocks on the door, slips a package in, leaves. And then the court decides. Then, my lord, when the judgment is passed, either positive or negative, proceeding or dismissing, it is an error apparent. It's my humble submission for 2 reasons. There's no locus for 2. The second, no one has touched. Though it's there in my written submission of the last time. The first is that when there's no locus for contempt, there cannot possibly be any locus demanded to show what is the locus to seek correction of an order passed on suo motu. Your lordship said that no, it has to be an error apparent. All that will be part of the adjudication of that application. But it will not be a threshold question. It will be a concluding question that we've gone through it. We don't think there's an error apparent on the face of the record. It requires deeper introspection, is a tantamount to review. Therefore, he has no locus. So therefore, this cart would be put before the horse, but at the end. But the application will not be said to be not maintainable. It will be maintainable. Whether it will succeed will depend upon the error pointed out. So that's where I am. I don't need to show locus to a court which has dismissed a contempt suo motu and made an error, with due respect. I may be wrong, maybe there's no error, but I cannot be turned out of the threshold that what's your locus for pointing out the error of the court. Number 2, the famous Order 1 Rule 8A argument. And I respectfully submit, forget about suo motu. even in a petition initiated by a person with locus standi, and the matter is disposed of or even is pending and is proceeding, but in the pending proceedings an order is passed which addresses a question of law wrongly, any one of 1.4 or maybe 1.5 billion people now in this country have the right under Order 1, Rule 8A of the CPC to approach that honorable court and place their view on the question of law under consideration before that court. Now, the question of law before this honorable court is this, and is not a question of fact. Is this court required to dilate on the source of documentation which led to a view? That's the question of law. In other words, alternative prayer. If this court passes a cryptic, for example, let's take the status quo order. Someone is a vendor to the pipeline, not involved, and he wants to know who will be responsible for paying his bills, because right now the purchase orders are coming from Hon'ble. So he files an application before this court. Please clarify status quo on alienation transfer. What do you really mean? Because I'm being asked to make supplies, and the question of law I want answered is that who do I have to sue for non-payment? Your Lordship cannot turn him out of the threshold that who are you? So on a question of law, any person has the locus standi to enter any proceeding before any court in any state at any point in time.
Yes.
The second was, my lord, para 25. Their argument that, all right, at the highest, let para 25 be deleted.
Yes.
The theme of para 25 runs through para 1 to whatever 42 or whatever the total paras, my lord.
Yes.
Those views could not have been adopted by this honorable court unless it also had the view, whether expressed or not expressed. My lord, for example, your lordship is not given explanation that your date of the orders by the Georgian calendar or the Gregorian calendar.
Yes.
Your lordship is not given your lordship's parentage, for example, while signing the order. A lot of things are not required to be stated. I mean, I don't mean any offense, my lord. I'm just trying to say. So therefore, even if you delete para 25, their argument is that your lordship is not required to reflect or reveal why you have taken a certain view. How can that be possible? My lord, let me put it this way. If para 25 was contradictory to the other paras and they wanted it removed, I'd accept that argument. Because according to them, para 1 to 24 and 26 onwards stand on their own legs. And in fact, para 25 is an aberration. I can accept that argument. I mean, I may agree, may not agree, may have something to say, but I can understand the logic behind that argument. That para 25 is an aberration. It does not fit in the whole. But para 25 fits in the whole. So why do they want para 25 removed? Because it suits them. If they want para 25 removed, my lord, I can take this order apart para by para and show how that para cannot survive if para 25 is missing.
Yes.
But that'll take 20 minutes, my lord. Kindly have the order, my lord, impugn order.
Yes.
Para 1 is introductory, my lord. We can skip it. I'm on page 88 of Can 10.
Yes, yes.
Para 2 we can skip, my lord. Para 3 we can skip.
I think these are all issues.
No, but my lord,
We
I
need to
take
look at-
objection to demur.
Yes.
The demurrer does not. I've given your lordship written. So I don't know if your lordship had the opportunity to go through them.
Yes, yes, I have.
Then the demurrer may be examined here, my lord.
Yes.
I am saying that by not filing affidavit, they've accepted.
Yes.
So if they accepted, my lord, then I need to stop arguing. In fact, I filed Can 13. My lord, can we have Can 13 for a moment? It seeks an order of conviction for contempt. Because by not replying to Can 10, they were admitted to contempt in CPAN 922.
Consider that. Let us, yes.
Let's skip para 6, para 5, my lords.
Up to paragraph 14, I don't think so. There is anything else.
Yes, my lord, up to para 13 is all okay.
14
14 onwards.
Yes, no, 15 onwards, I believe.
Now, my lord, it's relevant. For example, if the resolution plan is implemented, is it with pipeline or without? Para 14 can't stand.
What?
Para 14, I'm not saying the words of para 14.
Oh.
The sense being conveyed of para 14 in light of DDA versus Skipper and which relies on Sujit Pal, Calcutta High Court DB judgment. Please have this judgment, my lord.
No.
Yeah, don't worry.
You have not said anything on paragraph 14.
Beg your pardon?
Because paragraph 14 does not talk about anything else.
But with due respect, kindly read it from my side.
Paragraph 14 says that the petitioner number 1 is a company which has been a subject matter of insolvency proceeding under IBC at the behest of its creditors or the conglomerate of the creditors, and the resolution professional plan has been approved and all the shares and such are.
Kindly pause here, my lord. Now, resolution forget professional. Resolution plan has been approved. Kindly pause here. Now, kindly read DDA versus Skipper. Can you read DDA?
Has it been approved or not?
Of course, it has been approved.
So,
But something follows.
Yes.
I'll explain.
That
I'll
is
explain.
not stated. Only thing is it has been approved.
But it would not have been stated in this manner if para 20. My lord, may I explain why?
Can a bar dictate a judge that in what language the judgment has to be dictated?
No. I'm not
If they do not like that the words or the sentences had not been framed or written in that manner.
Lord,
Will it?
May I explain, my lord? May I explain?
It is the language's expression, how it varies with the man to man.
My lord,
A person
if you
may,
remove para
may
25,
write a particular thing in a one manner, another may write in a different manner.
my lord, then I request this, my lord, we will waste a lot of your lordship's value. You please decide CAN 7 and FMAT 1310.
We are closing CAN 10 for sure, because that was the gentleman promise from all the sides. CAN 10 has to be heard.
My lord, your lordship is causing an hindrance in your own lordship's deliverance of an accurate judgment. If your lordship will not decide CAN 7 and FMAT.
I reacted only to this when I read this sentence and you say this could not have been written.
Very well. Kindly have this judgment, my lord. I'll explain why. Please sit down, gentlemen. I have another hour and a half to go.
No.
Okay, then you go. Carry on. My lord, this is a judgment, Delhi Development Authority.
Yes.
He's citing Skipper. Skipper is on contempt. He's on recalling.
He did not have.
My lord, my learned friend may hold his horses and
He's in
set it
reply.
down.
Why you are standing? Yes.
Lord, Mr. Mithra, my lord, wanted to address you.
Yes.
My lord, this judgment is for the proposition that no act can be permitted in violation of a court order. And if committed, it has to be undone. Now, the relevance to para 14 is this. Kindly come to para 17 of the judgment. And para 18, it quotes Sujit Pal, Calcutta High Court Division Bench.
Correct.
So this judgment upholds that no act can be permitted in violation of a court order. Now, the relevance to para 14 is this, that if the injunction was violated, it does not matter that the resolution plan has been approved. That's why I'm on the line.
No, so I take it. So according to you, that even if the resolution plan has been approved, it has been affirmed by whatever. Meaningless. Injunction order, if it is there, that would operate.
Absolutely.
Let us then, yes.
Kindly have para 7. My lord, I'll read out that para so that your lordship is satisfied that I'm not trying to pull a fast one, as has been happening a lot in this particular litigation of the last.
Yes.
Kindly come to para 17.
Yes.
And then I'll read para 18, which is DB judgment of Calcutta High Court. The contemner should not be allowed to enjoy or retain the fruits of his contempt. The principle that a contemner ought not to be permitted to enjoy and/or keep the fruits of his contempt is well settled. In Muhammad Idris versus Babuji, this court held clearly that undergoing the punishment for contempt does not mean that the court is not entitled to give appropriate directions for remedying and rectifying the things done in violation of its orders. The petitioners therein had given an undertaking to the Bombay High Court. They acted in breach of it. A learned single judge held them guilty of contempt and imposed a sentence of 1 month's imprisonment. In addition thereto, the learned single judge made appropriate directions to remedy the breach of the undertaking, meaning putting him back. It was contended before this court that the learned judge was not justified in giving the aforesaid direction in addition to punishing the petitioners for contempt of court. The argument was rejected, holding that the single judge was quite right in giving appropriate directions to close the breach of undertaking. The above principle has been applied even in the case of violation of orders of injunction issued by civil courts. In Clark versus Chadburn, my lord, I'll not repeat, but it'll be the same theme. Then come to para 19. To the same effect are the decisions of Madras and Calcutta High Court in Century Flour Mills Limited versus Supaiya and Calcutta High Court Sujit Pal versus Prabir Kumar's son. In Century Flour Mills Limited, it was held by a full bench of the Madras High Court.
I believe this point has been taken note of at page 106 of that particular order dated 13th of March.
I am not aware, my lord, in my copy.
Yes, the paragraph 26, it's a longish paragraph.
Yes.
And
No, my lord, but para 26, what I may say, but
no,
completely.
it is, we have, the bench has already taken note of that. That it would not be proper for the High Court in exercise of contempt jurisdiction to hold a person guilty of violating the order of the court if the fact emanates from the record would reveal that certain acts have been done in due implementation of the order passed by the competent forum. It may remotely suggest the technical content, but the moment the approach is made to a forum raising a plea of nullity, it is advisable the court should not initiate a contempt proceeding when the act complained of is in due implementation of the order passed by the forum in exercise of the powers conferred by the statute.
My lord, your lordship
Such
completely.
order passed by the NCLT, though after the interim order that was taken, because you are arguing, though after the interim order passed such and such, yet those were passed in a proceeding which cannot be said to be invalid, but in exercise of power conferred by the statute.
My lord, with
The
due
order.
respect- Sorry.
Now the question is, Mr. Khosla, now I am on a very, very fundamental principles of law. If the court has arrived at a finding, taking note of the facts
My lord,
and
this is not the
interpreted
NCA. My lord,
and
please bear a
interpreted
moment.
and laid a law, if you are aggrieved by that ratio of the law or a law laid down, you have a remedy by going higher up and getting it corrected.
Oh, just pause here. Just please
Yes.
pause here for
Yes.
one moment.
Yes.
This entire para, my lord, if I may say it with the utmost of respect possible at my command, was a complete mishmash of appreciation of what the art. But allow me to finish, my lord. Your lordship has transposed our argument on section 419 of Companies Act leading to a nullity with something else. So I'm not on this. My lord, your lord, we argued nullity a lot, and nullity was not that they violated the injunction. My lord, please pause for a moment. We gave this thick a binder that a single member judicial cannot initiate IBC proceedings. Your lordships have rejected that argument only on the ground that no, the matter has gone to the Supreme Court. So we're keeping quiet. But this is not a proposition on contempt. Why did the nullity argument come up, my lord? Kindly pause for a moment. Our P1 was Hon'ble. Your lordship would recall I used the word we're trying to trap them in the arguments in court 37. And that they've fallen into our trap. That where an issue in the money suit would be decided at the end, now we are asking on their say-so to decide it in the beginning.
Any of those chapters are gone because
No,
you
I'm-
argued it and.
My lord,
those
I'm
were
trying to, no,
taken
because your
note of.
lordship has said, just now your lordship said that when I've taken a view,
Whether
I'm
you have
reminded.
put a trap or do not put a trap, we are not.
My lord,
concerned
please
with
don't
that.
catch my words, my lord. I am trying to say that your lordships did not appreciate the nullity argument flowing from single member judicial, which we are not agitating.
No.
This para is
Anyhow.
not that the nullity arises from violation of 22nd December 16.
Yes,
What your lordship, my lord, kindly have page 106.
yes.
No, because I'm a little disturbed.
Yeah.
That your lordship said that this is a clinching issue, that if I've settled it wrongly, go elsewhere. I will go elsewhere on the 419 Companies Act issue. But I'm not in recall on the section 419 Companies Act issue. Please read page 106.
Because paragraph 27
Such
is also
orders
very,
are,
paragraph 27 is also very clear.
my lord, what is the proposition upholding in para
The
27?
matter can be viewed from another angle. The stand of the parties in relation to the said pipeline is on the basis of the orders passed by the NCLT and affirmed up to the Supreme Court.
Yes.
If the contempt is initiated on the teeth of the aforesaid orders at this stage, it would have an implied effect on rendering those orders ineffective.
Yes, it will.
Redundant, and the person who have acted on the basis of the aforesaid order would still be punished being a guilty of.
Absolutely. That is what Sujit Pal says.
If the status of the pipeline has been declared in a resolution plan affirmed up to the Supreme Court, it's too technical at this stage to issue notice.
How is that? But your view is contrary to Sujit Pal. Your view is contrary to DDA versus Skipper.
Whatever.
That means your view is per incurium. That means your view is void. That means the recall lies, not review.
On a per incurium, the recall lies.
Exactly. So this is per incurium.
Tell us that a recall application on a proposition of per incurium judgment lies.
Yes, my lord. So therefore, para 27.
Show us one judgment.
Very well. I'll construct. I'll show. My lord, I'll show.
Show.
Please. Let me first construct the legal proposition, and then I'll give you, lordship, 25 judgments.
Yes.
Because when a court acts per incurium, it acts without jurisdiction. It acts coram non judice. It may have become a convention by lawyers to even take per incurium judgments up in appeal. But Article 141 binds your lordship's court to act in a certain manner. Your lordship's jurisdiction is flowing from oath of office. Oath of office contains your lordship's undertaking to uphold the Constitution of India. That includes Article 141. 141 says the law declared by the Supreme Court is binding on all courts. Now, that's a mandatory condition precedent. It is not a directory condition precedent. If it is a directory condition precedent, your lordship is right. Per incurium will not mean void, will mean not recall, will mean review. Please see the chain. Voidable, review. Void, recall. Now, the question is per incurium voidable or void? Your lordships time and again would have been presented judgments that please ignore this judgment of Supreme Court because it's per incurium. How can your lordships dare to ignore a judgment of the Supreme Court?
No, definitely. Who says so?
Because it is void.
Anyhow.
No, my lord. Please settle this issue, my lord. We don't want to come back again in another recall.
That is what we are beseeching. Permit us to state the law.
My lord, but please state the law, not in a hurry like last time.
Let the stage be reached.
So, my lord, your lordship has asked me. I have the compilations in my system, in my computer. I will prepare a compilation of judgments which will show that if a judgment is per incurium,
we take it that even a judgment is per incurium. It appears to be so, then it can be recalled. There is no difficulty. The only thing is we are concerned with the judgment here. We are concerned with the judgment. If suppose a judgment is passed on a basis of a particular special facts involved therein.
I don't understand, my lord.
The ratio of the judgment is to be culled out on the basis of facts involved in a given case.
Right.
True. And the judgment is to be applied by virtue of Article 141 of the Constitution of India in that perspective. If the facts are something different.
I got it. Now I'll answer your lordship. My lord, if your lord, for example, I'm relying on DDA versus Skipper. Let's say I gave your lordship DDA versus Skipper before 13th March, which I did, by the way. It's in the pleadings. Let's say your lordship dealt with DDA versus Skipper and said, no, doesn't apply. Your lordship's judgment is not per incurium. Because your lordship dealt with the judgment I gave and your lordship rejected my argument. Your lordship's rejection is within your jurisdiction because it is in your jurisdiction to judge rightly or to judge wrongly. It is in your lordship's jurisdiction. I cannot come back and recall. But if your lordship will not deal with the judgment cited at the bar, or your lordship acts in ignorance of a judgment that otherwise binds. Your lordship judgment will be per incurium, will not be voidable, will not be subject to review or appeal, will be void, will be liable to recall or collateral attack. I could file a suit before the civil judge at Alipur to please declare the division bench judgment to be null and void. I'm sorry, my lord, I'm not trying to shock your lordships. This is the law settled by Calcutta High Court.
On a lighter side, should not be transcribed. On a lighter side.
All right.
Can you go to the Alipur jurisdictional error, because this High Court does not fall within the
No,
territorial.
that's the beauty of it. I can take your lordship judgment to Jorhat, Assam. I do not have to come within a jurisdictional court.
Territorial jurisdiction.
And because my lord, I'll explain why. Just please kindly bear with me. My lord, I'm writing a treatise on the subject. Please bear with me. Your lordship's order conventionally would be required to be challenged within this territorial jurisdiction. Correct. But suppose they present it day after in Delhi. Please note down the judgment. Is JVG Finance versus Reserve Bank of India. I will give the citation right away. It's a
I'm
judgment.
aware. I will be reacting on that.
Well, that is one of the reasons why it's a pleasure to come before your lordship. We always go back with something more. So in JVG Finance versus RBI, a Bombay High Court suit court passed a certain direction. It was presented in Delhi High Court. Justice Sikri tore it up, figuratively speaking, and passed a 25-page order saying it's null and void. No one will all ignore it. Now there's a Bombay High Court judgment. How can it be dealt with in Delhi? Because it was presented in Delhi. So if your lordship judgment of 13th of March is presented in Jorhat, Assam, I can file a suit for declaration. My lord, kindly note section 44 Evidence Act. Wherever and whenever a judgment is produced that is passed by a court not competent, or by fraud, or by collusion, may be ignored. I could, while it's pending in my lord, please see, while it is pending in Jorhat, Assam, they present it in Srinagar. I'll file another suit in Srinagar, but disclosing that one suit is pending in Jorhat, Assam. It's moving forward, then the government presented in Patiala. I'll file another suit in Patiala, disclosing Jorhat pendency, Srinagar pendency. Ignore this judgment. My lord, that's the power of section 44 Evidence Act. That's the power of being able to challenge a nullity. A nullity, I don't have to go up. I can go coordinate, I can go down.
There's more academic.
No, my lord, it's not academic. No. With due respect. Para 27 is per incurium.
Yes. Yes, that's an argument. Yes.
It's yes. My lord, eventually, my lord, there's that phrase, no, that man proposes and God disposes.
Oh, no,
So I think that's why your lordships are called lords.
No.
Because your lordship will dispose.
No.
I'll tell her.
We dispense justice, not dispose. Yes.
My lord, well, would your lordship have heard of this gentleman, my lord, by the name of Mr. Amarjit Singh Chandiok? He's been the president of the Delhi High Court Bar for many years.
Yes.
He was once in London at the request of the bar in England.
Yes.
So they had some dinner. I won't be long, my lord, less than half a minute.
Yes.
It was some dinner convocation, etc., etc. So toasts were being proposed and so on and so forth. So one Englishman trying to act over smart, he says to Mr. Chandiok, you know, we Britishers left India to your devices, but you still follow our ways. So Mr. Chandiok says, how's that? Well, you still call your judges, my lord. So Mr. Chandiok got up and he said, yes, but we call it for a different reason. Because justice comes from above, from the Lord above. And our judges are manifestation of the Lord above. That's why we say, my lord. Whereas you say, my lord of reading, my lord of spelling, my lord of Thames, my lord of Kent. We are not on geographical. When we say my lord, we mean because our judges manifest the Lord above. My lord, he got a standing ovation by brown and white men alike.
Yes.
So, my lord, with the utmost of respect, para 27 is per incurium.
Yes.
It ignores Skipper, it ignores Sujit Pal. Because for your lordship to say that, so what? If let's say this, my lord, let's say your lordship's view was this. Yes, injunction means pipeline was to be hospitals, but Resolution plan, rightly, wrongly, fraud, mistake, whatever it was, has shown the pipeline to be part of SR Steel, which has gone up to Supreme Court. Well, now too bad. Sorry, my lord, cannot be too bad. Sujit Pal says, cannot be too bad. DDA versus Skipper says, cannot be too bad.
Yes.
It has to be undone. Which again takes me back to the importance. Please decide FMAT 7, FMAT 1310 or 2016 first.
Yes.
Because that will define your lordship disposal of Can 10. Your lordship will be committing a big, my lord, even if it is in my favor, even if your lordship's judgment on Can 10 is in my favor, there's a big chance of it being erroneous. Unless your lordships align your order in Can 10 with Can 7 in FMAT 1310. My lord, how more transparent can I be? That even if the judgment is in my favor, it is possible for it to be an erroneous judgment. And I want, my lord, not the right, I don't want the right judgment. I want a judgment for the right reasons.
Yes.
Because if I get a good judgment, but for bad reasons, it will be challenged and set aside.
Yes.
So, my lord, coming back to para 14, I hope, my lord, are we in agreement that para 27 is per incurium and no.
That's your submission we have recorded. Don't say on
No, okay,
agreement.
I apologize. Not per incurium, but are we agreed that para 27 observation could not have been there if para 25 is removed?
That we will tell it in a judgment.
That is beyond the scope of his application. What is arguing?
Why you are jumping every time?
It is in the scope of his argument. He's widened the scope of my application. Now, when I address his widened scope, he says, oh, your argument is outside the scope. Then why did you argue your argument?
Anyhow, you did not be so perturbed with this. Anyhow, we have.
Lord, para 14 could not possibly have been couched in these words if your lordship had not adopted the view that the pipeline belongs to SR in the resolution plan.
Correct.
Same way, para 15.
Yes.
No, we can skip para 15. 16 also we can skip, again, it's a question of law. We can skip 18. Now para 19, the entire thing will get wiped out.
Yes.
If you remove para 25.
Yes.
Para 20. Again, this is hinging on the view that the pipeline has been transferred to SR as part of the resolution plan.
Yes.
Para 21, again. My lord, it goes on. Without para 25, this judgment is like a Jenga puzzle, my lord. You remove one piece.
Yes.
The other pieces have to fall.
Yes.
So, my lord, in Sujit Pal, I was reading para 20 of DDA versus Skipper.
Yes.
A division bench of the Calcutta High Court has taken the same view. There, the defendant forcibly dispossessed the plaintiff in violation of the order of injunction and took possession of the property. The court directed the restoration of possession to the plaintiff with the aid of police. The court observed that no technicality can prevent the court from doing justice in exercise of its inherent powers.
Right.
It held that the object of Rule 2A of Order 39 will be fulfilled only where such mandatory direction is given for the restoration of possession to the agreed party. This was necessary, it observed, to prevent the abuse of law. There is no doubt that the salutary rule has to be applied and given effect to by this court, if necessary, by overruling any procedural or other technical objection. The same, what I'm submitting, please put all procedural issues into a gunny bag and have it thrown into the hoogly. Now, my lord, please come to my written submissions. This para 4, the fallacies, I will just read out, my lord, separately from a different note. I'll just come back to that. Then, my lord, section para 5 is relevant. If your lordship may have these judgments, this judgment of Delhi High Court, which relies on Supreme Court of Singapore, High Court of Singapore, and which have relied on Calcutta High Court. Very interesting. It's on section 209 of the Indian Penal Code, my lord, which reads as follows. Yeah, I'll just give it. Sorry. Just enough. Then I don't have time to print it. I'm not in any quoted drawing. So don't have to get nervous. What fast one? Sorry. My lords, in this judgment, if your lordship can kindly have my note, my written submission, page 3. Section 209 of the Indian Penal Code, my lord, it gets attracted here. There's a reason. It talks about dishonestly making false claims in court. Whoever fraudulently or dishonestly or with intent to injure any or annoy any person makes in a court of justice any claim which he knows to be false shall be punished with imprisonment of either description, 2 years, and fine. Now, my lord, in this judgment, the Honorable Delhi High Court has analyzed how it applies to everybody in the courtroom, including honorable counsels. Now, why that becomes relevant in this matter is because there's no affidavit. Yet, there are assertions being made on facts. So, when an assertion is made on facts, my lord, especially by a senior advocate, designated senior advocate, it's settled, my lord, that he cannot act in any matter. He can only plead. And pleading means taking the package of facts stated on affidavit, bundling them with the law applicable to present as rosy a picture before the court in favor of his client. That's pleading. But if a senior advocate makes assertions of fact without it being on affidavit, is no longer acting as a counsel.
Yes.
He's acting in his individual capacity, but with the utmost of respect, impermissibly while wearing robes. That's not permitted. So this judgment, my lord, I think from around para 30 onwards, deals with this issue of how it impacts counsels acting in court. And in fact, Delhi High Court has issued notices to lawyers under 209 for misleading the court. Then, my lord, kindly come to page 4, my para 6. It's very interesting. My lord, there's been rebuttal by Hon'ble. There's been rebuttal by SR.
Yes.
And there's been rebuttal by ArcelorMittal India Private Limited, which is the successful resolution applicant for Hon'ble and SR. So the group of three. And then I think Mr. Joy Saha appeared for R1 to R11, which is, I think, IDBI Bank. Yes, IDBI Bank and its officers. There's no rebuttal by anybody else.
Yes.
All have been served.
Yes.
Counsels have appeared. IDBI Bank is the biggest crook in the transaction, and please record my submission so they can seek my prosecution for defamation. I reiterate, IDBI Bank is the biggest crook in this transaction.
Yes.
So his appearance is to hide his own frauds. But what about the RP of SR Steel? He is the man who compiled the information memorandum. He is the man who invited offers by way of resolution plans. He is the man who received resolution plans. Not rebutting. So, 7th February 2018 order of NCLT Ahmedabad now takes an even more stronger light, because that order was passed while dismissing his application. He tried to say, please say pipeline belongs to SR because of cancellation deed. NCLT said nothing. Then, my lord, there's no rebuttal from the COC of SL.
Yes.
I'll explain the relevance. In the COC of SR Steel, if you also just make a note, my lord, is there in the pleading, but please make the note of this. 13th February 2018, State Bank of India files commercial suit number
13th.
13th February 2018.
Yes.
That means during the pendency of CIRP.
Yes.
SBI,
Yes.
commercial suit number 462 of 2018.
422.
462 of 2018
Yes.
files suit before Delhi High Court. And now please underline the next two words. Through SAM. Through Shardul Amarchand Mangaldas. I'll explain why. They say, I, State Bank of India, I am a lender to Hon'ble. I financed it to purchase the pipeline from SR in 2015. It has bought the pipeline. It is, not was, it is in 2018 mortgaged to me. And now the shareholders of Hon'ble are trying to sell the shareholding of SR, which is 30%, to New Metal Mauritius, a company promoted by Ruyas. Please stop this. They get an injunction. Now I'll explain why I said please underline through Sam. The legal advice, my lord, I'm sorry, it is a well accepted approach and correct also that courts do not like allegations against lawyers because they're usually false. Not because lawyers are above the law, but because they're usually false. But please just put that reservation aside for just a couple of minutes and please hear what I have to say. The reason why I urge your lordship to underline those words through Sam is because the legal advisors to the COC of SR Steel are Shardul Amarchand Mangaldas. Now the relevance is, your lordship is well aware the Bar Council's rule preclude a lawyer from acting like a mouthpiece of his client. So therefore, Shardul Amarchand Mangaldas, when they filed the commercial suit in Delhi, assuming they were not acting as a mouthpiece of their clients, did a reasonable due diligence of the claims being made by them, being drafted by them on behalf of their clients, and being argued by them to have some semblance of truth, which is that the hospital is the owner of the pipeline. When they come on as legal advisors to the COC, they surely cannot take a different stand from the stand on which they acted upon in the Delhi High Court. Today, they're silent, but they're here. Shardul Amarchand Mangaldas is here. My lord, I understand, my lord, your lordship will find all this offensive.
No,
But in a court of law, everybody is equal.
no, that's true. Why every time you perceive something of your own,
Because I have
which we
seen
never
justice,
thought of, we never
Lord,
even imagined. You imagined it.
because I've appeared before Honorable Mr. Justice Tandon for about 200 hours. And
No, no,
some
nothing.
mannerisms, my lord, we can guess at.
No,
And
no,
your lordship is not happy with what I am saying.
no. We are not making any comments.
Very well. Anyway, my lord, they were legal advisors, and it gets more shocking. The captain of the legal team was one Mr. Sapan Gupta.
Is it relevant for the recall?
Yes.
I'm just asking whether it is relevant.
Yes, my
because-
lord, it is actually the most relevant fact. The fraud, it's most relevant fact regarding the fraud.
Have you pleaded in your application?
Yes,
for
it's all there in my CPAN and all my.
recall?
My lord, I don't have pleaded in every application, my lord. But these facts are pleaded. Now, in January 20, my lord, would your lordship write this date? Supreme Court 15/11/19. Money in 16 December 19. 1 January 20, Sapan Gupta into ArcelorMittal. Relevance? A company has no mind of its own. It has to act with the mind of the person guiding its affairs. When it comes to litigation in a big company like ArcelorMittal, it will be the head of litigation, the legal head. So the legal head of ArcelorMittal India from 1st January 20 is Sapan Gupta, who from April 21 is global head. It's the credit, my lord, to Indian lawyers. He's the global head of ArcelorMittal worldwide. And he's been served with this application.
Lordship, I'm sorry, I want to intervene.
They won't let me speak.
1 minute, I want to say something, Lordship. This is highly improper. These are allegations made against fellow lawyers at the bar, and we strongly object to these. These are lawyers he's talking about. If one lawyer moves
I
to
apologize. Lawyers are above the law.
no, I'm not saying, I will never say this, but I will request my lords to request Mr. Khosla not to make these averments, please.
Then please decide this issue, my lord. Direct me not to make these averments, even if they are facts.
Lordship, these are allegations against fellow lawyers at the bar.
Allegations, they are assertions of fact.
1 minute, Mr. Khosla. I can understand what Mr. Khosla has been arguing so far, fraud, this, that. We have not said anything. But now to make personal allegations against the lawyers, I think it's not called for. And I will request and beseech this honorable court to please put a stop to this conduct.
Madam, we will definitely, the moment we find that something is beyond, the things, we will definitely not permit him to go on.
Lordship, I'll tell you what happens. I understand. Now, this statement has come. He is going to circulate this statement. You have seen that YouTube transcripts are being produced before this honorable court, and he has not even spared somebody like Mr. Sudipto Sarkar, who's the tallest member of the Calcutta Bar. And now he wants to target any lawyer, which this, I don't think, Lordship, I will request that this must be stopped.
Madam, don't worry, that will be taken care of. Don't worry.
Much obliged, Lordship.
All I can say, my lord, is see the panic. Every time I bring up Sapan Gupta's name, my
I'm
lord,
not panicky. I'm sorry. I'm
lawyers.
just talking of decorum.
I can appear for Sapan Arslan Mittal without Sapan Gupta approving the checks.
Mr. Khosla, if a litigant has can engage a lawyer to represent like your client who has engaged you to represent, anybody who is there have an authority to engage a lawyer in a litigation. Why you blame them?
They have no difficulty.
So
I'm saying the panic.
So why?
That's all.
That's
Because
why
this is
I
the
said.
first time.
That's
same
why
lady
I
is
said in
interrupting
the
me.
morning, Mr. Joysa said something. I immediately protested for that. Confined to what has been stated in the petition and nothing more than that.
Very well.
Yes.
So, my lords,
Yes. Conclude.
so, my lord, I will need a little bit more time, my lord. I need to finish off
Yes.
my points. Because they've gone quite extensively into various matters that they ought not to have gone into, but now they've
Yes.
gone into.
Yes. You were referring this 6 rebuttal. You have already referred 7 inexplicable orders.
No, I'll just, my lord, that will need a little bit of time. Just please kindly pause here for a moment, my lord.
Yes.
Because I am not cowed down by Miss Ruby Singh Ahuja.
I don't know how.
I'm sharing her name a lot. She's a senior partner in Karanjawala and Company.
Yes. Anyhow,
So-
that's the is a material for me.
So therefore, my lord, a company does not have a mind of its own. A small proprietorship, proprietor's mind. Partnership, usually one of the partners' mind. Slightly bigger partnership like Nirma was a partnership but doing thousands of crores, maybe as a law manager, then with the law manager's mind.
Whatever, that is there. It's
So what I'm trying to say, my lord, is that when your lordships are hearing assertions at the bar, which are not an affidavit,
correct.
is it wrong to say that they carry the endorsement, either explicit or tacit, of the legal head of the company?
Yes.
My lord will just note down, my lord, section 107 to 109 of the Indian Penal Code.
Yes.
Abetment. So when a legal head has been appointed to look after legal affairs, and now Aslo Mittal is taking the stand that the pipeline belongs to our SR Steel, and the legal head is Sapan Gupta, who is heading Shardul Amarchand Mangaldas, who's drafted pleadings, etc., which show that the pipeline belongs to Hospital.
I think
Can Aslo Mittal,
argument can be advanced without naming a person.
my lord, should I use SG?
No, whatever, not required at all. Not required at all. Oh,
You should. Why didn't you interject when your colleagues were calling? Oh, you don't know.
Mr. Mitro, please. No, we are here. Don't.
Not a preferred lawyer.
No, definitely not. Yes.
He cannot raise his finger on me.
May I carry on, my lords?
This can't be done.
My lord,
reading-
kindly resume the, now that the unpleasantness is somewhat subsided.
No, if he shakes my hand, my lord, that means the unpleasantness is over.
No, I have nothing personal against him, unlike
Want to shake
him.
my hand?
I don't mind shaking your hand. I don't mind shaking your hand.
Like a man, yeah, not like
Yeah.
I will do that. I will do that. I am sure he will also be gracious enough to offer me a cup of tea. Unpoisoned. Yes, my lord. So, my lord, I'm just sharing. I'll come back to the inexplicable orders in context of Mr. Jishnu Saha's rendition of that NCLAT 31st March judgment, where your lordship has highlighted a lot of lines. I'll come back. No, my lord, emphasis not on highlighting. I'll just come back. Now, my lord, I'm sorry I could not prepare a very.
My lord is not audible over the VC, my lord. I'm sorry, my
Oh,
lord.
this is the Delhi, yes, NCLAT judgment.
Yes, well, I'll come back to that in the end, my lords.
Yes. Yes.
My lord, do I take it that your lordship will not hear Can 7 in FMAT before passing order in this matter? Because it's a 2-minute argument in Can 7 FMAT.
I have already indicated you that we are concentrating on Can 10 filed for recalling of the order. That's all.
So do I take it that your lordship would like to ignore Can 7 while pronouncing
Why
order?
you are asking these questions to the
Because, my
court
lord,
that
if I can
ignore,
because-
why these words ignore?
Bec-
Why you think ignore?
My lord,
That is pending before the court will take up
I
at
mean,
any time.
I mean before or with Can 10.
We are now concentrating on recall applications of
All right.
CPN 922.
My lord,
That's
now
all.
these are my points. They're not in logical flow, but because I've not been I have time to organize them, but
Please.
here they are.
Yes.
My lord, coming to locus standi, Mr. Joyce has conceded that Article 215 suo motu power exists. He conceded that. But he said that the error must be apparent for a recall.
On a locus, he has not said so.
No, these are his words. He said that I concede that under Article 215, power, suo motu power exists. Therefore, any person can approach. But then he must approach for recall, provided the error is apparent right on the face of the record. But you have to show this order, this document, that document, then that's not an error on the face of the record. That can only be done by a person who can demonstrate locus standi. Very strange argument, but this is what he said. And I respectfully refute that by Order 1, Rule 8A.
True.
It's an omnibus pill.
Yes.
If I confine myself to a question of law,
Yes.
I can enter in any proceeding before any court, most subordinate, most junior, Supreme Court, in any state, in any matter.
Correct.
Then, my lord, they have not addressed the following 19 points against them, which are all there either in the CPAN or in the recall, and which go to the root of this issue about your lordship's observation that the resolution plan had an express provision, and what your lordship has observed in para 27, that, well, if the resolution plan, once it has been approved, then it doesn't matter whether contempt has been committed or not.
Yes.
Your lordship, you would be right if Supreme Court endorsed that the plan violates injunction, but it's okay. Because then I cannot come before your lordship.
Yes.
Then I have to go to Supreme Court. That, sir, there's an injunction. They could not have violated it. They violated it. Your lordship have erroneously held that it's okay. It's not okay. Please recall, review your order. That's different.
Yes.
But there is nothing in the entire chain from NCLT, NCLAT to Supreme Court which reveals that these people place their cards on the table, that their stand is that the pipeline belongs to SR Steel. They never did. On the contrary, these 19 points follow.
Yes.
One I've already shared with the lordships, State Bank's commercial suit, 13th February 18.
That is not there in the recall application.
It'll be there in the CPAN, my lords. No, my lord, when Mr. Joy Saha wanted to show the affidavit,
Which one? I have not.
no. When he wanted to point out Veerjay Khosla, son of Deepak Khosla, he
I-
went to the CPAN 70.
We immediately reacted to it, that something which is not there, you cannot.
So, my lord, it's my humble,
We reacted to it
it's my humble
and
submission,
did
my
not
lord.
allow him to make any submission.
It's my humble submission, my lord, that your lordship would be, when your lordship said that, is it on the record? It's my respectful submission that the record means the entire record of CPAN 922 and IA is flowing therefrom.
Yes.
It's not that every can must be a standalone can, replete with facts starting from 33 BC.
Yes. Yes, there must be some pleading on that.
Yes, absolutely. All these 19 points are there, either in the CPAN or in the CAN. My lord, there are about 8-9 cans.
Correct.
Supplementary development, supplementary. We kept updating the record of this court.
Correct.
Because CPAN was filed, I think, in August or September 22. So as and when developments took place, we filed additional material on the record of the court. So it's all there.
Correct.
But if your lordship likes, I'll put this into written submission with a reference that which assertion is borne by which document in which can.
Yes.
So SBI commercial suit is done. Below the 19 points, would your lordship like to note it, or shall I give a written note tomorrow?
What?
The aspects that they have deliberately not addressed, which if they addressed would defeat their ability to claim that the resolution plan provided for the pipeline to be a part of SR Steel, and therefore the view taken by this court in para 25 and 27 is correct.
So this is 19 is on that.
Yes.
We will take care of that.
I'll just run
Can
through it
you-
bullet points.
Can
my lord.
you, take that dictation, what he says is, this last one.
Or I'll give a written note to all.
No, it is just
all right.
dictated,
Noted.
they will take care
So
of
the
it.
first one is
No, the last one you said,
SBI.
they have not argued or taken any stand or disclosed any stand,
Yes.
that they have failed to disclose any stands as to whether that is what you want to say. Please correct it in your own language. I do not want to say. You just say.
I'll take care of it.
Yes.
As to whether or not the pipeline being a part of estate of Hon'ble or estate
SR.
of SL,
SR.
as borne out by the following 19 events, not disclose their stand one way or the other.
Correct.
And these 19 events go to the very root of the view expressed by this honorable court in para 25, read with para 27 of the judgment dated 13th March 23, comma, to the effect.
What more?
To the effect that the resolution plan for SR had an express provision that the pipeline belongs to SR.
Correct.
So item 1.
Dinner is over. No difficulty. Then.
No, but then may I read out the 19 points, my lord?
No, wait.
Just bullet point.
I'll bullet point.
SBI commercial suit.
Yes.
Number 2, the significance of it being filed through SAM.
Yes.
Number 3, the significance of SAM being the legal advisor to the CRC of SR and Hon'ble.
Yes.
So they cannot say when they are in COC of Hon'ble that yes, pipeline belongs to Hon'ble, and when they're in the COC of SR, say yes.
Belong to SR. Yes.
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 Same legal advisor.
Next.
Number 4, the Delhi High Court order dated 13th February 2018.
Yes.
Number 5, 3 banks who are members of COC of SR and members of COC of Hon'ble on 28th June 2019 have filed an affidavit before Sialda Court swearing pipeline belongs to Hon'ble. So the same banks cannot say as COC members of Hon'ble that pipeline belongs to Hon'ble, and when they're comprising the COC of SR, say that the pipeline belongs to SR.
Correct.
Number 4, number 6. Hon'ble RP, Ashish Chowchadia.
Don't use the name anyhow. Hon'ble. Yes. RP.
There's a reason.
Resolution
Anyway.
Professional. That use that term. Don't use the name anyhow.
There's a reason. Very well. Actually.
No.
The
Resolution
Hon'ble
Professional.
RP filed affidavit in Sialda Court 18th July 19.
No, he's not writing. Don't worry.
Oh, okay. No, I thought he was taking. Anyway,
No.
so Hospital RP filed an affidavit on 18 July 19 for Hospital, not for himself.
That the pipeline belonged to hospital.
Hospital.
No different. Then
And said injunction 22nd December 16. Refer to the order of 7 February 18, etc.
Correct.
Then, my lord, the Hospital COC minutes repeatedly show that all the lenders are of the view that the pipeline belongs to Hospital.
Correct.
The relevance being all these 12 lenders are part of 22 lenders group of COC of SR Steel. So they cannot say in Hospital COC belongs to Hospital, but in SL COC say it belongs to SR. The relevance, my lord, is this. The RP of SR acts under direction of COC. Information memorandum prepared with blessings of COC.
yes.
Resolution plan invited on instructions of COC. What I'm trying to say that whatever may be the opinion of the RP is of no relevance. It is the COC that has to decide that within the 4 gates
Yes.
of the factory, what are the assets inside?
Yes.
Those are the assets that form the information memorandum. And the COC has taken a clear view that the pipeline belongs to Hospital.
Yes.
So therefore, the information memorandum cannot say that the pipeline belongs to SR Steel, much less the resolution plan say that the pipeline belongs to SR Steel. Then, my lord, this is very important. That's why I took the name, but I'll refrain.
The same
Gentleman who's the RP of Hospital is the MD of Grant Thornton. The relevance is, if your lordship would like to make a note, 11th COC meeting of SR Steel.
Yes.
He personally attends the COC meeting,
Yes.
the gentleman by name. Thereafter, meaning what I'm trying to show is personal. He may be head of Grant Thornton, but someone could say, oh, but he does that does not mean that he knows everything that Grant Thornton is doing.
Yes.
So I'm trying to show that the head of Grant Thornton, who became the RP of Hospital, attended the COC of SR Steel and therefore was aware of what the parameters were or what was going on. So much so, please note,
Yes.
Grant Thornton was appointed as the plan evaluation advisor.
Yes.
Means how to frame the information memorandum and call for resolution plans. Thereafter, Grant Thornton was appointed as the bid evaluation advisor. Means all the resolution plans that came from ArcelorMittal, from .12.
Yes.
They have said that it is wrong to say that the resolution plan for SR Steel had a provision that the pipeline belongs to SR Steel.
Yes.
My lord, they are the legal advisors to the RP.
Yes.
Legal advisors to the RP have sworn an affidavit because they were arrayed as contemners before NCLT. That it is wrong to allege that the resolution plan filed by ArcelorMittal for SR Steel provided for the pipeline to be part of SR Steel.
Yes.
Then, my lord, the statutory auditor of SR Steel has filed an affidavit 11th October 22 before NCLT Ahmedabad. If your lordship would please make note, my lord, it's a very important document.
Yes.
This was his reply to interrogatories.
Yes.
He confirms that in the books of SR Steel, the pipeline has been shown as an asset with effect from 1st July 16.
Yes.
But he also says that the debt has not been transferred. Now, the cancellation deed, I am following the arguments of my learned colleagues. every document, every order must be seen in its totality. So the cancellation deed had a very clear condition that it will go into effect subject to consent of the lenders, and the debt will be transferred from Hon'ble to SR Steel.
Yes.
No transfer of debt.
Yes.
So tomorrow, if SR Steel's books now showed purchase of Taj Mahal,
Yes.
can ArcelorMittal say today, I own Taj Mahal?
Yes.
Because when I took over SR Steel, its books were showing Taj Mahal is one of his assets.
Yes.
Then, my lord, any contract implemented in violation of statute is void.
Yes.
For the pipeline to go from Hon'ble to SR Steel,
Yes.
required compliance with Section 180 of the Companies Act 2013.
Yes.
No compliance. So when there's no compliance, can it be said that SR Steel's claim that the pipeline now comes back to me has any substance when it's in breach of law?
Yes.
Section 180 of the Companies Act, my lords. Then, very interesting, in this cancellation deed, both the signatories for SR and for Hon'ble are SR employees. They're SR employees. Bogus. Fraud.
Yes.
Then, my lord, the fact that Hon'ble has charged depreciation because Hon'ble is showing the pipeline in its balance sheet today.
Yes.
So that makes very strange the statement of the learned senior counsel who opened arguments, who argued for Hon'ble, who said pipeline belongs to SR Steel.
Yes.
Hon'ble's balance sheet is in the record of this honorable court. And the pipeline is part of the balance sheet of Hon'ble. There's a qualifier, of course. There's a note that civil suit is pending at Shalda, and the title of the pipeline shown presently is part of the fixed assets of Hon'ble is subject to outcome of the suit. But that's normal treatment. When a man has an asset and another man has laid a claim on that asset, that man will show the asset as his asset, but will put a note in the balance sheet that someone has laid a claim on my asset.
Yes.
So the public at large is not misled that this asset is an unfettered, unencumbered, undisputed asset.
Yes.
No, the more, my lord. No, my lord, if your lordships hold today, as your lordships have observed in 13th March, which I say with the utmost of respect, erroneously on facts, your lordships have observed that the pipeline is part of SR Steel. This means that SR Steel is claiming depreciation.
Yes.
But Hon'ble is showing the balance sheet in Hon'ble is showing the pipeline in his balance sheet. So Hon'ble is claiming depreciation.
Yes.
So your lordships are endorsing tax evasion.
Yes.
So your lordships would be endorsing your judgment, your finding
Yes.
would be endorsing tax evasion. Because the pipeline, the Hon'ble balance sheet is on your record.
Yes.
And the Hon'ble balance sheet, they claim depreciation.
Yes.
So, my lord, surely it would not be the intent of this honorable court to encourage a party to evade taxes.
Yes.
Then, my lord, very interestingly, this balance sheet that's on your lordship's record, if your lordship may make a note of these two names, they are directors now.
Not necessary. Anyhow, we'll take that.
May I take the initials so your lordship can note
No,
down?
no, it's not necessary. We'll take just balance sheets of the Hon'ble.
It's a 280-page document, my lord.
Yes. Yes.
My lord, it's not the typical CA signed format, it's the XRML, XBML.
Yes.
Anyway, the initials are KG and HE. HE is a Japanese.
Yes.
and KG is an Indian. So as directors of Hon'ble, they've signed the balance sheet, certifying the pipeline as an asset of Hon'ble. And the same two gentlemen, please note, the same two gentlemen are directors of SR Steel concurrently, simultaneously. Now, can these two gentlemen sign both balance sheets? Because in SR Steel, my lord, like the pipeline is showing in Hon'ble, the pipeline is not showing in SR Steel's balance sheet.
Yes.
My lord, I hope I was able to convey my point.
Yes, yes, obviously.
In SR Steel's balance sheet,
Correct.
there is no line item showing
Correct. That the
pipeline.
Yes.
All these hand waving going on is at the bar. There's no affidavit.
Yes.
There's no balance sheet. But Hon'ble balance sheet is there.
Yes.
Then, my lord, please note this, my lord. I'm not sure if it's on record, but if it's not, I'll put it on record. On 10th November 22, because Mr. Jishnu Saha made reference to this. And you, Mr. Kar, they said that the challenges to Hon'ble plan have been carried all the way to the Supreme Court and dismissed. That Supreme Court orders dated 10th November 22.
Yes.
And that 10th November 22 order says as follows. I'll just read it out, my lord. It's a very short order. If your lordship would like to note down the appeal numbers, civil appeal number 4791 of 22 and 4754 of 22. Both of them, the title is Srey Infrastructure Finance Limited versus Ashish Chowchadia and others. It says heard learned senior counsel appearing for the parties at length. We find no reason to interfere with the impugned order passed by the tribunal. The appeals are accordingly dismissed. However, we make it clear that the proceedings arising in Company Appeal number 1038 of 2020 and 1043 of 2020 from the order dated 10th November 2020 of Adjudicating Authority NCLT Ahmedabad Court 1 pending before NCLAT may be independently decided on its own merits without being influenced by the observations made under the present order impugned.
Yes.
My lord, I will need about 10 minutes of your lordship's kind attention to understand what's the meaning of these 4 lines.
Yes.
My lord, what happened was after the SR resolution plan was approved by Supreme Court order of 15 November 19, 1st December 19, ArcelorMittal filed resolution plan for Hon'ble. 6th December 19, the plan was approved by COC of Hon'ble. After its approval, 16th December 19, he put in the money. In January 20, SIFL came to your lordships with a misguided application. It's there in the FMAT that please direct them to pay RTU charges also in addition to the injunction.
Yes.
Your lordship rightly dismissed that application that now you're trying to widen the scope of the injunction. Our injunction was only to the effect that no alienation transfer, not the consequences flowing therefrom.
Yes.
So when this application was dismissed, SIFL filed an application in Ahmedabad saying that this resolution plan is incomplete because it does not provide for RTU charges payable by SR to Hon'ble. My lord, I'll need your lordship's kind attention.
Yes, yes, I
Sorry, I'm so
understand.
sorry.
I remember it's a recapitulation of the arguments which was advanced there. Yes, yes.
Oh, this is very important. So SIFL says that this plan is not code compliant. This plan is in breach of the provisions whereby CIRP costs are to include all costs during CIRP, and the phrase all costs includes RTU charges payable to me, payable to Hon'ble. Now, my lord, and this goes into the injunction. Why should SR pay RTU charges to Hon'ble during the CIRP if the pipeline
Bank
is its
belongs
own.
to SR.
Exactly.
That was argued, I know.
So SR wakes up. Now, this is the first time that false affidavits are filed. Till now, SR is quiet. His resolution plan for SR does not say pipeline belongs to SR, though his resolution plan for Hon'ble says that the pipeline belongs to Hon'ble. And I have placed, my lords, with Can 10, both resolution plans, so your lordship can verify my submission at leisure.
Yes.
That in SR resolution plan, he recognizes that it's sub judice.
Yes.
But in Hon'ble, he recognizes the pipeline to be an asset of Hon'ble, so much so that he's showing RTU charges earning. The reason why he's showing it? Under the IBC, no plan will be approved unless the successful resolution applicant shows to the COC that the company is not going from the frying pan into the fire.
Yes.
That insolvency resolved today in 2019, only to become insolvent again in 2024. So what are your projections? Show us that the company will be viable. So they showed projections. In the projection, they showed RTU charges being earned from SR Steel.
Yes.
Can they earn RTU charges, my lord, if Hon'ble does not have the pipeline?
Yes.
So on this premise, SIFL went to NCLT, notice issued. And this is the first time now that in August 2020, if your lordship would like to make a note of the date, in August 2020, ArcelorMittal for the first time takes a stand. Oh, what are you talking about? Landlord does not pay rent to the tenant. Tenant pays rent to the landlord. So why should I pay RTU charges for a pipeline that is mine? First time, August 2020. All these allegations are rejected by Honorable NCLT by a 325-page order, 10th November 2020. And the two main fulcrums of this order of 10th November 2020 for rejecting the arguments by ArcelorMittal are: number one, the injunction dated 22nd December 16 passed by this Honorable Court. And the second is the order dated 7th February 18 passed by Honorable NCLT. And then, of course, many other reasons like Section 180 of the Companies Act, lenders never gave their NOC, the debt never got transferred, that was a condition of the cancellation. After all, my lord, if it's a 325-page order, there must be very extensive reasoning. That order is part of your lordship's record and it bears reading. This order was taken and challenged by ArcelorMittal before NCLAT. And they got an ex parte stay. I don't know, my lord, if it was a wise move because after all, by this time, ArcelorMittal owned SR, ArcelorMittal owned Hon'ble. So if he complied with the order, at best, it would have meant writing a check from his left pocket into his right pocket. So maybe he should have done that. Anyway, it's whatever is the legal advice that he got. He decided to challenge it, and NCLAT granted an ex parte stay of 10th November of the order of 10th November 20 by its order of 4th December 20. Now I'm linking it with the Supreme Court observation. I'll just read out that line of the Supreme Court again. They have said that the resolution plan challenged all the way up to the Supreme Court. Very well. They didn't highlight the caveat put by the Supreme Court. The Supreme Court said, however, we make it clear that the proceedings arising in Company Appeal number 1038 and 1043 of 2020 before NCLAT from the order dated 10th November 20 of adjudicating authority NCLT Ahmedabad pending before NCLAT may be independently decided on its own merits without being influenced by the observations made under the order impugned. And the order impugned also is in the Lordship's court. Kindly make a note of it, my lord. 2nd March 2020 NCLT order resulted in 18th January 22 order of NCLAT. So 18th January 22 order of NCLAT is what the Supreme Court is saying, that the order impugned before us, which is NCLAT's order, it will not be guided. The disposal of 1038 and 1043 will not be as per the observations of NCLAT in 18 January 22 order. Now, what are those observations that they're talking about? All their arguments being shown today.
Yes.
So, Supreme Court could very well have said that we dismiss this. We understand that 1038, 1043 are pending on similar contentions. Means not by the appellants, but by the defendants who were the applicants before NCLT and who got the 325-page order. and therefore NCLAT need not proceed further with the appeals. Supreme Court did not say that. So therefore, 1038 is alive. 1043 is alive. Now, may I explain, my lord? Suppose 1038 succeeds. That means ArcelorMittal has to pay 1,300 crores to Hon'ble. Why? Because Hon'ble is the owner of the pipeline. How will we reconcile that with the lordship's order? Or will the lordship's order be taken to NCLAT, which is what they'd like to do, and say, oh, what are you saying? Look at Calcutta High Court. It has said pipeline belongs to SR.
Yes.
Please allow the appeals.
Yes.
Please set aside the order of 10 November. So, my lord, everything comes back to CAN 7 and FMAT 1310. If your lordships will not decide that, your lordship will allow court after court after court after court after court to be misled by statements at the bar that what is the meaning of the injunction.
Yes.
So please forget about the fact, my lord, that this, because this recall and that FMAT clarification, if I'm not wrong, maybe the FMAT 7 was filed before this recall was filed.
Yes.
So, my lord, let it not be a random chance that CAN X is taken up before CAN Y. I don't think justice revolves around a roulette wheel.
Yes.
So everything, my lord, please imagine how much time is being devoted by multiple courts by that one line issued by Honorable Calcutta High Court.
Yes.
That status quo and alienation transfer, and which now different songs are being sung at the bar by different counsels depending upon their mood of their client.
Yes.
Then, my lord, and I'll give these points, my lord, in bullet point form in writing so that I am.
No, we have taken note of it.
My lord is so busy with so many other
No,
multitasking
don't worry.
matters.
We have decided to invest time for this matter today.
Very well.
No difficulty.
Point 3.
No, point 6 you said, now point 3 more.
No, I'm reading this fresh note, Manoj. Then at the end I'll come back to that point 7, inexplicable order. It's a very important point.
Anything you can say. What more? What?
My lord, please don't. My lord, I am not here
Yes,
to
yes.
waste
What is
yes.
the other?
My lord, repeated this will come back to TDA versus Skipper, but with a different twist.
Correct.
Repeated reference has been made to the fact that the resolution plan has been approved by the Supreme Court.
Yes.
Repeated reference.
Yes.
As if that is the ultimate test.
Correct.
And now, once it's been approved by the Supreme Court, everybody hands off. Don't you dare question what the Supreme Court has done.
Correct.
I think that was Mr. Joy Saha's phrase. Would this court dare
No.
look into something approved by the Supreme Court?
Sorry. I think the word dare was never used.
Very well, my lord. I know. Anyway, so
At
if
least
my lord,
to my knowledge, sorry,
well,
or
my lord,
my remembrance.
all right, my lord.
Yes.
Politer version,
Yes. Whatever. I do not know. Anyhow.
but the same thing that would your lordships transgress
their-
authority?
Their argument was that the resolution plan was approved or approved and affirmed up to the Supreme Court. That
Yes,
was
that happens every day. Your lordship is aware of Union of India was a Ramesh Gandhi judgment
yes.
flowing from Calcutta High Court.
Yes.
Anyway, my lord, my proposition was if the plan does not contain an explicit reference to the pipeline being an asset of SR,
Correct.
has the Supreme Court anywhere in its judgment dated 15 November 2019, whether specifically or even by passing inference or reference, approved that the pipeline belongs to SR?
Correct.
Please show.
Yes.
There's nothing in the judgment of Supreme Court which said that it has blessed the idea that the pipeline belongs to SR. My lord, there is no way the Supreme Court could possibly do that. I mean, when the COC of SR is of the view that the pipeline belongs to Hon'ble, when the RP has been told by NCLT by order of 7 February 18 that the pipeline belongs to Hon'ble,
Yes.
when the bid evaluation advisor, Grant Thornton, whose now owner is now the RP of Hon'ble, has vetted the plan of ArcelorMittal and therefore could not possibly have accepted the plan built on the premise that the pipeline belongs to SR Steel. Can the Supreme Court not possibly say, in the teeth of your lordship's injunction, that the pipeline belongs to SR Steel? If so, please show. Please show the page para number of the judgment of the Supreme Court of 15 November 19. Since he wants to do a sir rejoinder, my lord, he may kindly make a note of that. Mr. Basu wanted to make a sir rejoinder.
Yes.
So, judgment dated 15 November 19.
Yes, yes, yes.
What are the
What
para
he will do, don't advise him. He will take care of his
Then, my lord,
client's interests. Yes.
the natural reaction of anybody trying to climb onto the shoulders of the Supreme Court for support in such a scenario where the Supreme Court judgment is silent would have been to immediately go back to the Supreme Court. Sir, your judgment is silent, but you meant that the pipeline belongs to me. Please issue a 2-line clarification.
Yes.
They don't go
Yes.
because they're afraid. If they go,
Yes.
and the 325-page NCLT order directing ArcelorMittal to pay 1,300 crores to Hon'ble is shown, and the reasoning is looked at, the Supreme Court might recall its own judgment of 15 November 2019, suo motu.
Yes.
In fact, my lord, let them go even now. We can go in for an adjournment in this hearing. Why, my lord, passing order before Jalpaiguri is not a priority. Accurate justice is a priority. Let them go to Supreme Court now. Get a clarification. We can defer. And if the Supreme Court clarifies that the pipeline is part of SRC, I'll withdraw my recall. No difficulty.
Yes.
So can we adjourn, my lord, and they can go to...
No, we will. As I said, I have invested the full time.
No, but it's not wasted investment, my lord. Whatever is argued will remain.
No. We want to. Yes.
Oh, I'm dying for it.
What is the next point?
Yes, my lord. Like getting a clarification from Supreme Court. Go to NCLT. After all, Supreme Court is mounted on NCLAT. NCLAT is mounted on NCLT. NCLT is mounted on COC approval. COC approval is mounted on resolution plan invited by RP, which is based on information memorandum. That's the chain. Go to NCLT Ahmedabad, get a clarification.
Yes.
That in this plan that you approved, you don't know what you are saying in 10th November 2020.
Yes.
I don't know how you passed this order of 10th November 2020. You please clarify that in your order of 8th March 19 approving the resolution plan, you always meant that the pipeline is part of my SR Steel. Where's the difficulty? My lord, Bharat Coking Coal, what does it say? Which is the judgment I'm relying upon in prayer B. It says that whenever there's some ambiguity in an order, you don't make your unilateral interpretations. You go to the court and you give your argument as to what, according to you, is the right interpretation. But then you leave it to the court to clarify what this order means. They don't do that. Even after 7th February 18, they never came back to your lordship's court to clarify the injunction. That please see, because the cryptic language used, please see the damage and harm being caused to us at NCLT, who's given us his order of 7th February 18.
Yes.
They didn't appeal that NCLT order either.
Correct.
So I don't understand, my lord. And then on top of it, my lord, then in that context, please see the refusal to file affidavit. And your lordship is condoning it.
Yes.
By condoning, I mean, your lordship is allowing arguments at the bar on facts in absence of affidavit, which is the very problem that existed in the CPAN leading to this order.
Yes.
Otherwise, had notice been issued on the CPAN, even if eventually dismissed,
Yes.
at least it would have been dismissed on an accurate basis,
Yes.
not on an erroneous basis.
Yes.
Then, my lord, I have already read out the order of 7th February 18. I'll not trouble your lordships again of NCLT Ahmedabad. But if your lordship may note the paras, my lord, 64, 70, 72, and 81.
Yes.
Actually, I am so sorry. I think my learned friend interrupted me. So I'll just finish the reading, my lord. I finished para 64. I read para 70. I was in para 72. But just to refresh, I'll refresh your lordship's mind on para 70. Para 70 said, it is pertinent to mention that the interim order had been passed by Honorable Calcutta High Court, restraining unwinding of BTA on the basis of cancellation deed. Unequivocal, my lord.
Yes.
No ambiguity.
Yes.
They may like it, they may not like it. If they didn't like it, they could have gone and appeal. But the language is very clear that Calcutta High Court has stayed unwinding of the BTA on the basis of the cancellation deed. Now kindly, my lord, see para 72 at the bottom. Minutes of the meetings of the lenders to applicant and respondent number 1 also show that there is no approval for rewinding and transfer of business undertaking pipeline from all the lenders, more so from respondent number 2. Therefore, pipeline remains the property of the respondent number 1.
Yes.
Again, my lord, unequivocal, unambiguous.
Yes.
Then in para 75, they say, in the case on hand, the cancellation deed was entered into between first respondent and applicant without approval of second respondent, despite the applicant having knowledge of the clauses that require approval of respondent number 2 for rewinding the BTA, which is IDBI Bank, which I said, my lord, is one of the biggest crooks in this transaction and was represented by learned senior counsel appearing for R1 to R11. Moreover, the first respondent also attacked the cancellation deed as stated in para 68 above. Hence, the decision relied upon by learned senior counsel for the applicant is not applicable to the facts of the case. Then, my lord, I'll straight away go to para 81, which is the directions now. In view of the above discussion, the following are the findings of the adjudicating authority. Number 1, adjudicating authority NCLT has got jurisdiction under section 60, subsection 5 of IB Code to decide the claims of corporate debtor, questions of fact or law, provided with such claims, questions of fact or law arise out of or in relation to corporate insolvency resolution process of corporate debtor, and that too for the purposes of resolution process, but not to grant declaratory relief to corporate debtor. Number 1. Number 2, very important, the title of corporate debtor over pipeline, corporate debtors SR Steel. The title of corporate debtor over pipeline is subject matter of civil suit number 177 of 2016 on the file of civil judge, senior division at Sealdah, filed by respondent number 2 against respondent number 1 and applicant prior to commencement of corporate insolvency resolution process, in which there is an interim order dated 22nd December 16, passed by Hon'ble High Court of Kolkata in CA number 11760, restraining, unwinding, it says rewinding, but I think it is meant unwinding of BTA and RTUA, which is enforced. My lord, please mark that phrase and RTUA, because if there is any ambiguity in understanding that there is restraining of unwinding of the BTA, the fact that the RTUA is enforced, which is the right to use agreement, how can a landlord have a right to use agreement for his own house with the tenant?
That you have said many times.
No, but
That's true. Anything, yes.
then
Something
it comes
more-
on.
You are in reply. Again, I'm reminding you.
My lord, I am on the protection of the dignity of this court.
Yes. So also you have to restrict your argument, because your
My lord,
argument
this is
must be
all,
restricted.
my lord, this
to
is
the
all
top
relevant
line.
to the widened
reply.
scope that they have created.
Yes.
Otherwise, this was a 5-minute argument for everybody. Nonetheless,
Yes.
then, my lord, but they clarify NCLT, because a lot was said by the learned senior counsel appearing for Hon'ble, that the right to use had to remain with SR.
Yes.
So now NCLT clarifies. However, for the purposes of CIRP and to clarify, resolution professional and resolution applicant, this authority gave certain finding views on the ownership of pipeline and effect of cancellation deed dated 24 June 16 in para 64 and 72 of this order, which are subject to result of civil suit. Now, the 4th paragraph is what protected the right of use. There is no hindrance for potential resolution applicant for filing resolution plan in view of right of corporate debtor to use pipeline under RTUA.
Yes.
That means anybody coming in to bid for SR Steel, why are you worried? It's not that the pipeline usage will not be available to you. The
Yes.
pipeline will be available to you. Keep paying 2 crores per day.
Yes.
That is a right to use agreement.
Yes.
720 crores per year. So your business will run.
Yes.
And 720 crores as rent is not a big deal, my lord, for a 4,000 crore pipeline, because the interest on 4,000 crores at 15% will be 600 crores.
Yes.
Depreciation will be approximately about another 400 crores. So if you own the pipeline, it will cost you around 1,300 crores. You're paying 720 crores. What is the big deal?
Yes.
It's better for you.
Yes.
And you await the outcome of the civil suit. If the court says, Sealdah court said that the pipeline belongs to SR, you are in any case paying the, if it says it belongs to Hon'ble,
Yes.
you're already paying RTU charges, which you're liable to do. And if it says that the pipeline belongs to SR, no problem. Hon'ble had paid SR 2,400 crores, which is not paid back.
Yes.
So this payment that you'll make of RTU will be deemed as part payment of the capital cost. So very balanced approach. So therefore, the affairs of SR will not suffer. RTUA is protected. Go ahead.
Yes.
And that is what the first learned senior counsel has been hammering repeatedly, that the injunction was intended to protect and preserve the right to use of SR Steel to use the pipeline, implying thereby as if SR Steel was the plaintiff. And that to obtain relief to ensure that it could keep on using the pipeline, it approached the Sealdah court, when that is not the case.
Yes.
SR Steel was trying to appropriate the pipeline,
Yes.
leading to SIFL going to Sealdah court and filing a suit that no, you can't take the pipeline. And it got an injunction.
Yes.
Injunction interpreted by NCLT in 7th February 18, reiterated in 10th November 2020,
Yes.
upheld by Supreme Court in 10th November 22, that yes, the 1038 appeal and 1043 will be taken to the logical conclusion, independent of the impugned orders.
Yes.
My Lord, I'm giving a citation. Union of India versus Ramesh Gandhi. The citation is 2012, 1 SCC 476.
Yes.
My Lord, much has been made that the matter has gone to the Supreme Court, and whatever word was used, which I heard that how dare, but whatever be the word, that now it's untouchable.
That you have already indicated.
But
That you have said
this-
that if it
this
is a
judgment-
fraud, if it is a fraud, immaterial.
But they
whether
don't
the
agree.
Order is
No,
affirmed
they
at
don't
the
agree. So
Supreme
I have to address that.
And it can be impugned before the court of first instance.
My Lord, but they don't accept that. So I have to.
No, it's not necessary. You argue whether they
I have
will
to
accept.
So
they
please
will
note on the
not accept.
citation, my
You
Lord.
argue the law straight away.
My Lord, kindly note on the citation
We have
2012.
said 2012, volume 1, SEC, page 476. What more?
I stand corrected, my Lord.
Yes,
And I'll give the list of dates for that.
not necessary anyhow.
The gist of it was
Yes,
the Calcutta High Court was approached with certain relief which went to the Supreme Court,
yes,
approved by Supreme Court.
correct.
Thereafter, a government company, I think something coal, Bharat Coal or whatever coal,
Yes,
it filed an application that, sir, fraud has been played.
yes,
This FIR should have been registered, And the High Court said, no, nothing doing.
yes,
Matter gone to Supreme Court. Now you go to Supreme Court.
correct.
So he took this order to Supreme Court.
Yes,
The refusal of Calcutta High Court to revisit an earlier order because it had gone to the Supreme Court, even though it was contended before the Calcutta High Court that what had gone before the Supreme Court and approved was by fraud.
yes,
Supreme Court then passed this judgment, which I'm relying upon, and whose list of dates I will give tomorrow, because it's a complicated judgment. And in that judgment, the Supreme Court chastised the Calcutta High Court that your approach is not correct.
correct.
Your approach is contrary to settled law.
Yes,
If a person approaches you alleging fraud in your passage of some order, even though that order may have been taken up to the Supreme Court, as long as the fraud was not in agitation,
yes,
you have a duty to re-examine your earlier order, independent of the fact that it traveled to the Supreme Court.
yes.
Same thing, my Lord, in A.B. Papaya Sastry. That also I'll give the list of dates tomorrow morning, my Lord, but the citation is
Citation is,
I'm just giving him all this. AIR 2007 SC 1546. Same issue. Andhra High Court taken to Supreme Court, then recall sought. High Court entertained the review because it was, shall we, appreciative of the law and recalled this earlier order. Then the recall of the earlier order was taken to Supreme Court. That how can the High Court recall as an order which has merged into Supreme Court? Supreme Court said nothing doing. There's no doctrine of merger when it comes to fraud.
yes,
And it upheld the order of the High Court, recalling its earlier order, which had been carried in appeal to the Supreme Court, which is identical to what is going on here.
yes.
Then, my Lord, the third citation is Kunaiya Ahmed.
2008, volume 5, SSC.
My Lord, I bow.
Yes,
I will not even try to find the citation. My Lord, kindly note, they will show your Lordship para 42 to 44 of Kunaiya Ahmed. They will hide para 14, sub para 4. Because in para 14, sub para 4, the Supreme Court has made it clear that a nullity will never merge.
Naya Ahmed is 2000 volume 5 or 8 SCC.
Well, that's very humble on the part of your lordship. The lordship normally remembers the entire.
No, now recently there has been a doubts created and the matter has been, I think, placed
But
before the larger
The
bench.
reference has been answered in a subsequent judge.
No, this is
Again,
answered subsequently. It
in
was
favor,
referred.
upholding the view in.
It was
Korea.
referred.
I'll give my lord.
I think I beat him to it, Malord. AIR 2000.
No, that is the 2000 volume 8 SCC page
I have the AIR version.
AIR.
AIR 2000 SC 2587 brackets 1.
Yes.
Now, my lord, the relevance of
on a
Kanai Ahmed.
question of merger.
Yes. Now, please note down, my lord.
It's 2000 volume 6 SCC 359.
That is a Kunai Ahmed. No, the later on it has been referred. I do not know answer. By a
Lord,
larger bench.
but your lordship must note this para 39 in Papaya Sastri. I'll read it out. It's relevant. Hopefully, it'll kill further arguments on doctrine of merger.
Yes.
Please allow me a moment, my lords.
Yes.
Yes, my lord. My lord, kindly note, I'm going to read out para 38, but the relevant part is 39. In para 38 and 37, they deal with Kunai Ahmed. Kunai Ahmed says this, doctrine of merger.
I am also. I know, but later on, very recently, it has been.
No, chamber, cannot be. The law is very clear in Kunai Ahmed. So in para 38, they said, the matter can be looked at from a different angle. My lord, this is the same issue. Andhra High Court, fraud, went to Supreme Court, review, sought, allowed, then challenged. The matter can be looked at from a different angle as well. Suppose the case is decided by a competent court of law after hearing the parties and an order is passed in favor of the applicant plaintiff, which is upheld by all the courts, including the final court. Let us also think of a case where this court does not dismiss SLP, but after granting leave, decides the appeal finally by recording reasons. Such order can truly be said to be a judgment to which Article 141 of the Constitution applies. Likewise, the doctrine of merger also gets attracted. All orders passed by the court's authorities below, therefore, merge in the judgment of this court. And after such judgment, it is not open to any party to the judgment to approach any court or authority to review, recall, or reconsider the order. Then para 39, the golden line. The above principle, however, is subject to exception of fraud.
No difficulty.
Malad, please, your lordship cannot imagine how many hours have been spent by, now I can't take names, but Solicitor General of India, ex-Attorney General of India, a dozen senior advocates arguing doctrine of merger.
Yes.
That even if there's fraud, you go to Supreme Court and explain the fraud. Why don't you go to the Supreme Court and explain the fraud?
Yes.
So if your lordships are clear,
Yes.
that's wonderful news, my lord.
Yes.
So this means
compliment or
it's a compliment and an expression of gratitude that now we don't have to dilate on something which has been dilated ad nauseum. In fact, when CPAN arguments were heard, this was the whole crux. That can this court hear a contempt of a resolution plan approved by Supreme Court?
Yes. Yes, next.
Yes, my lords.
Yes.
Yes, my lord. My lord, learned senior counsel who first argued the matter for Hon'ble. He repeatedly said that the injunction was only to ensure that the right to use would remain with SR. Now, if the right to use remains with SR, would that not mean, my lord, that he's saying that SR is the owner?
Yes.
My lord, I'm simple logic. Counsel says that the whole objective of the injunction, and is there in the transcript repeatedly, that the whole objective of the injunction was to ensure that right of use remains with SR and has remained with SR and will remain with SR. So where is the controversy? So if the right to use remains with SR, if the asset is SR's, the right to use remains with SR.
Yes.
But suppose the right to use is on payment of charges. Why are charges to be paid? Because SR is not the owner of the pipeline. Hospital is the owner of the pipeline.
Yes.
So again, we come back to CAN 7 and FMAT 1310.
Yes.
It's 19.4 SCC. But the larger bench decision is 2019 4 SCC 376. Khode distilleries.
2000.
19.4 SCC 376.
Larger.
Larger bench. Yeah.
2019 4 SSC. Page.
376.
No.
But this affirms the view in.
What is the cost title?
Khode distilleries versus.
Yes. Khode distillery. Now I remember. Yes, I have read that. Yes. Yes, completed.
My lord, now if it is argued that the my lord, please, I'm not.
No, we are not in hurry. Don't worry. We are here till the last.
My lord, if the argument is taken at face value, or what has been argued at the bar last time and today, that the injunction of December 16 was to uphold the transfer of June 16, then this becomes a very strange suit.
Yes.
SIFL is the plaintiff
Yes.
as a lender to Hon'ble, worried that its security is being attempted to be taken away by SR by the fraudulent rules of a cancellation deed, which is being signed on both sides by SR people. Please note that, my lord, the cancellation deed is being signed on both sides by SR people.
Yes.
So if he approaches the court for protection, is it reasonable to say that protection was granted for defendant number 2's benefit, SR's benefit?
Yes.
And if it was, since Hon'ble was supposed to be the recipient of RTU charges by the pipeline remaining its ownership, but being used by SR, from December 16 till 18, it keeps quiet. It then wakes up, why are you not paying me RTU charges? Starts writing letter after letter to the RP. I'm sorry, from 17 onwards. It starts writing letter after letter to the RP, pay me RTU charges. And the RP never says, no, I'm not going to pay you, but the pipeline belongs to SR Seal. Because implementation of the cancellation deed is an act of colossal fraud. It's accounting fraud. It's mortgage fraud. Because this means that banks who have lent money to Hon'ble, now there's no security.
Yes.
Banks go after the life of a person for a 10 lakh car loan if he sells the car, because they have no security. And banks will keep quiet on a 2,400 crore loan where the pipeline has been transferred out to the other company.
Yes.
This would be a fit case for a CBI investigation.
Yes. I think all the weapon in the armory has been exhausted.
Few arrows left, my lord. Then I come to the inexplicable orders.
Still few arrows are there.
Yes, my lord. Then, my lord, my English is limited. We learn my lord, my English is limited and we learn new things every day. To obstruct recall and thereby escape contempt charges, there's been repeated reference, again, starting from first learned senior counsel who argued for Hon'ble. There's been repeated reference to the phrase intended to be used by this court. Means not an express provision. It is merely the pipeline is intended to be SR. I don't know, my lord. This is a lady bearing a baby and going to come, I don't know, sometime in the future. What does it mean intended to be? Either the pipeline is or the pipeline isn't. And if the pipeline is contended by the respondent that it was viewed by this court that the pipeline was intended to be the asset of SR, then obviously this court cannot then be heard to say that there was an express provision for in the plan for the pipeline to belong to SR. Because if so, then it's not a question of it being intended to be. It is.
Yes.
So we come back to prayer B, my lord. So therefore, if the pipeline was intended to be an asset of SR in the resolution plan or in any other document, the lordship may please expand the order to just highlight what is that. Then, my lord, no assistance was forthcoming on the point that though there was repeated assertion, I think 6 times, that there was no false statement or there was no statement at the bar. Let's put it that way. There was no statement at the bar to the effect that the pipeline belongs to SR Steel. Then, my lord, then the question arises. It's settled law that honorable judges are not supposed to act on their private knowledge. My lords adjudicate a list. I present my case. He presents his case. Your lordship will verify the relevant materials. If something is permissible under section 57 of the Evidence Act, your lordship will take judicious notice of that and then deliver judgment.
Yes.
But then if they say no statement was made at the bar, then they should assist this honorable court that how did this honorable court form an impression that the resolution plan foreseed the pipeline to be an asset of SR Steel.
Yes.
Then, my lord, they've argued, perhaps taking a cue from your lordships, that is a technical contempt. I'm not aware of this phrase.
Relevant so far as a recall is concerned. Tell us whether
My lord,
the court
my lord,
can
if
go
your
into
lordship
all
did not
this.
check them,
I am again asking, there must be an argument to be to that effect. They have simply relied upon that what is the wrong in the order and why the recall is to be made.
it's there in the application.
So
Both issues they don't address.
they were referring those paragraphs or from the order itself. You have not made out a case like this. And again, I'm reminding you with the humility at my command, you are in reply. What they have argued, they have simply read out that this is the portion you have written in your order or a judgment. Where is the difficulty? That is what the argument is.
My lord, with the utmost of respect, if a man takes a judgment and relies on the judgment, it's his assertion of fact that what is stated in the judgment is true.
He say that where is a case of recall made out?
I'm answering that.
That where is
He is making an assertion that the pipeline belongs.
Reading out the portion.
I am sorry, my lord. I beg to differ with your lordship in the sense, if a man takes an.
There must be somewhere, some point of time, there must be something.
My lord, may I answer?
Yes.
May I answer? There's an order passed by your lordships.
Rightly, wrongly.
Exactly. Your lordship took the word out of my mouth.
If somebody is aggrieved by it, he can go higher up and get it.
But suppose somebody, I'll answer. Your lordship pass an order rightly, wrongly.
Yes.
And suppose your lordship passes an order wrongly, giving him undue benefit. One moment. No,
corrected there.
Please allow me to finish, my
Yes.
lord. Please allow me to finish.
Yes. So everything will be done.
Please allow me to finish, my lord.
Correct.
Your lordship passes an order
Yes.
in his favor on an incorrect factual observation. Allow me to finish, my lords. He does not challenge it.
Yes.
He's happy. Your lordship made a mistake.
Correct.
On a factual assertion.
Correct.
Then I seek recall.
Yes.
And he starts reading out passages of the order. He should be prosecuted for perjury.
That we'll consider. We'll consider that reading out the passage from a judgment is a perjury. Let us go to that height.
Yes, my lord, because
reading a judgment which a person perceived to be a wrong.
No, not he perceives to be wrong. Oh, no. Then let me explain again, my lord. Maybe I've not been able to convey. My lord, I presume that in your lordship's court, truth is paramount.
True, no doubt about it.
So then please allow me to finish. So if truth is paramount and your lordships have made a mistake, suppose, for example,
that's the matter between a person who is aggrieved.
Please allow me to finish. It'll be a test of your lordship's adherence to purity of truth.
True.
Suppose I have sold him a house for 10 crores and he's paid me 9.5 crores. He owes me 50 lakhs. And your lordship by error have written that I've sold him the house for 100 crores and he's paid me 95 crores and 5 crores is due. So it's an order in my favor.
Yes.
I am now to get 5 crores instead of 50 lakhs.
He will immediately come and
One
seek
moment.
for a correction.
One moment, my lord. Suppose he does not.
Why not?
My lord, I am giving you an example.
Yes.
And suppose I take resort to this order in other forum that look more 5 crores, Calcutta High Court has endorsed it. I'm a liar.
Then he is to be prosecuted for perjury.
He? Why he? No. Yes, in this case, he, yes. My lord, I'm very sorry, my lord. I don't seem to be getting through.
It is a typographical, arithmetical, ministerial error. There is nothing on that.
Sir, you have said the pipeline belongs to SR.
Let us see.
One moment.
Till this time, we have not said anything.
In your 13 March, you said.
That is what you read. Have we said anything as of now in a recall?
No.
We have not.
Your
Who is the best person to interpret his words? Who is the best person?
Your lordships.
Author.
Yes, your lordships. So what
So
I'm
that you are not permitting us to make what we intended, and we are arguing. Yeah, and everybody has argued. You have flagged an issue that what I perceive from this is a problem. That's all. Nothing more than that.
My lord, what I'm trying to say is that if a person tries to draw benefit of an error in
No difficulty.
let me
He
tell-
cannot reap a benefit.
I just want to say in one line, my lords, if a person draws benefit from an order which contains a wrong factual view reflected by the court, and he acts on that order, repeating that assertion time and again without owning up himself that the assertion is an erroneous, not assertion, the view is an erroneous view, he is liable to be prosecuted for perjury because he's making a false claim in court, punishable under 209. If your lordship says no, all I can say, my lord, I'm shocked.
Yes. No, I'm giving an example why I say so. If a court may be on some perception, has directed them to do a particular thing, maybe on an erroneous presumption, it's a mandate upon them to do it. If they flout the order, if they do not do it, then what will happen? Perjury 209, if they comply the order of the court.
That's different, my lord. Here he's
That is
taking
what-
advantage.
The law has to be judged from the different
I'm
parameters.
coming to that, my lord.
And you
I-
can't adjust the law.
No. Your lordship's analogy is wrong. Please, with due respect. I am giving the analogy where there's an order in his favor.
This is also against the Calcutta High Court's tradition.
My lord, maybe so, my lord, but I think there should come a time when a spade is called a spade.
Yes.
With the utmost of respect.
In a more articulate manner.
My lord, then I am lacking, my lord. I am lacking.
Anyhow, yes.
All I am saying, my lord, the order, if it is in his favor unduly, not duly. If the order is in his undue favor and he recites it again and again, he is liable to be prosecuted for perjury because he's taking advantage of an error of the court.
Dilate and digress from this. Yes, you complete the arguments. Let us finish off.
Then, my lord, coming back to technical contempt, there is no such thing as technical contempt. No, my lord, there's a reason. Please write down section 105 Evidence Act.
Yes.
This, my lord, is the general exceptions contained in chapter 5
Yes.
in the Indian Penal Code.
Yes.
Sections 76 to 106.
Yes.
IPC
Yes.
relatable with section 105 Evidence Act.
Yes.
Section 105 says, my lord, the burden of proving the case of accused comes within exceptions. And I'm drawing it to contempt.
Yes.
Because even if an order is violated, it is contempt, but it is not punishable contempt.
Correct.
The definition of contempt is a violation of an order willfully or deliberately. So if an assertion is made that someone has violated an order willfully and deliberately, the court will not take it at face value. The court will proceed, issue notice, hear the arguments. But if the court finds that the order has been violated, it is contempt, but is not punishable because it does not fall in the caveat pertaining to contempt that is willful and deliberate. So therefore, the exception, the explanation that though I have violated an order, it was not willful or deliberate, will be in the spirit of the general exception under the Indian Penal Code. That's what I'm trying to build the argument.
Yes.
And now please read section 105. It says,
Yes.
burden of proving that case of accused comes with an exception. When a person is accused of any offense, the burden of proving the existence of circumstances, bringing the case with any of the general exceptions in the IPC, or within the general exception, or within any special exception or proviso contained in any other part of the same code, which is IPC, or in any law defining the offense, contempt, where the definition is willful and deliberate, is upon him, and the court shall presume the absence of such circumstances.
Yes.
Now, the point I'm trying to make, my lord, if I assert that he's violated the order, I'm sorry, it may not be as per the traditions of the Calcutta Bar, but the court will be prohibited from entertaining objections to contempt at the bar without affidavit.
Yes.
Then, when the affidavits are filed, the general exception will be pleaded
Yes.
that either I did not violate the order,
Yes.
or I did violate it, but it's not punishable because it's not willful, deliberate, or Mr. Saha tried to take advantage on the last date of hearing when I said that please clarify in FMAT. He said, oh, if it needs clarification, then it's not contempt.
Yes.
So, lack of clarity of an order is a general exception to the law of contempt.
Correct.
But that exception neither can be presumed by the court, nor, my lord, can the exception be taken at the bar without affidavit.
Yes.
So again, coming back to the principles underlying the recall application, which are synonymous with the principles of adjudication on the CPAN, my lord, this approach of entertaining arguments at the bar without a party being an affidavit, my lord, in my understanding, is prohibited by law.
Correct.
My understanding, but we will learn from my lord's superior wisdom.
Yes.
No, I'll tell you.
We are here up to 10 o'clock in the night. Don't worry.
My lord, if
We
you
are
didn't
not
get,
in hurry.
my lord, in a lighter vein, if your lordship would not offer us tea, there's no
Uh-huh.
hope for dinner.
No. Don't worry.
So,
Don't worry.
my lord, and contempt proceeding by virtue of Sahadeo versus state of UP, which your lordship has referred.
Referred.
Yes, your lordship has referred.
Yes.
Therefore, my lord, the provisions of section 105 Evidence Act will apply. The general exception, if to be claimed, will apply. Onus is on the person accused,
Yes.
and the court shall presume the absence of such circumstances. But, my lords, unfortunately, this honorable court has not presumed the absence of such circumstances.
Correct.
And
Yes,
I
sir.
again, well, I tell your lordship when I finish, please. I'm getting a little nervous now, my lord. Each time your lordship, oh, I wonder what's coming. Then, my lord, please make a note of this. Your lordship will kindly decide the issue of demurrer, because if they are on demurrer, I'm asking for conviction for contempt of court. No, but then, my lord, it cannot be that a lordship will pass judgment without hearing arguments on demurrer. Then the matter has to be argued properly.
Demurrer.
My lord, your lordship's judgment
They have
says,
taken a point of demurrer that the applicants have no authority locus standi to maintain.
that's not demurrer alone, my lord. With due respect, just allow me to please present.
Yes.
Could your lordship peruse those written submissions I sent across, my lord,
Yes.
on the academic side?
No. I have gone through that.
No substance?
No. To some good, just to
therefore-
have the idea.
So therefore, worthy of debate, my lord, or not really waste of time?
Anyhow, I do not know because
Because,
we have to. look
Demurrer
it in a
will
very
not ap-
neutral manner.
my lord, with due respect, all these lawyers, with the utmost of respect, are civil lawyers.
We are very civil.
Phil. He beat me to the punch. Demurrer applies in civil proceedings. And your lordship has already observed in the judgment on the CPAN that they are on demur. I don't know, maybe that's the convention in Calcutta High Court. In criminal proceedings, my lord, there is no demurrer. If your lordship and wish to import principles of civil demurrer, the phrase is nolo contendere. no contest.
Yes.
So no contest means I've done it. Let's go forward. I will aim for acquittal.
ঠিক আছে. Yes.
So in those notes, in those notes, my lord will find all this. In civil law, even assuming that there is a demurrer, it does not mean what they are implying what it means. And what they're implying is, oh, assuming without admitting that what you have said is true, but you are not entitled to the relief. Demurrer means, my lord, taking what you have stated to be true, or whether it is true or not, I waive my right to contest.
Yes.
But I will defeat you even despite that. That is demurrer. So therefore, they have admitted, assuming demurrer applies. My lord, assuming demurrer applies, which I respectfully submit cannot apply to a criminal proceeding. To a criminal proceeding, all will apply will be nolo contendere. No contest. So if that be so, then please make a note of them, Lord. Can 13 now does not seek recall.
Yes.
Can 13 seeks conviction and CPAN, which means implied recall.
Yes.
Recall 13 March, they were admitted to the act of contempt because they were on demurrer. Please convict them.
Yes.
So if your lordship would like to hear the extended debate on demurrer and can 13,
We know how to deal with the demurrer in a civil perspective.
but this is not a civil proceeding.
Correct. Civil contempt.
No, but civil contempt does not mean a civil proceeding, my lord. Contempt is punishable by imprisonment.
Even under the civil procedure code, decrees are executable. Person can be put into a civil custody, jail.
Well, no, that is true. It's actually, this is an interesting observation. We've argued that once before the division.
That is the code of civil procedure. There are provisions.
I'm coming to that. Not every proceeding under CPC is civil, and Order 39 Rule 2A is a perfect example. Violation of an injunction. It's a criminal proceeding.
Anyhow.
Similarly, not every proceeding in the CRPC is a criminal proceeding. 340 is an example. Your lordship may be surprised. A review under Order 47 CPC will lie against an order passed under Section 340 CRPC.
If it is a criminal proceeding under Order 39 Rule 2A, then against an order passed under Order 39 Rule 2A, the appeal under the Code of Criminal Procedure is
Exactly. Now, my lord, take the example. Your lordship said.
And why Order 43 Rule 1R is introduced in CPC? Which
Lord,
says that it is an appellable order.
My lord, there is no way I can match your lordship in the CPC, so I will not even try. I have these little windows, little pockets that I have learned.
Anyhow, finish it. Anyhow, please complete it. Yes.
So, my lord, they are on demurrer. It is my respectful assertion that your lordship may proceed on the premise
that you have said that the moment the plea of demurrer is taken, that means they have no defense so far as the merit is concerned. They are sure that this point of demurrer has to be decided.
No, my lord, that's not my case of demurrer.
Not.
Demurrer is of two parts.
Yes.
One is I accept what he's saying.
Yes. And second one is that without
I don't care whether he's right or wrong.
Yes.
I'm waiving my right to contest it.
Yes.
Because to surrender a right
Correct.
is a right.
Correct.
So if a man has a right and he's surrendering his right to contest, his choice.
Yes.
That is demurrer. But demurrer will not apply to a criminal proceeding. It is nolo contendere. No contest. That means he's admitted. He's not contesting the facts asserted against him.
Yes.
So your lordships would be obliged, if I may use the word, to act on the premise that all that has been stated has been admitted.
Yes.
Or all that has been stated has been agreed to, the right to contest has been waived.
Yes.
Because, my lord, that is why Order 7 Rule 11 has been introduced to replace demurrer.
Yes.
But if you don't choose Order 7 Rule 11, and if you take demurrer as your stand, you are preparing for your funeral as far as the facts are concerned.
Correct.
Now,
Yes.
I mentioned that Justice Bose's judgment was per incuriam. Please allow me. This is the judgment that he went against.
Yes.
Kindly come, my lords, to the para 10. Probably the
Yes.
first thing, fifth, sixth page,
Yes.
the underlined portion. Even I have no doubt or hesitation. My lord has that?
Yes.
Even I have no doubt or hesitation in my mind about such principle by whatever name it may be called, referring to demurrer. Similarly, I do believe that the explanation as made by Mr. Bakshi in this case is not very clear. The principal point is demurrer as a preliminary issue can be decided at the earliest when there is no need of investigation of fact. Such analytical aspect of the judgment has to be appreciated. The real import is that when there is availability of two possibilities, the point of demurrer cannot be decided as a preliminary point, but derived from the analysis of evidence. But when there is no question of two possibilities, the point of demurrer can be taken as a point of law, and it has to be determined as a preliminary point. Now, my lords, please come back to the phrase, the real import. But that is the crux. The real import is that when there is availability of two possibilities, meaning on facts, not on law. Now, my lords, kindly have the CPC Order 6.
Yes.
I believe Rule 3, Rule 4.
Yes. What?
CPC Order 6?
Yes. What? What for what?
Oh, no, to show that if you don't file an affidavit, what's the implication?
Oh, that's true.
No, but then your lordship is not abiding by that.
Yes, you come. Order 6 rule.
Rule 3 or 4, my lords.
Yes, 4, 3.
I hope your lordship will not give me a bashing in open court.
It is a form of pleading, particulars to be given.
I'm coming to that, my lord. Just allow me a moment.
You are talking about Order 8, evasive and no denial. Yes.
It should not be evasive and specific denial.
Absolutely. Order 8.
So therefore, when there is no affidavit in rebuttal, and please note one more distinction, my lord. Here is not a case of pure demurrer. Here is not a case on opening day. They said, we don't want to file an affidavit, we'll argue.
Yes.
They said issue notice. So now demurrer is out of the window. Now they'll get covered by Order 6 CPC. They wanted an opportunity to rebut an affidavit. But then they don't rebut an affidavit. Now, he who does not rebut an affidavit, my lord, is a settled law of pleadings. He who does not rebut an affidavit is deemed to have admitted all that has been asserted against him, though the court still may not grant judgment on admission and may require the facts to be proved by the asserting party under Order 12. Rule 6, I think.
So we got it. We got this point that since they have not rebutted the statements or the averments made in the application, it will be deemed to have been admitted by them, and therefore the court should proceed on that basis.
And my lord, I forgot though, the reason why I said that Justice Bose expected what he said was after 15-20 days, he says, in a lighter vein, we were winding up the court that day. He says, I was inclined to agree with you, but then I didn't want to change the practice. So I thought, let's leave it to you to appeal. I'm surprised you didn't appeal.
Yes.
Because those written submission, my lord, we traversed a lot of foreign law as well.
Yes.
Where the concept of demurrer has been formally abolished.
Yes.
And that is why there's no, if a man's if he insists he's on demurrer,
yes,
he cannot say, I do not admit. He admits, or he's waived his right to contest.
Yes.
I'll just say it once again, my lord. This court ought not to have any hesitation in viewing contempt to have been committed if it indeed has been committed simply because the resolution plan has been approved by the Supreme Court, but without any assertion.
Question on the ownership,
Yes,
no difficulty.
because that, my lord, will be a classic case of fraud.
Yes.
And doctrine of merger, they can sing as many songs, Kunaiya Ahmed, here, there, everywhere. Sorry, my lords.
Yes.
Your lordship's hand will not be tied, but your lordships would be bound to examine, notwithstanding approval by Supreme Court.
Yes. Thank you.
I haven't finished.
Yes, Peter Rakku, we are coming within 5 minutes. We'll dictate the judgment in the open. It will take 1 more hour. We'll dictate the judgment in the open court on no, nothing. Yes. Yes. We are just coming within 5 minutes. You can also have a cup of tea.
Grateful.
Chalo.
My lord, may I have your lordship's kind leave, my lord, to mention, my lord, item 1 of original site list, my lord.
Sorry,
My lord,
we are not applying our mind, we are applying our
my
mind.
lord, kindly let the matter appear tomorrow. Only with that prayer, my lord.
Sorry. Yes,
My lord, time has expired, my lord. Let the matter appear tomorrow.
Canton only.
Can I just
No, no,
my point 7, my lord?
no,
Inexplicable orders.
no. We are concentrating on 10. Therefore, a disquiet litigant is beleaguered between the scope of recalling an order passed on contest and the order to be revisited on a perceived fraud played upon the court at the behest of the appearing counsels on the other side. The contempt application was taken out by the applicants in a different nomenclature, and a plea of demurrer was taken, which is akin to a plea of locus standi to maintain the said contempt application, and was decided by this court in an order stroke judgment dated 13th March 2023. A practice has developed at the bar in making an extensive arguments, sometimes dehorse the pleading, sometimes by filing the documents and several applications, treating the same to be a part of the record and perceiving the same to be an integral part of the pleading. So as to postpone the disposal of the main matter on its merit. Even after the judgment is passed on contest, the application to recall the said order is taken out on the ground that there has been a fraud committed upon the court in relation to certain observations made in the said judgment. Full stop. There is a clear distinction between a recall of an order / judgment and a review of the order / judgment. The review has to be entertained on a well-defined parameters enshrined under Order 47, Rule 1 of the Codice Procedure. On the other hand, the recall to a contested order has to be decided in a limited sphere, and should not be permitted to expand the horizon of the rewriting and or reappreciation of the facts, as its applicability is within the limited contour envisaged under the law. To stop. The moment the plea of fraud is taken, it admits no ambiguity that the court always visualize the same as a serious matter, as the persons who have been instrumental to commission of the fraud should not be permitted to reap the benefit thereof. The fraud unravels all things, and even can be taken in a and a plea of fraud can be taken in a collateral proceedings. Mere using the expression, the word fraud is not sufficient enough to constitute the same, as the law of pleading incorporated under Order 6, Rule 4 of the Code of Civil Procedure provides the particulars thereof to be succinctly narrated and or jotted down with precision and clarity. The judgments have been cited on the consequences of fraud to which we do not feel any dissent thereupon, as the fraud is always considered to be a ground not only to impinge the action of the parties, but have its equal application in a judicial parlance. The moment the fraud is alleged in relation to a judgment and order passed by this court, the court always took it seriously in order to ascertain whether there has been any fraud committed by the parties or any such fraudulent act has been done in course of the dispensation of justice. It would be an ideal exercise to recapitulate the law laid down on the concept of fraud as all the judgments are uniform in the uniform in the context that once the court finds that the fraud has been practiced, there is no fetter on the part of the court to recall the order, as dispensation of justice is the hallmark of the judicial system. The court should be conscious when a recall is intended on a alleged fraud and would refuse to exercise its discretion if there is a lack of element of fraud, or the real intention is to invite the attention of the court to various observations which may sometimes be factually incorrect or arrived erroneously. Stop. The moment the element of fraud is lacking and the hidden intention is to reopen the entire case in the garb of a so-called fraud, by creating an illusory cause of action with the clever draftsmanship, the court should nip such a litigation in the bud. And in this regard, the celebrated observations of Justice Krishna Iyer in case of T. Arivandanam versus T.V. Satyapal and another, reported in 1977, volume 4, SCC, page 467. Is required to be recapitulated, which runs thus. Quote the relevant portion, which runs thus within courts. The London Munsif must remember that if on a meaningful task, not formal task, reading of the plaint, it is manifestly vexatious, and meritless, in the sense of not disclosing a clear right to sue, he should exercise his power under Order 7, Rule 11 of the court, taking care to see that the ground mentioned therein is fulfilled. Full stop. And comma, if clever drafting has created an illusion of the cause of action, comma, nip it in the bud at the first hearing by examining the party searchingly under Order 10 of the CPC. Full stop. An activist judge is the answer to the irresponsible lawsuits. Full stop. Unquote. An argument is sought to be advanced that the moment a plea of demurrer is taken, it invites two eventualities. Firstly, such demurrer would defeat the right of the parties to contest the issues involved therein. Secondly, it is a conscious decision of the party not to answer the issues and impolitely abandoning the same, as he is confident on the plea of demurrer that would defeat the cause. It is sought to be contended that the plea of demurrer having resorted to would lead to an inescapable conclusion that the contesting party have either no answer to the issues raised therein or have consciously abandoned the issues, to abandon their right to contest such issues. And therefore, the statement must be taken to be true and sacrosanct. We are unable to comprehend such conception of law for the simple reason that a plea of demurrer available to an adversary is one of the tool for defeating the legal proceedings, but can never be expended to deny the right to contest the proceedings, nor would be construed to take away such right in the event the point of demurrer fails. There are various facets of the demurrer. Sometimes, semicolon, sometimes it is purely a question of law on the basis of the facts pleaded in the plaint. Sometimes it is a plea on fact lacking a clear right to sue or non-disclosure of the cause of action for the reliefs claimed therein. The plea of demurrer has been advanced by a passage of time in the Indian judicial system by insertion of various provisions under the codicil procedure. Stop. It would be preposterous to suggest that the plea of demurrer, as envisaged under Order 7, Rule 11 of the court, has to be construed in such a manner as it would be opposed to the legislative intent behind the incorporation of such provisions. The moment the plea of demurrer is taken, the same is required to be decided on the facts emanates from the proceedings before it reaches the stage of being decided on merit. And even if the plea of demurrer fails, it does not take away or denude the adversary to contest the proceeding on merit. Stop. It is a misconception in the minds of the petitioner that the moment the moment a proceeding is initiated before the court, it has to be decided after giving an opportunity to the other side to controvert the statements and or allegations made therein, as it is a primary duty of the person initiating a proceeding to prove his own case. And have to pass the muster of maintainability of the said proceeding at the first. Stop. A plea is taken by the other side that the applicants of the instant application cannot maintain the same, which would be evident from the cost title of the said application. It is sought to be contended that somewhat identical cost title was depicted in an application for contempt being within bracket CPAN 1922 of 2022, and a point was raised as to whether the persons shown there in as petitioners can maintain an application for contempt by an order dated 13th March 2023, the court has held that the applicants of the contempt applications are not entitled to initiate a proceeding, nor can maintain an application for contempt after considering the various provisions of the Act and the rules of this High Court framed in this regard. The identical plea has been taken in the instant application, as there has been a little variation in the description of the petitioners. Stop. The applicant of the instant application now are described as under, please quote from paragraph page 35 and 36. Where is the original contempt application? The applicants of the contempt application appears to be identical except its representation. Manifest from the quoted portion as above. In the judgment and order dated 13th March 2023, this court held that the petitioner number 1 this court held that the petitioner number this court की बोले that the petitioners of the petitioners of the contempt application have cannot maintain the said application in a capacity of in the name of the trust without the trustees having impleted therein. The instant application is filed by the same trust acting through a shareholder of the trust having 52% contributory in an India Growth Opportunities Fund and Stray Industrial Finance Limited within bracket karo Stray Infrastructure Finance Limited acting through a person who claims himself to be the shareholder stop. A plea is taken that so far as the Stray SIFL karo, so far as SIFL is concerned, his dues have been cleared off and there is no due to.
Interest was not paid. That was a false statement. Interest was not paid. Running to
Whatever,
crore,
dues have
hundreds of
been
crores.
cleared off. There is no as on the date and therefore cannot have any grievance. On the other hand, the applicant says that the interest component has not been paid. Be that as it may, it is a public company incorporated. It is a publico corona. It is a company incorporated under the Companies Act 1956. And it does not appear from the averments made in the instant application that the person who claims himself to be the shareholder have been authorized. However, it is averred in the said application that the said shareholder is aggrieved both in his individual capacity as well as in the capacity of a shareholder, but did not specify the percentage of holding of such shares therein.
Your Lordship may assume one share, my lord. From the legal perspective, you may assume one share.
Mr. Counsel.
I don't have to state.
Mr. Counsel.
My lord, with due respect, your
Mr.
Lordship
Counsel,
truncated my arguments.
Mr. Counsel, it is not expected from the member of the bar to interfere at the time of dictation.
I respect them.
You have completed it.
No, my lord.
It is
I-
now
not
the
right.
turn of the judge.
My lord, with due respect,
No,
your
sir.
Lordship truncated my arguments. I got
Please.
my bullet point list.
Please, what I have said is this. I am taking their point of demurrer.
And I have to come back. This is
Please,
my list.
I have listed from 1.2, paragraph 1.2, what you have said
My lord,
in the
all I-
application.
My lord,
Please.
all I'm trying to say is
No.
you truncated my
Mr.
arguments.
This is a last request to you. not
If
interfere.
your lordship is determined to pass an order in
No,
a certain
please,
manner,
we are. You can't interfere during the dictation.
I don't want to interfere.
You are interfering.
I'm simply
Sorry. After the completion of the dictation, you can say that something is omitted. But you
my
can't in the
various
mid-
points have
It
not been
really
answered.
disturbs the flow of mind.
I
When you
apologize,
are
Lord.
being distracted by them, you say my flow of minds, I lost. So please do not interfere.
Very
in
well.
this.
I'll finish my arguments after the orders
Sorry.
vacated.
Sorry, we can't. You have finished your argument?
I have not
Enough
finished.
of
I
it
have
has
not
been
said I finished. Your lordship truncated me.
No.
I'll show my list.
Sorry, you can't. We have heard you for what?
That is not the point, my lord.
No,
I've got
sir.
my list of
No,
points that I
sir.
have to address.
No, sir. No, sir.
Very well, my lord. My lord is determined to pass an order in a certain manner. Very well.
No, sir.
Please.
This is not expected.
Very well.
Yes. Yes, কি বলেছি? There. It further appears from the pleading that the said shareholder No, it further appears from the Kibalichi, from the pleading that the SIFL is also claiming a derivative rights through its shareholder and intended to invoke the provisions contained under Article 215 of the Constitution of India as a court of record. And further asserted that the court can act suo motu if the court found that its records are not correct. It is no longer res integra that the High Court is a court of record and have been bestowed power to punish for its contempt. The moment the court finds an erroneous findings, the moment the court finds that there is an error apparent on the face of the record, in order to correct the records, such constitutional right can be activated, and we do not find any quarrel to such powers enshrined under the aforesaid article. The moot question arises whether there has been a case made out for putting the record straight or correcting the error manifest from the record. Stop. As indicated above, in absence of any disclosure of the percentage of shares held in SIFL by the LS shareholder, and when the company itself does not intend to proceed with the litigation, nor have authorized such shareholder to do so, we do not find that an application can be maintained at the behest of such shareholder. However, a point is sought to be taken that Order 1, Rule 8, capital A of the Code of Civil Procedure imbibe within itself every person interested on a question of law can be permitted to participate in the proceedings, as such question of law is would affect the public at large. We find that the aforesaid provisions though relied upon by the applicant cannot be applied in the present case. The said provisions provides that while trying a suit, the court may, if satisfied, that a person or body of person is interested in any question of law which is directly and substantially in issue in the suit, and that it is necessary in the public interest to allow that person or body of persons to represent his or its opinion on that question of law, permit that person to present such opinions and to take part in the proceeding of the suit as the court may specify. It applies in a special circumstances where a suit between two litigants involves an issue which may have a larger effect on the public, but does not clothe any power upon such persons to take a action upon, to take a responsibility upon itself. And the proceeding between two individuals are diverted in the hands of such person, and the orders passed therein is amenable to be recalled and or challenged by a third party in a court of law. It has a restricted applicability on the question of law, which again must be directly or substantially an issue in the suit and having a larger impact on the public. And therefore the court may take an opinion of such person and may also permit him to participate in the proceedings. In our opinion, such provision is misplaced in the context of the instant disputes, and therefore such applicant acting through the shareholder cannot maintain the instant application to recall an order passed on contest though we may not have ventured to proceed further after having held so, yet we feel that we will be failing in our duty if we do not address the issue sought to be raised in the instant application. The application running into several pages is intended to recall the order dated 13th March 2023 acting suo motu, being a product of fraud played by the respondents upon the court on the basis of the false statement made orally across the bar. Which is reflected in paragraph 25 of the said judgment. The core issue raised in the instant application is that the court that a serious fraud has been played upon the court by the respondents, which led to the finding in relation to the ownership of the pipeline. It is contended that the resolution plan never imbibe within itself the rights of the parties thereto over the pipeline. And therefore, such finding that the pipeline belong to the respondent number 34 therein is an act of fraud. And therefore, the court should recall the entire order. The argument on behalf of the respondents are uniform in this regard, that such finding cannot be construed to have declared the right over the pipeline as the entire, as the sentences comprised in paragraph 25 has to be read conjointly and should not be read in isolation of one another. A further argument is advanced that even if the said finding is taken out from the judgment, the other findings which are independent can withstand, and there cannot be any incongruity or inconsistency therewith. The counsel for the applicant has taken an exception to the aforesaid submission and persistently insisted the court to arrive to read the said finding as an act of fraud, declaring that the pipeline is under the ownership of the respondent number 34, which is a blatant, which is an apparent false statement. As the stand of the parties in course of the proceeding would reveal that such pipelines is still a subject matter of dispute, as the respondents have in fact prevaricated their stance at different stages. It is sought to be contended by the counsel for the appellant that in absence of any document, more particularly the resolution plan, the court cannot arrive at such finding, as the court cannot base its decision on its personal knowledge, but must be guided by the pleadings and the documents filed in the proceedings. Though it has not been argued by either of the parties, the first and foremost question involved in this regard is whether there is any finding made by the court in the said paragraph 25 of the judgment dated 13 March 2023 that the pipeline is owned by the respondent number 34, or it is a mere observations not touching upon the merit, but based upon the perception of a judge in delivering the judgment. It would be apposite and profitable to quote the observations made in paragraph 25 of the judgment dated 13th March 2023, which runs thus. It is no longer res integra that while interpreting a judgment or considering the error having made by the court, the judgment has to be read as a whole and not in the piecemeal. The court should deprecate segregation and or culling out one sentence out of the context and interpret the same in a manner never intended by the judge in the said judgment. The sequel of the events narrated in various paragraphs of the said judgment has to be read conjointly with the paragraph 25 onwards. And in the event it is found that the said finding is perverse and based on no material, there is no impediment on the part of the court to either correct the same or to recall the order. It is no doubt true that the resolution plan was approved by the NCLT, affirmed by the appellate tribunal, and ultimately reached to the Supreme Court. And the challenge to the same was futile. This, in the said paragraph, the court recorded that the resolution plan so approved was duly implemented by the parties. And it was further said that it would reveal from the said plan that the aforesaid pipeline was always intended to be the property of the respondent number 34. And after approval, of the resolution plan, recognizing the LS contender number 34 as successful resolution plan applicant. Thereafter, the court proceeded that no further deliberation is required, as the order approving the resolution plan was affirmed up to the Supreme Court. And therefore, within courts, whatever has been expressly provided therein is binding on the parties. In paragraph 24 of the judgment, this court found that the entire allegation running into the several pages was founded on the assertion that the moment the pipeline was transferred to the petitioner number 1 by the LS contender number 34, and the deed of cancellation being the subject matter of suit in the Sealdah court, was subject to the approval of the lender and the stakeholder, the same cannot be regarded as a complete transfer of the said pipeline, and therefore was not given effect to at any point of time. The court further records that the cancellation deed is the subject matter of the suit before the Sealdah court, wherefrom the appeal originated, and an order of status quo with regard to transfer or alienation of the pipeline is passed therein. Such observation does not, in our opinion, declares any right of the parties, nor can be said to have created any impact on the right of the parties, as what is provided in the resolution plan approved up to the Supreme Court binds the parties thereto. In the event the resolution plan does not contain any amendments or the rights of the parties over these said pipelines, such observation cannot be regarded as a foundation of the entire judgment. Stop. Furthermore, the language which was used was that what the court perceived as the perceived from the conduct of the parties, and cannot be regarded as a conferment of any right, deholds the rights recognized under the resolution plan. Otherwise, the next sentence used in the said paragraph would be rendered meaningless and or osseous. It would not be incorrect, in our opinions, what we gather from the stand of the applicant, that the instant application has been taken out to achieve a thing which cannot be, to achieve a thing indirectly, which cannot be achieved directly. What is intended by filing the instant application is the revisitation of the judgment rendered in the contempt application, and any findings incidentally or accidentally made in the instant judgment to take advantage thereof, which in our opinion should be deprecated. Full stop. We have indicated in the judgment dated 13/3/2023 that the words of inconsequential significance is being projected, and the time of the judicial hour of the court is consumed at the expense of the other litigant who have an equal right under the Constitution to have their matter disposed of at an earliest. The manner in which the argument is advanced, it leaves an impression in us that a desperate attempt is made to have the order reviewed in the garb of a recall. Stop. We do not find any element of fraud, either from the pleading or otherwise. Stop. As indicated above, slew of litigations are filed after each days of hearing, culling out something from the submissions advanced at the bar and inviting the attention of the court to invoke and activate the process under the criminal law. Even a live streaming, which has started with the award object, is being misused and or abused, despite the disclaimer having been shown therein. Every bit of the interaction in course of the hearing is being taken as a sacrosanct and a part of the and as a part of the affirmative stand of the parties. Full stop. The disclaimer would reveal that no person shall be allowed to record the live streaming, which is primarily aimed to make aware of the common man of the country to understand the mannerism in which the proceedings are dealt in the court and the procedures adopted. It further aimed to bring transparency and fairness in a journey of dispensation of justice, but can never be abused and misused to such extent. To stop. We do not intend to say any more words and leave it to the wisdom of the respective members of the bar to ponder upon the same, as we still have a fond belief that the live streaming may bring a radical change in the court system, and may also percolate the awareness into a common people. on the nuances of the procedures adopted in this regard. The erudite submission was advanced at the behest of the counsel for the applicant on a proposition of law that any act done on the teeth of an order of temporary injunction is always regarded as illegal and should not be permitted to continue, and there is no fetter on the part of the court to put this to put the parties to a to a position prevalent at the time of passing an order of status quo. As indicated above, we do not as indicated above. Firstly, the contempt application was dismissed on the ground that the applicants / petitioners are not entitled to maintain the same. Even the court has considered whether there is any element. Even a court considered whether the court should initiate a suo motu contempt application, contempt proceeding, treating the petitioner as an informant, and ultimately did not find any merit therein and dismissed the said application. It cannot be the applicant cannot be permitted to take a circuitous route and approach the court to reopen the entire issue already decided. By engaging a counsel who in his rhetoric invited the court in every bit of the merit of the case. We thus do not find that it is a fit case where we should recall our order. However, the conduct of the party would not deter us from imposing a cost for unnecessarily inviting the court to invest the time on such frivolous allegation, on such frivolous points. Stop. We therefore dismiss the said application. We therefore dismiss the said application with the costs assessed at ₹5 lakhs to be deposited with the State Legal Services Authorities, West Bengal, within 2 weeks from date. Stop. In the event of the deposit of the said amount, the same shall be invested in an account maintained for juveniles and shall be utilized for their betterment.
Lord, may I make some submissions now?
Yes.
If your lordship could also please deal with prayer. If your lordship could please deal with prayer B.
Yes, suo moto we have dealt with.
No, prayer B has not been addressed.
Yes. Oh. What is the prayer B? Now, what is prayer B? কোথায় দিয়েছে দেখি?
To please amplify the order that if there's no fraud and it is a fact that the pipeline is a part of the resolution plan.
After the judgment was dictated, the attention of this court is drawn by the learned counsel for the applicant that the instant application contains two prayers, one substantive, other in alternative, which should not be construed in such fashion, but be treated as a substantive prayer. Addition to the going by the language used in the second prayer, having made in alternative, the applicant invited the court to act suo moto in alignment with the views of the Supreme Court in case of State of Bihar versus Bharat Coking Coal Limited, reported in 1987 within bracket supplementary SSC page 398. Relatable to a duty of the court of records under Article 215 of the Constitution of India to make correct and accurate records and to make a reference of the documents. As indicated above, the parties in the proceeding have resorted the procedure in taking out slew of little applications, disclosing certain documents, and inviting the court to consider each and every document, whether having any relevance to the core issue or not. The manner in which such prayer is caused, in our opinion, is intricately related to the substantive prayer made therein, and the points have already been addressed in a preceding paragraphs of the instant order, and therefore we do not find that any further deliberation is required thereupon, more particularly when we held that the applicant of the instant applications cannot maintain the same. Yes.
My lords, I have some submissions in this regard.
You can't. After then you make your submissions, conserve your energy, and
I have plenty of energy. But no, my lord, I am not going to go to the Supreme Court yet.
No.
We will examine our options. My lords, I had given 19 contentions.
Nothing.
My lord,
we have recorded.
Allow me to just speak, and then you can keep rejecting each one. No problem.
No, we don't. You can't dictate like
Not
this.
dictate, my lord.
What? No, sir. Please,
My lord, I am
there must be a
sure,
limit.
my lord, I am sure your lordship is not predisposed to
No,
take a
definitely
certain
not. We have kept always our mind open.
Secondly, please record my submission.
We have done it. There
is no
may not be in the same language as you
No
understand,
difficulty,
as
my
you
lord.
are
No,
saying.
my lord.
but
No,
we
my
have-
lord.
we have
Please
considered-
record my submission that your
Sorry.
lordship would not have jurisdiction to impose costs.
Sorry.
Please record my submission. My lord,
The imposition of cost is with us.
that's right. So I'm respectfully submitting to your lordship that your lordship do not have the jurisdiction to impose costs.
Jurisdiction.
Secondly, my lord, yes, your lordship do not have the jurisdiction under the Contempt of Courts Act to impose costs. Secondly, my lords, your lordship is referred to abuse.
Yes.
My lord,
No, it a can 10.
my lord, your lordship has referred
Arvichuda.
to.
my lord,
No, that is what we have used.
No,
the
so kindly
language.
amplify, my lord. What is the abuse?
Do
My lord,
not
last thing.
address-
My lord, last thing, please.
My lord,
CPAN, if your lordship can kindly direct for listing of CPAN 434 of 2023 tomorrow.
that we can't do it.
my lord, consequently, my lord, the two other
Well,
CPAN
then
should
please
also
at
be
least record my
discussed.
submission that I respectfully urge your lordship to adjudicate CAN 7 and FMAT 1310 of 2016
Lako.
first.
Letter.
That had a bearing.
No,
No, not
letter.
later. I've been requesting this, my lord, at the beginning of the hearing. So let's kindly record my submission and
Letter-
your lordship can
letter-
elect it.
And at a latter part, Koro, after the completion of the judgment, after completion of the dictation in the open court, the counsel for the appellant submits that he has been consistently insisting the court to list.
Well, these words are not appropriate. I've been requesting the court. I don't know if when it becomes insisting.
Yes, requesting the
Yes.
court. Yes. What?
That please adjudicate CAN 7.
CAN 7 of to
FMAT number.
requesting the court to list CAN 7
And adjudicate
2023.
No,
CAN
no.
7 2023
in FMAT number.
filed in FMAT
FMAT number 1310 of 2016.
2016
Because that would define the contours of the
to-
injunction.
to Kibolechi, requesting the court to list tomorrow, like tomorrow, full stop.
I requested your lordship to adjudicate FMAT, this CAN 7,
Lako.
prior or with this CAN 10, that your lordship
Sorry,
declined.
not tomorrow.
I'm
along
also
with the-
requesting tomorrow,
along with
but-
the instant application. Stop. Since the arguments were advanced on the instant application, as we were primarily concerned with the recall of the order and a judge or slash judgment dated 13/3/2023. Stop. We decided to hear out the applications one after another as clubbing of the several applications would invite the endless arguments to be advanced at the bar. So, a further request is made to list the said application tomorrow. I think that's correct.
Because I'm here
Tomorrow.
from Delhi, my lord, I
Tomorrow,
have-
but we are unable to accede to such prayer as this bench, that as one of us would be holding a circuit bench from the next week. Furthermore, the present application which has been disposed of has been extensively argued at the bar at the expense of the other matters listed today. And therefore, we do not think that such prayer can be accepted at this stage. So list the said applications in the second week of August. The third week of August, because of
Or if your lordship would give a
third
date,
week
my
of
lord, then
August,
it's easier for us to.
2023. We'll consider.
My lord, please, just allow me, my lord, please allow me to finish. I'm not detaining your lordship unnecessarily. My lord, I had also requested that your lordship may kindly adjudicate CPAN 434 of 2023 with this CAN 10, because contempt is one. Or, my lord, with due respect, your lordship not hesitate to include my submissions as part of the judgment. Your lordship may not agree with it.
No, these
That
are
is your
all-
lordship
these are
prerogative.
all not
No,
a
because I
part of
want
the
to
judgment.
show that the manner of adjudication of this matter for the appellate court.
Yes.
I want to show that the approach adopted was not optimally.
Optimally.
My lord, with due respect.
Now everything is there.
My lord, with due respect.
No.
Please.
No. Now that's enough.
Extremely grateful.
Yes.